Hello folks, welcome to Legacy IAS Academy. In this video, we will be discussing your polity from Prelims 2026 perspective. We will see what are the important topics that needs to be covered, and you can use this like an important revision topic or whatever important aspects which has to come from a particular, let's say, fundamental rights. What and all should you be aware of? What kind of questions can come? What are the important points in this you have to remember specifically from prelims perspective. Now many topics in this I will be teaching you through your MCQs. So this is more like a marathon series of your polity. Understanding? So today we will be starting with fundamental rights. Alright, let's get the video started. First and foremost, the very basics, your fundamental rights are inspired and derived from your USA's concept of Bill of Rights. Bill of Rights of USA is like how we say fundamental rights of India. Fundamental rights of India are also called as Magna Carta of India, implicating the importance of fundamental rights. And also important thing here about fundamental rights, especially in regard to prelims, is it comes under part 3 of the constitution. Now if I say fundamental rights, what is the aim of fundamental rights? If you see, it is to exercise your political democracy and rule of law, not social democracy, not economic democracy, okay, largely political democracy. Also, when I tell fundamental rights, if I'm going to speak from a broader perspective, I will be saying it is from Articles 12 to Article 35, broadly speaking. Okay. Now, if I have to narrow it down, why I'm telling narrow it down means only fundamental rights means it is Article 14 to Article 32. Why am I calling that this Article 12 to 35 also means these particular, your 12, 13, 33, 34, 35, all this give effect to these fundamental rights, that is 14 to 32. Alright. Also, originally we had 7 fundamental rights, but as of now in present we have only 6 fundamental rights, because right to property, which was earlier a fundamental right, was removed through an amendment and it is added in Article 300A. Under Article 300A, which means it is no longer a fundamental right but just rather a legal right. Understanding? And also your fundamental rights are justiciable in nature or enforceable in nature. Meaning what? When and where your fundamental rights get violated, and if and when your fundamental rights get violated, you can seek for remedy in court. Who is telling this? Your Article 32. Article 32 is a fundamental right in itself. Understanding? That is why your Dr. B.R. Ambedkar ended up calling Article 32 as soul of the Constitution. Okay? Now, if you see, we have broadly termed your fundamental rights under 6 rights. What are those? First one is right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and last one is right to constitutional remedies. So all of these things contribute your fundamental rights. Now we will see each one of these. The first one we will start with is your Article 12. When I was discussing earlier, I told you from Article 12 to 35, we will consider it also as part of your broader perspective of fundamental right. Why? Again, here I told you, it gives effect to fundamental right. What is it giving effect to fundamental right? Earlier when I used this word, your fundamental rights are enforceable in nature. Enforceable in nature means if in case your FRs or fundamental rights are violated. Violated by whom? Let's assume state itself. Okay. then you can take action against the state itself. For that, you first have to know what and all will come under the term state. Yes, now that particular term state is what is the aspect of Article 12, or otherwise what we say as the definition of state. What and all the state include? It includes central government, it includes state government, it includes parliament, it includes state legislature, it also includes your local authorities. Alongside this, it also includes authorities such as your LIC, ONGC, public sector undertakings, okay, and also any instrumentality of states such as in which states own more than 50% of shares. So all these people will contribute under the terminology of state. Article 13. See, now there are three simpler things. Again, we are discussing it from prelims perspective. If I want you to remember Article 12 as definition of state, simpler sense पे. Okay, in simpler sense if you have to remember, Article 12 is definition of statements. Article 13 will be two things. A definition of law and judicial review. Okay, this is what I want you to know from Article 13. See, what is a judicial review? Let's say legislature passes a law, but this particular law, let's say, is violative of fundamental rights. Then your judiciary, specifically Supreme Court, can strike this law down as unconstitutional and void. This concept of judiciary trying to review whether a law is violating any basic aspects of constitution, or now the word we will introduce is basic structure of constitution or fundamental right, then judiciary will strike down that particular law. Now previously while I was explaining for state, then I told you have to know then what a state is. Similarly then here you have to know what a law is. That is what is told in your Article 13. This process of judiciary striking down this particular law is called as judicial review. Understanding? Now, what do we say as law? Law includes ordinances, rules, bylaws, customs with force of law, all of those. Now, the question, one thing that will arise is a constitutional amendment a law? The answer is constitutional amendment is technically not a law, but it is still under the purview of judicial review. Understanding? So, dual front of Article 13 is definition of law, judicial review. Your constitutional amendment is not a law, but it is still part of your coming under judicial review. Okay? Now we will start with right to equality, which has articles from 14 to 18. Understanding? The first is Article 14. Now in Article 14, I want you to remember it in this particular manner. Equality before law and equal protection of law. Equality before law is a British concept. Equal protection of laws is a US concept. Okay, your equality again specifically from prelims perspective, right? So equality before law is largely more of negative in nature. Your equal protection of law is more of positive in nature. See, understand in polity, there is no such thing as negative means bad. Your normal usual connotation, negative means bad. But in this polity perspective, you have to see positive right means it is more broader. It gives more aspects to it. Negative means it is constricting in nature. It is limiting the authority. Understanding? So, your equality, your Article 14 is two things you will see. Equality before law, UK concept, equal protection of law, US concept. Equality before law is largely negative, which means you are telling the state that you cannot give privileges to any particular class. Class legislation cannot be done. Every single person has to be treated the same way. Irrespective he or she is rich, poor, doesn't matter. Male, female, no changes, no discrimination. Understanding? So, it is more of a limitation. So, equality before law is not a bad concept. Negative ones don't think that. It is a limiting factor. Equal protection of law, on the other hand, is a positive concept. Meaning what? You are telling that, okay, in equal protection of law, I will treat the equals equally. Okay, now for example, let's say in our country, our taxation is based on our economic income. So you cannot tell both, let's say a person who earns 1000 rupees per month and a person who earns 1 crore rupees per month, both of you will pay equal taxes, simply not possible. So here you give something called as positive discrimination. Understanding? So Article 14, equality before law, equal protection of law. Now the same equality before law concept, if you see, this comes under, or this is a component of something called as rule of law. This is a very broader concept which has been introduced by a British jurist by the name A.V. Dicey. What is this rule of law? If you see, it is largely in order to tell that you will reduce the arbitrariness of the state. You do not want state to act in an arbitrary manner. Here state means both executive as well as legislature. Understanding? And for every fundamental right, one important thing you have to know is the fundamental rights are not absolute in nature, except one fundamental right, that is your Article 17. Which means all of these articles are subject to reasonable restrictions. Understanding? Article 14 is also subject to reasonable restrictions, and also we use the word rule of law, right? Your judiciary has held that rule of law is belonging to your basic structure category. Now look at this. What rule of law is? Just have a look at this. Rule of law has three main components. First one is absence of arbitrary power. Second one is equality before law. Third one is primacy of individual rights. Understand this absence of arbitrary power, meaning what? No one which means law is the supreme power in the land, and also no one single person is above the law of the land. Understanding? So this is what we mean absence of arbitrary power. Not executive, not legislature, not PM, not your MPs, no such thing. Equality before law, the concept that we saw, okay, where everyone are to be treated equally. The third important concept is primacy of individual rights. Otherwise, where is the source of these individual rights, or also called as what is the source of your fundamental rights? According to rule of law which is propounded by Dicey, he tells that judiciary is the source of fundamental rights. Okay, in Indian perspective, is judiciary the source of fundamental rights? See, your Supreme Court is a protector, understanding, but it is not the provider. of fundamental rights. In our country, the provision of fundamental rights is by constitution, not by judiciary. So, the rule of law in Indian scenario will apply only here and not here. Understanding? So, rule of law has three components. We have only these two components. So, when we tell rule of law is a basic structure part, then we mean by these two parts and not just this one. Understanding? So, what is the objective of rule of law? Supremacy of law, no arbitrariness, right? Now, there are some exceptions, like I mentioned, for every article. Apart from your article 17, all have reasonable restrictions. Why reasonable? It should not be again arbitrary, or just by the likes of anyone in power, it should not keep changing. So what are the exceptions for article 14? Immunity for president and governor, your parliamentary privileges, article 31C, where certain laws will give effect to certain DPSPs. Many a time here we will be seeing where your judiciary has mentioned when article 31C comes in, article 14 goes out. Okay, and there's also foreign sovereign immunity provided to your diplomats, heads of states, United Nations immunity. All these things are your reasonable restrictions. Now, to further teach an aspect of article 14, we will see a question, and from that we will learn. First and foremost, a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution of India? 2021 question. First, let's break down the question. A legislation, which means a law, which confers on executive or administrative authority an unguided and uncontrolled discretionary power. Unguided, uncontrolled. Uncontrolled means you have limitless power. Okay? Limitless power means what? Arbitrary power. No one is there to put checks and balances. Okay, the whole point of limitless or arbitrary means there is no checks and balances. Arbitrary power in the matter of application of law violates which one of the following articles? So, in simpler sense, they are telling if you give someone arbitrary power, okay, be it an executive body or a legislative body, then which article is getting violated? See, this is the whole point we discussed article 14, telling that first thing is supremacy of law, second thing is no arbitrary power. So, this will come under a article 14 of the Constitution. Now, see, like I told you, article 14 has two aspects: equality before law, equal protection of law. When I say equality before law, it means it is preventing arbitrary power and ensuring fair treatment. Equal protection of law means fair treatment or fair application of law, right? So, this indicates that first thing is arbitrariness should not be there. That is what the question states. There were other options, right? Article 28, 32, 44. What are those? 28, freedom of religious instruction. 32, your heart and soul of your constitution, that is constitutional remedies. 44 is not a fundamental right, it is a directive principles of state policy which speaks about uniform civil code. These have nothing to do with the arbitrary power. The next is article 15. Look at this, what article 15 is. See, in simpler sense, if I have to tell article 15, it is again in two parts. First part tells that you should not discriminate Okay, let's say you have opened up public parks. Okay, the state ka fund using you have opened parks, roads, wells, ghats, tanks. All of these things, if you have opened, you should not discriminate based on only certain grounds. What are that only certain grounds? Religion, race, caste, sex, or place of birth. Only on these grounds you should not discriminate on those things, which means this right is applicable to state. Understanding? Now the second portion of 15 is, now if you have opened up any public places such as hotels, dabas, places of entertainment, anything which is meant for public purpose, and again same thing, built either partly with state funds or fully with state funds, then you should not discriminate only on the grounds of religion, race, caste, sex, or place of birth, which means this is applicable for private individuals also. So Article 15 has two attributes, where one is applicable to state, one is applicable to your state as well as your private individuals. Understanding? So these are the two important aspects you have to know from Article 15. Look at this. Public places such as shops, public restaurants, hotels, places of public entertainment, these are not to be discriminated only on those grounds. One more thing about when we tell only on these grounds, which means apart from these grounds you can discriminate on other grounds. Understanding? Then look at this, public utilities and spaces, wells, tanks, bathing huts, roads, the places of public resort which are either maintained wholly or partly by state funds. Understanding? So which means Article 15 is applicable in one case to against state and one case against your private individuals also. The exceptions here are very important. For example, see, the first thing when we spoke is sex. You should not discriminate based on sex. Now let's say government has decided, okay, I will introduce a scheme where I will tell, Pradhan Mantri Janani Suraksha Yojana, something that will help for women empowerment. Understanding? So here you told you will not discriminate only based on sex. Then how are you giving these particular aspects or benefits only based on sex? So here is where you have to see these things are not as violations of Article 15, but rather an exceptions, or rather what term we will use is positive discrimination. Understanding? Positive discrimination otherwise means empowerment of this section. Or in other case, in Article 14, remember we used the word equal protection of laws. You will treat the equals equally. Understanding? So the exceptions are women and children, SC, ST, OBC, EWS is economically weaker section, which was 10% reservation quota. This was added in your 103rd constitutional amendment. And also these will to certain extent apply to private institutions except your minority institutions. Now this applies to citizens only. Again, from prelims perspective we are speaking, means there are certain fundamental rights which are available only to your citizens. Which are those? Article 15, 16, 19, 29 and 30. Understanding? So these are the fundamental rights which are applicable only to the citizens of India, which means for foreigners you can discriminate on all these grounds that is mentioned and they can't claim it as a matter of fundamental right. Again, like I told you, it covers both state and private individuals. Now we will look at a possible question in here to teach you more on this. Just have a look at this particular question. So what you're supposed to do is match the following. Articles are given this side, provisions are given this side. Article 14. First I will read out all these things. The articles we have is 14, 15, 16 and 17. State shall not discriminate against any citizen on the grounds only on religion, race, caste, sex, place of birth. State shall not deny to any person equality before law or equal protection of laws. Untouchability is abolished in and its practice in any form is forbidden. There shall be equality of opportunity for all citizens in matter relating to employment or appointment to any offices under the state. So here there are few words, let's underline. Shall not discriminate. Okay, state shall not deny to any person equality before law or equal protection of law. Next is untouchability. Another aspect here is there shall be equality of opportunities with regarding to employment. So Article 14 means it is equality before law and equal protection of law. So the second one will be Article 14. The state shall not discriminate against any citizen. This is Article 15. Untouchability is abolished and its practice in any form is forbidden. This is Article 17. So you have to just know at least these important words with respect to these articles. There shall be equality of opportunity of all citizens relating to employment. This is Article 16. Understanding? So the correct answer for this particular 2004 question would be C2143. Next is Article 16. Article 16 speaks about equal opportunity for all citizens with regarding to public employment, and you should not discriminate solely or only on the grounds of religion, race, caste, sex, descent, place of birth or residence. Here important thing is your word residence is also added. So here in 16 what you have to remember mainly is the word residence. Understanding? There are certain exceptions here also, where residence can be prescribed as a condition by Parliament. As of now, it is there only for Andhra Pradesh and Telangana. Also, they can give backward class reservations, religious officers and EWS categories. Okay, so this is not violative of your Article 16. Another thing you have to remember about Article 16 is your 1992 with regarding to your concept of OBCs, other backward classes, which was brought about by your Mandal case, where they agreed for 27% of reservation for OBCs, and they also included the aspect something called as creamy layer and non-creamy layer, which means even though you belong to a backward caste, but if you are economically doing better, then you will not be getting benefit of this reservations. Understanding? So thus the creamy layer, non-creamy layer, it is applicable only to the OBCs, not your SC and ST. And also they held that the total reservations, including your horizontal as well as vertical reservations. Vertical reservation means different castes. Horizontal means within that same caste. So total reservation cannot be more than 50%. Understanding? Now, we'll see one possible prelims question from here. Again, if you see here, previous when I had the match the following question, it was just the articles. Here, it is including the clauses. Article 16 of 2, 29 of 2, 30 of 1, 31 of 1. Now, let's read the options. No person shall be deprived of his property save by the authority of law. Let's highlight few words. No person can be discriminated against in the matter of public appointment on the ground of race, religion or caste. All minorities, whether based on religion or language, shall have the fundamental right to establish, administer educational institution of their choice. Here, minorities and language. No citizen shall be denied admission into any educational institution maintained by state or receiving state aid or on grounds of religion, race, caste, sex, language or any of them. Now, earlier I showed you directly here, right? Now I will show you with options. Okay, first let's see, A is 2431, which means this has to be linked with, let's say, Article 16 of 2 with respect to discriminated against public employment. Okay, so this is Article 16 of 2. Understanding? So, what here you have to understand, one important thing is, now let's say the next option 1, no person shall be deprived of his property, 31 of 1, right? Most important thing for you is, even though you don't know the clauses or subclauses, at least the article must be, this is what, now for example previously I told you 14 means, here I'll show it to you. 14 means at least one word, equality before law, equal protection of law. 15 means discrimination, okay, prohibition of discrimination. Like that, at least for one article you have to remember one line. That will help you deal with this, okay. Okay, look at this next question. Consider the following statements. It's a 2023 question. The Supreme Court of India has held in some judgments that reservation policies made under Article 16 of 4 of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. So here they're speaking, it's a statement kind of question where they're speaking about two articles, Article 16 of 4 and Article 335. Okay, let's assume you don't know what 16 of 4 is, but at least though you have to know this much key. Article 16 is something that deals with employment, public employment. Also, we spoke about many exceptions in public employment with respect to women, children, SC, ST, OBC. Then we added one more category of EWS. This is statement 1. Statement 2 is, Article 335 of the Constitution of India defines the term efficiency of administration. Which of the following is correct in respect to the above statements? See, whether you know what Article 335 is or not, certain simpler things let's use, a little bit of common sense. Article 335 of the Constitution of the India defines the term. This should be your, okay, red flag. Constitution largely does not define the terms. Understanding? So, the definition of term, and if you see the term also, let's assume, okay, now it has told defines the term, that raised a red flag. What is the term? Efficiency of administration. Can you physically define efficiency as, yes, you perform this much, then only that is called efficiency. You can, that too on what? Efficiency of administration. Can you define the term efficiency of administration for a country as large as India, which has various differences in that? So this statement automatically will become wrong. Now come to the first statement. The Supreme Court of India has held that in some judgments that reservation policies, so something 16 of 4 is speaking about what? Reservations, okay, of 16 of 4 of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. So, when you are going to dissect this, all they are trying to tell us 16 of 4 provides reservation. But this reservation does not mean you will only fill seats with people who are not being otherwise eligible to be in that place. Understanding? So, which means your reservation should also be there. At the same point of time, it should not negate or disturb the efficiency of administration. Both should be equally balanced. That is what the statement is telling. And that is what is the whole concept of your reservation and your efficiency in administration. So, this statement is correct. Now, look at the options. Both statement 1 and 2 are correct? No. Both statement 1 and 2 are correct and statement 2 is not correct explanation. Statement 1 is correct, statement 2 is incorrect. This is correct. Okay. So Article 16 of 4 means what? It is for reservation for backward classes. Article 335 is policy should not compromise overall efficiency and quality of public administration. They have used efficiency of administration but they have not defined the term in the constitution. Okay. Next is Article 17, which means your untouchability, prohibition of untouchability. Okay, and also this is a absolute right, which means there are no exceptions for this. This is applicable against your private individuals and state can make laws so as to make sure this doesn't happen. How is it enforced? Through your Protection of Civil Rights Act of 1955. And also the term untouchability has not been defined in the constitution. That is why I told generally the terms are not defined in the constitution. Look at this question. Which of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? 2020. Right against exploitation, right to freedom, right to constitutional remedy, right to equality. See, you will be tempted to put right against exploitation, but I told you from Article 14 to 18, everything that comes under will be right to equality. Your 17 is coming under this list only, so it is right to equality. Next is Article 18, which is abolition of titles. Okay, first and foremost, no hereditary titles. Colonial times pe they used to confer these titles also in order to showcase the differences. Why are we telling we are going to abolish titles? Because of one simple aspect. Everyone is of equal status. Understanding? No hereditary status is to be there. First thing. Second thing, the only titles that are permitted are either military or academic titles. Now we are telling then the only titles are military or academic. Then what about your Padma awards? Your Padma Shri, Padma Bhushan, Padma Vibhushan or Bharat Ratna, what are those? See, those are national awards and they do not come under the concept of titles. And also your judiciary has clarified that you cannot use your national awards as titles. If you use, we have the right to forfeit it, which means Padma Shri awardee so and so, not Padma Shri so and so. Understanding? So you cannot use national awards as titles. Why? Because the whole concept of abolition of titles is to maintain equal status. The Indian Constitution, right to equality is granted by 5 articles. Which are they? Again, though this seems very trivial now, at that point of time, these kind of questions are very static as to you should not make a mistake at all on this. Article 16 to 20, 15 to 19, 14 to 18, 13 to 17. This 14 to 18. Next is Article 19. So this ends your equality. From now, freedom will begin. Okay. Look at this. Now, under Article 19, we have freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, and freedom of profession. We initially had 7 rights under your Article 19, with one more being the right to acquire property, but that was removed through your constitutional amendment. Okay. 44th Constitutional Amendment of 1978. So we will see each one of these. So your right to freedom is from Article 19 to 22. Equality is 14 to 18 means freedom is from 19 to 22. So what are the 6 freedoms? Speech, expression, assembly, association, movement, residence, profession. This much at least you have to by heart. And also 15, 16, 19, 29, 30 only for citizens of India. Look at this. Article 19, 7 freedoms changed through your constitutional amendment, and right now we have only 6. This is available only against state action and not private individuals. Prelims perspective, very important. This will be coming in your statement kind of questions. Now here also, see if at all there is any fundamental rights that gets maximum restrictions, that is your Article 19. Okay, during your emergency and all, we will discuss that in case if it is your national emergency, and that too by external war, aggression, those things, automatic suspensions and all will be there. That so largely will affect Article 19 only. So state can impose reasonable restrictions, but on the grounds which is specified in Article 19 itself. Okay, it cannot bring more, let's say, arbitrariness to impose restrictions. Okay, so if you have to impose, then it has to satisfy reasonableness and your judicial scrutiny. So now let's say what and all might come under. First thing we will take your freedom of speech and expression. Judiciary has held various things will come under freedom of speech and expression. What are those things? For example, right to propagate one's view, freedom of press, okay, right against bandh, which will be called by a political party or organization. See, under your freedom of speech and expression, we have both dual nature, both negative right also within it. We also have certain positive right also within it. Okay, so you have right against bandhs called by political party, freedom of commercial advertisement, right to telecast, and also right to know. One more thing is here, look at this. Freedom of speech does not only means verbally speaking, but also freedom of silence. Then right against tapping of telephonic conversations, right against imposition of pre-censorship on newspaper, a right to demonstration, picketing, but this does not include right to strike. That is one most important thing. Article 19, 1 of A, freedom of speech and expression does not include a right to strike. This you have to know. Okay, right to access information, right to filmmakers to exhibit their movies. Okay, and also the one important thing, if you see, right to information will also come under your Article 19. Okay, it includes right to information, it does not include right to strike. Next is freedom of assembly. Have a look at this. Right to freedom of assembly is under Article 19, 1 of B, which means you can assemble peacefully without arms. Okay, if it is, and it has to be on a public land only. And it should also be of one important thing, your right to assembly, okay, should not mean that you will go to some private places or places which are restricted and there you will start protestings. Okay, so public meetings, demonstration, processions, everything is permitted, but it all has to be on your public land only. Here also, when we say public meetings, demonstration, processions, it does not mean right to strike. Okay, and again, if you see with respect to reasonable restrictions, one is your criminal procedure code mentioned your article section 144, wherein you will limit the assembly. Let's say 5+ members should not be together, or unlawful assembly. If we tell you are not, when let's say I have imposed section 144, you cannot have assembly of more than 5 people. Understand? So this is coming under your reasonable restrictions or exceptions. Next is freedom of association under Article 19(1) of C, which means you have the right to form political parties. Okay, you have the right to form political parties, trade unions, cooperations, societies, all of these you can form. But at the same point of time, like you have a right to form association or join any association, under the same article you also have right to not form or join any association also. Okay, like I mentioned, both positive, negative, both are there. Again, positive, negative does not mean good or bad in polity. See, again, we've told you, right to form or join association is there, right to not form or join association is there. These both are part of your Article 19. But there is something that is not part or does not include is, let's say you have formed an organization. You have no fundamental right for recognition. Article 19(1) of C does not confer fundamental right for recognition of your association. Understanding? So, this has to be kept in mind. Next is freedom of movement under Article 19(1) of D. You are free to move about anywhere within our country. Again, when we say movement, here also, let's say you are going to move within our country. Within our country means it is protected under Article 19. Now you are going to move outside the country and you decide to come back. All this is covered, especially after your historic Menka Gandhi case. You are moving outside the country is all covered under your Article 21. This is one important thing you have to remember in Article 19 with regarding to freedom of movement. Okay? Why you can freely move about anywhere within the country? Again, promotes national unity. Understanding? So 19, movement within territory. 21, movement outside the territory of India. Next is freedom of residence and settlement, which means you can settle, reside anywhere in India, either temporarily or permanently. Okay. Now, if you see, it is almost like your previous freedom of movement only. So, your right to freedom of movement and right to freedom of residence is complementary to each other. And also here reasonable restrictions also, if you see, largely it will be similar for both movement and your residence. For example, you can restrict the movement of your prostitutes, understanding, or movement into or residence into your scheduled areas, vulnerable sections, understanding. So these both, your movement and residence, are complementary to each other. Okay. Next is restrictions. If you see, interest of general public. Now, for example, general public means you can even put health. Yes, when you say you will restrict the movement of your prostitutes, a protection of scheduled tribes, tribal customary property laws. Okay, and judiciary also will tell that because of your these kind of things, habitual offenders are also not allowed, or you can restrict their movement in certain scenarios. Next is freedom of profession, trade or business. See, you can do any profession, trade or business subject to few things. Let's say I have decided I will now give medicines to people. See, because my occupation involves certain expertise that is needed, I cannot just without doing an MBBS degree, I will decide, no, I have all the knowledge, I'll start giving. That is not permitted. If you have to carry out a particular profession, then you need certain things which the state will specify you need to do for practicing medicine. If you have to practice medicine, if you want to give medicines, if you have to be involved in that, then you have to have this degree. Understanding? First thing. Second thing, any illegal activities or harmful activities, let's say your concept of human trafficking, child labor, on all those things you cannot call that as a profession. Okay, those are merely illegal activities only. And third thing under this is, your state can put a monopoly on any of the trade and you cannot question, no, you are violating that. And last thing, state can put the concept of license for any trade. Okay. So you can practice any profession, carry out any occupation. All of this should be lawful means of livelihood, no illegal ones. Okay. Look at this. State can prescribe any professional or technical qualifications, and state can create a monopoly either fully or partial, and that does not have to be a particular justification. Your trafficking in women, children, harmful drugs, explosives, all of these things will not come under this ambit. Understanding? Next is Article 20, which is protection with regarding to conviction of offences. Under Article 20, you have three things. No ex post facto law, or otherwise also called as retrospective law. Okay, let's say on January 20th, if I make a law, in our country there is a provision to tell that this law is applicable from, let's say, 13th May 2024. I am in 2026, but I can tell this law will be applicable for period of time from 24 onwards itself, right? So can India make a retrospective law? Yes, it can make a retrospective law, but it can only make it for civil cases. Okay, you can make a retrospective law only for civil cases. Understand few things here, it will get confusing if you don't understand properly. Civil cases I can make a retrospective law, okay, otherwise called as ex post facto law. But for your criminal cases, I cannot make ex post facto law, or I cannot make retrospective law. So, no retrospective law is there only for criminal cases and not for civil cases, which means you can make a retrospective law or ex post facto law on civil cases. Next is no double jeopardy. Objective is simple. No person should be punished twice for the same crime. Okay, but the exception here is your departmental or administrative authorities are not part of double jeopardy. Okay, which means, let's say you're a civil servant, you have did a mistake, let's say something with regarding to dowry harassment. Judiciary has already given you the punishment. So technically you should not be tried on the same case again, but let's say in the department they will open a case, they will find out, yes, then they may even suspend you or remove you. That does not amount to double jeopardy. Last one is no self-incrimination. No self-incrimination means you cannot be a witness against yourself. Okay, so if you tell you can't be a witness against yourself, no one can force you to take up. Okay, this is not permitted, such as your narco tests, polygraphs, hypnosis, lie detector tests, etc., no one can force you, and this alone cannot be a source of evidence. According to your BNSS, we have held that there is a provision that tells that if a person wants to voluntarily undergo this test, they can take it, but that also alone cannot be taken as a sole evidence. Understanding? But there are certain things you cannot tell, no, I will not give. Now, for example, these aspects such as blood sample, fingerprint, etc., for your DNA analysis, all those things, these things you have to give. That does not come under self-incrimination. But these things, narco test, polygraph, hypnosis, these kind of things, you cannot force someone. And if you do so by obtaining that, then that itself will be the reason to throw out that case. Next is Article 21. Otherwise, your right to life, which is a very broad article in all of our fundamental rights. Article 21 is life and personal liberty. It is applicable to both citizens as well as your foreigners. In Menka Gandhi case, they established the aspect that, see, when we tell arbitrary laws should not be there, it does not mean only for executive but also for legislature, which means the law that they are making should also be fair, just and reasonable, which means we are trying to tell not just procedure established by law but also due process of law. Procedure established by law means, are you doing explicitly like what the law is telling? Has executive violated the law or not? But this is mentioned in our constitution, procedure established by law. This term is not mentioned, due process of law. Wherein we are seeing in the first aspect, procedure established by law, we are putting a limitation on executive so as to not do arbitrary powers. But with the due process of law, we are checking for the fairness of the law itself, which means you put a limitation on the legislature itself. Understanding? So, Indian judiciary tells that while we are going to be thinking on Article 21, we will be considering both of this. How? In Menka Gandhi case, they said that the procedure itself must be fair, just and reasonable. Understanding? Your Article 21 includes various rights, right to privacy. Okay, this becomes important, right to privacy. Many times they have asked this question. It comes under which article? It comes under Article 21. Right to dignity, health, environment, speedy trial, legal aids, sleep, reputation, all of these things comes under your Article 21. And this is a ever-growing list. So that is why we add the word etc. Understanding? Under Article 21, we have one thing, Article 21A, which is right to education, wherein you have free and compulsory education. Okay, free and compulsory education from 6 to 14 years of age, which means we provide only elementary education or primary education. You cannot use that we have right to education. We have right to primary education, free and compulsory, which was brought about in your 86th Constitutional Amendment of 2002 and the Statutory Act is RTE Act of 2009. Okay. So, we will end the content up until here. We will continue in the next lot. Okay. Thank you guys. Hello folks, welcome to Legacy IAS Academy. In this video, we will be continuing the second part of our Polity Prelims Marathon, where we were discussing about fundamental rights. In this video, we will be speaking about the second part of fundamental rights. In the previous video, we stopped at your Article 21A. Now we will begin from Article 22. First and foremost, in Article 22, if you are to know something, it is protection against arrest and detention. Okay, this particular Article 22 is applicable only. Okay, in a way, if we see up until now, I've told you, Article 15, 16, 19, 29, 30 are only for citizens, right? In that, this Article 22 is applicable for your foreigners or opposite of citizens. What is it? Aliens. But which kind of aliens? Means only friendly aliens. Okay. So Article 22, friendly aliens means what? Countries which have had good relationship with India, and enemy aliens means what? Countries which are at war with India. Just because a country is at a war with India doesn't mean it is automatically made into enemy alien. So protection against arrest and detention is available to your aliens also or non-citizens also, but only your friendly aliens. In this, when we say protection against arrest and detention, detention is of two types. One is punitive and one is preventative. Punitive means when you have actually committed a mistake or it puts you in the possible clause. Some event has happened and for that you are trying to punish. Then comes preventive detention. Here you may or may not have committed. In this case you have definitely committed or you are in the probable. In preventive detention, you have not committed a crime yet. Okay, you have not yet committed a crime, or let's say with respect to anything that you might lead to. The possible thing here is based on a suspicion or that it might lead to this. Understanding? Usually what used to happen means, let's say in any important occasions, certain very let's say sensitive scenarios or sensitive environment pe, certain leaders will be taken under preventive detention. Understanding? So punitive detention for a past committed crime, preventive detention for a future may possible or might possible committing crime. Okay, so if you have, I told you the name of the article is right against, okay, that is you have certain rights even if you are getting arrested. What rights are those? For example, to be produced in front of a magistrate within 24 hours, that should include even the journey time. Okay, you should be informed of the grounds of arrest and you should not be detained beyond the 24 hours, and also you should have the right to consult your lawyer. All of these have to be done. But let's say it is based on a preventive order or it is based on a court order, or it is in the case of preventive detention, or if it is for any civil liability case, then in those cases you don't have to do this particular aspects. Okay, so this will apply only in your ordinary law relating to criminal or quasi-criminal. Now these particular aspects, that is Article 22, not applicable to enemy aliens, and this particular provisions are also not applicable when you have brought in a person under preventive detention. So if you see, even when you are going to hold a person in preventive detention, okay, you should not hold them beyond 3 months without approval from your advisory board. That advisory board will have members from your High Court. Understanding? Preventive detention, you can be held. You cannot hold someone in preventive detention for more than 3 months without your suggestion or approval from your advisory board, which consists of High Court judges. But Article 22 also gives one more provision to your Parliament, is that Parliament can make a law as to how long the term is without wanting your advisory board approval. Which means, now I told you 3 months. They can make that 3 months to 2 months, or they can make the 3 months to 10 months. Yes, that is Parliament's discretion. So it can specify the time limit without which your advisory board approval is not needed. Now, like that, once in your 44th constitutional amendment, they held that, okay, advisory board has, now before you go to advisory board approval, you have to do it, you can hold a person in preventive detention for 2 months. But it was not brought into force yet, so the concept of 3 months still is continuing. Understanding? And also, if a person is under preventive detention, you should give him an opportunity to make a representation against the detention order. But let's say if it is against your public interest, then that also can be curtailed. Now, one thing is, like I told, you can hold someone up to 3 months, but above that you need advisory board opinion. 44th Amendment had changed this 3 months to 2 months, but it was not brought into force, so we are sticking back to the 3 months. Now, the preventive detention, who can make a law on preventive detention means it is both Parliament and state legislature have the power to make laws on preventive detention. But there are certain topics which only Parliament can make law on preventive detention if it is on these topics. What are those? For example, defense, foreign affairs and security of India. This only Parliament is authorized to make. Now, on other topics where both Parliament and state legislature can make means it is security of state, public order, supplies, services of essential community. Understanding? In these cases, both of them can make. Now, next is Article 23. Article 23 is right against exploitation. It covers Article 23 and also 24, traffic and forced labor, which means under Article 23 you cannot traffic human beings, you cannot purchase, sell men, women, children, no immoral trafficking activities, prostitution or Devdasi system, slavery, all these are prohibited. Okay, you cannot force someone to do. Now when we used beggar means you are forcing someone to do a job without being paid. So the force here includes either physical force, legal force or economic compulsion, where you make someone work for below minimum pay. Now if you see, this particular Article 23 is applicable for both citizens as well as non-citizens, and this is available against both state as well as private individuals. One important thing is about in here how your Parliament tries. See, Parliament having to make laws on this is not whether optional or voluntary. It is mandatory and only Parliament can make law on this. There is also an exception where your state can provide for compulsory service, okay, but that compulsory service, be it with respect to military service or social service, you cannot discriminate on the grounds only on religion, race, caste or class. Okay, next is Article 24. Look at this. Article 24 is prohibition of child labor in hazardous work. See, here we will make this distinction. 0 to 14 years or 1 to 14 years, okay, you will not be allowed to work in majority of any things, okay, except your innocent works. Innocent works means what? Let's say your family has some business, evening you will just go visit shop working in your agricultural land, or let's say in movies and all they will work. Yes, so overall, irrespective of the fact that you do these things, your right to education should not get spoiled. Okay, it should not get affected at any cost, and a child should be able to have its own childhood. Now from 14 to 18 years is adolescence. In this also, you are prohibited from doing very work which are considered as dangerous or harmful. Understanding? So, according to Article 24, prohibition of child labor in hazardous work, and also employment of children below 14 years in factory, mine, hazardous employments, all these is not permitted. And this does not prohibit harmless work or otherwise what we call as innocent work. And also, your judiciary, according to Child Labor Rehabilitation Welfare Fund, it has said that any person who employs or engages in child labor, per child that he has employed, he will be levied with a fine of 20,000 rupees per child. And also there has been set up Commission for Protection of Child Rights through your Act of 2005. And your Parliament has brought in an amendment in 2016 to your Child and Adolescent Labor Prohibition and Regulation Act of 1986. Understanding? So these are the important acts with regarding to your Article 24. Next is right to freedom of religion, which will be from your Article 25 to 28. First is Article 25, which is freedom of conscience, right to profess, right to practice, and right to propagate. First and foremost, under Article 25, you see freedom of conscience, which means it is up to me to develop my inner self or my relationship with God however I want. And let's say I have found this religion, or I have associated with this particular belief system, then I have the right to profess that. Tell, yes, this is the religion that I believe in, this is my belief system. You can publicly tell it outside. You don't have to worry about professing your faith. Next is practice. You can practice, meaning the ritual portions are also involved. You can do ritual ceremonies, whatever is associated as a part of yours. Again, here also reasonable restrictions will come with respect to your health, morality, all those things. And propagate, you can spread the ideas, you can spread your belief system, and you can convert people into your religion also. But a right to convert forcibly does not cover here. Understanding? You cannot convert someone forcibly. Now these are subject to public order, morality, health. Understanding? Now if you see with respect to Article 25, largely it deals about your individual rights. Understanding? It targets more about an individual's faith belief system. So it targets more on individual rights. This is applicable to both citizens as well as non-citizens. Next is Article 26. Freedom to manage religious affairs, which means it is a collective right. Article 25 is individual right, Article 26 is a collective right for an individual organization or a denomination, wherein you can establish institutions either for your religious or charitable purposes, and you can manage your religious affairs, own properties and administer properties as per the law. Now this Article 25 tells that Article 25 speaks about your religious belief as well as religious practices. This is one important thing from prelims perspective. And if you see, it is covering both citizens plus non-citizens, your Article 26 also. Article 25 and 26, if you see it with synonymous, comparatively see it, okay. And under your 25 and 26, one of the important things, if you see, it is collectively speaking as a right of a person and a group, okay. Your Hindus involves your Sikhs, Jains, Parsis, that is your Buddhists. And also according to Article 25, they have recognized wearing kirpans as part of your profession of your Sikhs. And 25 focuses on individual rights, 26 on collective rights. Okay. Next is Article 27. What is Article 27? No tax for promotion of a religion. You don't have to pay tax for promoting your religion, but tax is different from fee. Now you can be asked or you can be levied a particular fee that you have to pay in order to run the secular institutions of our country. And also one more thing is, us being a secular country, we do not promote any one religion, we promote all the religion, and you cannot use taxpayers' money for promoting one religion but for promoting all the religions. Okay, fee is allowed, tax is not allowed. Next is Article 28. Article 28 is telling that no compulsory religious instructions in certain institutions. Let's say you are running an institution and completely it is run from state funds. In those state run institutions, you cannot impart religious instructions because in that particular place all religion people will come. So you can't make anyone forcibly do that. That there will be certain institutions which are state administered but it is founded by some trust. In that cases, your religious instruction to be imparted is permitted. Now there are certain other organizations or institutions which are state recognized, okay, but all the functioning, funding, etc. will be taken care of them, means there the religious instruction is permitted, but the people or the children who are minors will receive the consent of the members, wards, parents, and it should be on voluntary basis. You cannot force anyone to do it. Now, state aided, okay, state aided institutions means state funding a little bit is there, where a religious instruction is permitted, but minor child again needs permission of your guardian or parent. Next, cultural and educational rights under Article 29 and 30. First and foremost, if you see what is Article 29, any section of citizens, this is the keyword for your Article 29, with distinct language, script or culture. These three words you have to by heart. Because if I say language, now outside a state, let's say Kannada might be majority spoken language in Karnataka, but outside Karnataka, pura India pe, it will become in a minority level. So what I'm trying to tell here is, any section of citizens with distinct language, script and culture can conserve it. That is, they have the right to preserve, protect and promote their respective language. And this is not only limited to minorities. That is why any section of citizens, and also no individual will be denied admission in a state or state-run institution only on the grounds of religion, race, caste or language. Understanding why is this? In order to promote your national unity. Next is Article 30. Article 30, minority educational institutions. In simpler sense, your minority institutions can run an institution, and also let's say your Article 31 was removed, right to property. So that created a lot of fear for these institutions as to what if they take off our property and destroy our institution. How does it mean? Example, I'll give you one thing. One particular minority institution property, okay, has been acquired by government. The actual valuation of that property, let's assume, is 50 crores. Now, if your state agrees to pay only 5 crore rupees, then it is almost like you are undervaluing the property. And also you're putting it to an extent where this minority institution is crushed because they can't run further. So this cannot happen and this should not happen. This kind of protection should be there where they have to be fairly compensated. Okay, this is for your minority institutions. And also no discrimination should be done with respect to grant in aid. All minority institutions must be treated in an equal manner. Okay, that is why we said composition for acquisition should not abrogate the right. Okay, that is, you removing your 31 should not violate Article 30. What do I mean by this? This example, which means they have to be adequately compensated. The minority institutions also, we have different types, where certain institutions require both recognition and aid, where certain require only recognition. There are certain other institutions which neither require recognition nor aid. See, in all these scenarios, at the end of the day, government still has control. But in this, where they don't require autonomy nor where they don't require recognition or aid, autonomy is higher, but they are still subject to general laws. Here, state will be having a look into all the other affairs also with respect to administration, okay, school curriculum, etc. Next is Article 32. Article 31 is a right to property which was removed in the fundamental right of, okay, which was removed as a fundamental right and it is added under Article 300A. So, it just has now a legal right and not a fundamental right. Article 32 is a fundamental right in itself according to B.R. Ambedkar. It is the soul of the constitution. So what is 32? Right to constitutional remedies. That is, if any of your fundamental right is violated, under 32 you can directly approach your Supreme Court, or under Article 226 you can approach High Court. Now through this what will happen means, for the protection of fundamental rights, your judiciary will issue something called as writs. Now this writ issuance is for Supreme Court very narrow, which means you can issue writs only for violation of your fundamental rights, whereas for High Courts it is much broader. it can issue writs for violation of fundamental rights plus other legal rights. What are the writs? Writs are, first one is habeas corpus, next mandamus, prohibition, certiorari, quo warranto. Okay, habeas corpus is your bulwark of individual right, liberty. Okay, mandamus means we command authority, public authority, to do their job properly. Prohibition is your order issued by higher court to the lower court telling that the lower court is taking a case out of its jurisdiction. Certiorari. Certiorari means it is telling you don't take up the case, rather I will take up the case. Next is quo warranto, under whose warrant and authority or seal has this position of government post been created. The concept of writs has been taken from your English law, which has been called as prerogative law. What is prerogative law? Which means fountain of justice. Next is Article 33. Fundamental rights ends at Article 32, but 33 onwards, like I told you, it gives effect to your fundamental rights. It is with regard to armed forces and fundamental rights. If Parliament decides, and only Parliament can do this, it can restrict the fundamental rights of armed forces, paramilitary, police, intelligence forces, and etc. Why do they do this? In order to instill discipline and proper discharge of duties. And also, your Parliament can exclude some of the fundamental rights from your let's say jurisdiction of your paramilitary, all those people ka fundamental right enforcement. Next is Article 34. Article 34 is imposition of martial law. Why is martial law there? To restore or maintain public order. Under this, what can Parliament do? It can indemnify persons for acts done during your martial law. Be it civil servants or anyone, whatever act they do during this martial law period of time, it can be justified if it was done in order to protect the law and order. Now, the term martial law is not defined in the Constitution, and it is applicable either to whole of areas or just to specific areas. And at this point of time, ordinary courts are suspended, but this does not mean habeas corpus is automatically suspended. Understanding this has a rights on effect on fundamental rights, where it curbs the fundamental rights or enforcement of fundamental rights. Last is your Article 35. What is Article 35? Parliament alone can make laws on these matters. On what matters? Article 16, prescribing residence as a condition for certain public employment. Hello folks, welcome to Legacy IAS Academy. In this video, we will be continuing with our Prelims Polity Marathon series. So as you know, we have completed fundamental rights. I am picking topics, static topics, which has been coming into current affair very often, and possibility of the questions from these topics are higher. Today, the next topic in our Prelims Polity Marathon series is your President topic. President has come into news. Now, when we will be discussing President, we will be discussing President and Governor. Understanding this has been quite some time in news. Now, what are the current affairs that we will be discussing? Let's say the reason is because an ordinance was made with regarding to Manipur GST. Yes, that was a presidential ordinance. That is one thing. Second thing is where we have seen a presidential reference asked with regarding to Article 200 and 201 with respect to the assent of bill power and time limit for President and Governor. Understanding? So, on various topics as such, we will be discussing these static topics. Let's brush up quickly on these. So, there are some static features which you should not forget. First and foremost thing is your president is part of your union executive. Union executive means what and all does it comprise? President, Prime Minister, Council of Minister, Attorney General, CAG, all these people. Right? Now, if you see the specifics in this particular topic, I want you to know about the part which it comes in and also the articles. Like I'm mentioning again, this topic has been in news for various reasons. So in statement kind of questions, possibility of President and part 5 would be higher. So that is why I want you to know about the part 5, and articles are from 52 to 78. And also if you see President is the nominal executive of the state. The real executive, or now when we are going to say about power, okay, let me tell it this way. Nominal authority, which means symbolic authority. This will be your president. Your real authority will be your prime minister. Okay, and also your president is considered as the first citizen of India. He is the head of state, understanding, and he is also a symbol of unity. He is the head of the tri-services in our military, army, navy, understanding. Now let's see how the election of president will happen. The election of president happens through an electoral college. The electoral college of president comprises of elected members of Lok Sabha, elected members of Rajya Sabha, and elected members of state legislative assembly. In all these words I have used only elected. Understanding? Now let's say, now there will be certain states. Which are the certain states? 6 states are bicameral in nature. Now because we have brought the topic, which 6 states are bicameral in nature? Now, first and foremost, Karnataka, Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra. These states are bicameral in nature, which means they have 2 houses. One is Legislative Assembly, Legislative Council. For all the states, we told elected members of State Legislative Assembly. What about Legislative Council and what about elected members of Legislative Council? No, they are not added. Legislative Council, whether you are elected or you are nominated, that is not added into your presidential election. Understanding? So who are the members? Elected members of your parliament and elected members of State Legislative Assembly. Understanding? Now, one of the most important thing here we will also have to understand is with regard to your value of an vote. Okay, when a particular, let's assume your MP or MLA is voting. In order to maintain a parity, there is a particular formula with which we will calculate. Value of vote of an MLA is total population of state by total number of elected members in the State Legislative Assembly into 1/1000. Understanding? The same thing is for an MP, total value of votes of all MLAs in state by total number of elected members of parliament. Understanding? This particular question or this, you don't have to particularly by heart the entire vote list, but there are few important things you have to know this. What that is, I will teach you in the form of an MCQ. Okay? Now, who are not included in your presidential electoral college? Nominated MPs of Lok Sabha, Rajya Sabha, nominated MLAs, MLCs and nominated MLAs of Delhi, Puducherry, that is Union Territories with state legislature. So if you see the election of your President of India, it happens through single transferable vote of proportional representation. Why do we choose this? Because it avoids vote wastage. Understanding? Proportional representation, single transferable vote we pick is because of reduction in vote wastage and also wide voices will be represented. This is contrary to the vote wastage scenario of first past the post system, which is what we will use usually for your elections of MPs and MLAs. Then where and all are we using proportional representation with single transferable vote? If you see, it is for presidential election, vice president and for your Rajya Sabha. Okay, and for your president the election is via your secret ballot. Understanding? Also, any dispute, see your Supreme Court will not so moto enter into the election disputes of these bodies, but when a petition is raised, then the election petition specifically is raised, then they will enter in. The final deciding authority is your Supreme Court judiciary. Now let's say, okay, any issue has happened in the elections, Okay, a person has been elected as a president. After 2 years, we find out, okay, there are a lot of discrepancies. This person has again, okay, this disqualification of election has to happen, etc. Then the time period in which, in that first 2 years, whatever acts done by him, that will remain valid. It will not become invalid. Understanding, that is one important aspect you have to understand. Okay. Now, what are the qualifications to be a president of India? Have a look at this. According to Article 58, you must be a citizen of India and must be 35 plus years of age. You must be qualified to be a member of Lok Sabha. Here we have mentioned Lok Sabha. It should be Lok Sabha only, not Rajya Sabha. And also they should not hold any office of profit. Should not hold office of profit means what? You should not be MP, MLA, or you should not be holding any other employment with regarding to coming under office of profit. Next, the nomination of your president. See, first and foremost, nomination pay, how you have having means you will have 50 proposers and 50 seconders. 50 people should support or tell that you are they have to support you, that is, they have to suggest your name. Next 50 members should support that name. So in total you need 100 people. Security deposit of 15,000 will be given to RBI. Now this will be given back to you once you win the election, or at least even if you don't win the election, at least if you have managed to secure a minimal amount of vote, it can be given back to you. But if you have secured less than 1/6 of the votes, then this amount will be forfeited. Why did they bring this? Means they brought this in order to avoid non-serious candidates into the elections. Next, the oath. According to Article 60, a president will take oath to protect, defend the constitution, and it will be administered by the Chief Justice of India or any senior most judge of Supreme Court. Now again, your president cannot be an MP, MLA, should not hold any office of profit, and will be given official residence at Rashtrapati Bhavan without any rent, and also the salaries etc. will be decided by the parliament, and you cannot change the salaries, allowances etc. post the appointment. That is, you cannot change it to their disadvantage after appointment. Next is immunities. Your president or governor, they all have certain immunities. Now these immunities are not given to them because as the person, because of the position that they hold. What is the position that they hold? Symbolic or representative of India. Understanding, for that reason we will give. Now what are the immunities? As long as they are in power, okay, holding the position as President of India, head of state, or your governor, you cannot do any criminal proceedings on them, even though it is done in personal capacity. But this immunity is available only for criminal charges or criminal proceedings, not for your civil proceedings. Civil proceedings can be started while they are in office itself by giving 2 months advance notice. Now does it mean that criminal proceedings on them cannot be done? No, it can be done after once they step out of the power. Understanding? So civil cases after 2 months advance notice. Now if you see with respect to the term resignation and impeachment, we'll see this from Article 56-61. The term is for 5 years. Now vacancy can happen, or a particular instances that you will say yes, the presidential position is vacant is because of certain reasons such as let's say death, resignation, okay, disqualification, etc. In these cases, if the position of your president is vacant, then the vice president will act as a president for a period of 6 months. Now when I tell for a period of 6 months, that is the maximum period that a vice president can fill in the role as a president. Understanding? Now what happens after 6 months? The election to the position of president must be filled within the 6 months. Understanding? Look at this. Also, president is not bound by the number of terms of office. For example, if you see your USA presidents, they are bound by only 2 terms. Understanding? No such terms are there, which means they can be re-elected any number of times. Now, if your president has to give resignation, then he will write it or give it to your vice president. Now, next is impeachment. Impeachment is removal of president, and the grounds for impeachment is mentioned in the constitution. Meaning what? Which means if he is violating this particular provisions, then only you can impeach him or remove him. What is the provision that is given for impeachment? Violation of constitution. Now, they have not defined what does violation of constitution mean. The impeachment process can be initiated by either of the house, either Lok Sabha or Rajya Sabha, and it has to be signed by 1/4 of the members, and 14 days advance notice. So one most important thing is, if you have to let's say pass the impeachment, one of the main things you have to get to know here is about the majority. See, in general, do not be confused by your usual special majority means what? 2/3 of the members present and voting. Here 2/3 of the members present and voting will be wrong, because it will be 2/3 of the total membership of the house. Understanding why? Because it is impeachment of a president, it is of a very high important nature. That is where your substantive motion and all will come in, right? And also your nominated MPs who did not take part in the election will be involved in the impeachment process. Your state legislative assembly, otherwise elected MLAs who took part in election, will not take part in impeachment process. Clear up until here? Now, what is the vacancy coming due to? Expiry of term, resignation, impeachment, death, disqualification, all of these things. Now, in the meanwhile, let's say your election commission has to conduct elections within 6 months of time. In that 6 months of time, your vice president will act as the president. Even if the position of vice president is absent, then either a Chief Justice of India or senior most judge of your Supreme Court will serve as President of India. Now let's see the powers of president. First we'll see the executive powers. Now when we tell executive powers, all the executive actions will be taken in the president's name, and also he is the one who will be appointing the prime minister, council of ministers based on the advice of prime minister. Understanding? Now these people, that is prime minister and council of ministers, will hold office until the pleasure of president. See, for president we told term is 5 years. Understanding? But we cannot tell the same term for your prime minister and council of minister. They hold office until the pleasure of president. The president is the one who will appoint attorney general, comptroller, auditor general, chief election commissioner, election commissioners, UPSC, and also your governors, finance commission, all of these. And he can also seek information from prime minister. Your president can tell a particular topic or matter to be placed in front of the council of ministers to the prime minister. He can even return their advice for reconsideration once. Okay, and he administers union territories through administrators. He sets up commissions for SC, ST, OBCs and determines the powers of your scheduled areas. What are his legislative powers? Means he can summon the house, prorogue the house, and he will be the one who will be dissolving the Lok Sabha. Understanding? Now when a joint session has to be held, he has to be the one who has to tell for or call for joint sitting. This joint sitting will be presided over by the speaker of Lok Sabha, and also he will address the parliament. Okay, when at the beginning of your general elections, after your general elections are done, and also first session of every year. And he will nominate 12 members to Rajya Sabha. Earlier he used to nominate 2 members from Anglo-Indian community to Lok Sabha, but this provision has been done away with 104th constitutional amendment. And also when he gets a bill, he can assent. reject, return, understanding. And one more important provision he has is with respect to ordinance. He can pass ordinances with respect to Article 1, 2 and 3. What that is, little bit later I will be discussing. Now if we see with respect to your military powers, financial powers or your judicial powers, your president is the one who will appoint Supreme Court and High Court judges. He has the power, this is very important here, under Article 143, this is what we will call as presidential reference. Under Article 143, he can seek the opinion of your judiciary, but the advice tendered by judiciary is not binding on the president. Understanding, remember I told you it came in current affairs for your presidential reference with regarding to Article 200 and 201 with respect to assent of bills and the time associated. Money bill can be introduced only with the prior recommendation of president and only in Lok Sabha. He will be the one who will be having authority of all the three funds: contingency fund, consolidated fund, public account of India. But in order of any emergencies, then he will be the one who will give advances out of contingency fund. And he will set up finance commission at the end of every 5 years. He is considered as the head of all three tri-forces. And he appoints the chiefs of all the three forces, all the three emergency provisions. Your national emergency, state emergency or president's rule, or financial emergency can also be proclaimed by President of India. Now with respect to the veto powers. Veto powers again we will be seeing from two separate ways. Veto powers with respect to your union or parliament is separate from that of your state legislature. What do I mean? Let's assume this. Let's assume Lok Sabha has introduced the bill and it passes the bill, and it is introduced in Rajya Sabha, and Rajya Sabha also introduces the bill. Now when the bill goes to the hands of your president has few options. What are the options? He can either sign that bill, give assent to that bill, it becomes an act, or he can completely reject that bill, understanding, or withhold that bill, that is called absolute veto. Or otherwise, he can return the bill for reconsideration. Now when he returns the bill for reconsideration, Lok Sabha again introduces the bill and passes it with same majority. Rajya Sabha also passes it with same majority. When it goes back to the president, in this case, he has to sign that bill. Okay, this is called as suspensive veto. Now, there is one more kind of veto called as qualified veto. India does not have it, but countries like your USA has it, where once the president returns the bill, that same bill has to be passed with higher majority and sent back. India doesn't have the need for qualified veto. We work with suspensive veto only. There is one more provision, that is pocket veto, which means no action is taken on that bill. Now, according to Article 201, that is, let's say, governor's Article 200 is what powers governor has when a bill is given to him. He can give assent to the bill, he can withhold the assent, he can return the bill, or he can reserve the bill for the president. Now, once let's assume the president ke liye the governor has reserved the bill, this is where Article 201 will kick in. Wherein once the bill that is reserved by your governor comes to the president, let's assume he will return that bill. Now again it is sent back. Here the president is not obligated to sign it the second time. Understanding? So the concept of union bills and state bills differ in this aspect. So state bills, Article 201, you are supposed to know that here. Next is we will see with respect to ordinance making powers according to Article 123. Look at this. First and foremost, what is an ordinance? Ordinance is a temporary law making power given to the executive. Usually law making is done by your parliament, but in case of emergencies it is given here. So we saw what is an ordinance. Now who can form an ordinance or promulgate an ordinance? That is President of India on the aid and advice of Council of Ministers. What is the term of ordinance? Means maximum term is 6 months, 6 weeks. Because once the parliament comes back, within 6 weeks of its reassembly, if it is not approved, then it lapses. Why that 6 months? Because maximum time gap between two sessions cannot be more than 6 months. Now, we will see with regarding to his pardoning powers. Under Article 72, your president can pardon, commute, remit, respite and reprieve. This will be with regard to all the actions against your union. He can also look into the matters of your court martial and death penalties. Now, if pardoning power of president is 72, your powers of governor is 161. One difference is he can do commutation, remutation, respite, reprieve, everything, but he can't look into court-martial cases and he cannot pardon a death sentence, but he can suspend, remit or commute a death sentence. Okay. So, Article 74 states that President will act according to the aid and advice of COM. Now, in that they have also told that the advice of COM is binding. This was made according to 42nd Constitutional Amendment. 44th Constitutional Amendment made even the advice which is tendered by the COM to the President can return the advice back to the COM for reconsideration once. When it is passed back the same, he has to do it. He is bound by it. Understanding? And he also takes certain discretions. He does not have any constitutional discretion. He only has situational discretions. When no particular party has won the clear majority, or when COM has lost the confidence. Understanding? So dissolution of the house. In these period of times, he has discretion. Now let's see some possible prelims question under these topics. A presidential reference is made to the Supreme Court under which article? 131, 136, 143, 144. Answer is 143. Earlier cases I would have also discussed in fundamental right about your 142 also complete justice. Further down also we will be discussing that when it comes to your governor case. Next, with reference to article 143, which statement is correct? Supreme Court's opinion is binding like a decree. Supreme Court gives an advisory opinion on question of public importance referred by President. Next is only Parliament can refer question, only questions of fact can be referred. The correct answer is Supreme Court gives an advisory opinion on questions of public importance. The 2025 presidential reference on assent of bills was linked to the constitutional provisions, mainly dealing with 324, 329, 200, 201, 352, 360, 368, 370. The correct answer is 200, 201 with regarding to assent of bills and the time limits associated. Now this is a 2023 prelims question. If the election of President of India is declared void by Supreme Court of India, all acts done by him or her in performance of his duties of the office of President before date of decision becomes invalid. This is specifically the thing I told you. Irrespective of what it is, the work done by him will not become invalid. So this is wrong. Elections for the post of President of India can be postponed on the grounds that some legislative assemblies have been dissolved and elections are yet to take place. Just because any vacancies are there, you cannot postpone the elections of President. When a bill is presented to the President of India, the Constitution prescribes time limit within which he or she has to declare his or her assent. The concept of time limit is not mentioned in the Constitution. So how many of the above statements are correct? Only 1, 2, 3 and none. The correct answer is none of the statements are correct. Next question. Consider the following statements in respect to the election or to the President of India. The member nominated to either House of Parliament or Legislative Assembly are also eligible to be included in the Electoral College. Otherwise, election of President and nominated members will not sit together. So this is wrong. Higher the number of elective assembly seats, higher is the value of vote of each MLA on that state. No, this is wrong. It is not based on each MLA, it is on that particular formula. The value of vote of MLA of Madhya Pradesh is greater than that of Kerala. No. The MLA's it is. The value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh. Yes, because here Puducherry has more than Arunachal Pradesh. Because the ratio of total population to total number of elective seats in Puducherry is greater as compared to Arunachal Pradesh. This statement is correct. So how many of the above statements are correct? It is only one statement. Okay. With this, we come to the end of the content. Next we will be continuing with the governor from your same current affairs part, and then linking it to your static topics. Okay, with this we come to the end of the content. If you like our content, subscribe to our channel, hit the like button and share it along with your friends. Thank you. Hello folks, welcome to Legacy IAS Academy. In this video, we will be continuing with our marathon series for polity from prelims perspective. So in today's topic, we will be discussing about your vice president, prime minister, council of ministers and governors. So if you see, in the last 2025 26 there has been a lot of topics regarding these things, with regarding to the vice president's resignation in the midterm. In the history of India, there has been no such instances where a vice president has resigned in the midterm. So this vice president, your Dankar, had resigned citing health reasons in the midterm. And also there will be a lot of options with regarding to governor, okay, with respect to assent of bills. And also recently the debate with regarding to omission of speech while addressing the session, like we have seen in the instances of Karnataka, Tamil Nadu, Kerala, understanding. So we will see from these topics is a high important topics which weighs a lot from current affairs. We will see the static as well as follow up current affairs. Through that I will be teaching you more points on this. First, we'll start with the Vice President of India. Now, first and foremost, if you see about Vice President of India, if we say your President of India is the first citizen, or in the warrant of precedence, the highest priority is given to presidents, means the second highest position next to president is given to Vice President of India. If you see how the Vice President's office is modeled, it is similar to your US Vice President concept. But there is a significant difference here. What does that mean? First, let me speak about your US Vice President. Let's say in your USA, the whole point of Vice President office is to provide continuity. Continuity means what? Let's say the president, because of any reasons, is not able to assume office. Let's say the president has held office for 2 years. The term of US president is 4 years. Now the remaining term, if you see, that is 2 years. Now this remaining 2 years will be completed by the Vice President of India acting as the president. Now if you see the whole concept of Vice President, one of the important things your Vice President does is, in case a vacancy arises for the office of President in India, okay, a vacancy arises due to a number of reasons, okay, be it death, resignation, health citing reasons, temporary, permanent, whatever it is, your Indian Vice President will assume the role of president. But here is the most important key difference. For US Vice President, whatever remaining term is there, he will be acting as the president. But in India, the Vice President can act as the president for a term of maximum period of 6 months, not more than 6 months. Why? Because in our constitution, there is a particular mandate that tells that the office of president cannot be vacant for more than 6 months, which means if it is vacant, you have to fill it up with elections to the office of president within 6 months. So the vice president is there in India to offer continuity like your US vice president, but the term of US vice president and Indian vice president differs. Understanding? Now, the position of Vice President is a constitutional position. It is the second highest constitutional office after your position of President. Now, how does election of Vice President happens? That also happens through an electoral college. Now the electoral college, here the statements I want you to remember is electoral college the electoral college of your president of India is more broader and it has a wide representation. What do I mean by wide representation? Which means state legislative assemblies also take part in the election of president of India. But whereas with respect to the vice president, his electoral college only comprises of your parliament, which means both houses of Lok Sabha and Rajya Sabha. Now, when I tell both houses of Lok Sabha, Rajya Sabha, I mean both elected plus nominated members of both the houses. Your state legislative assemblies will not take part in the elections of your Vice President of India. Okay, and it is an indirect election through proportional representation through single transferable vote, and it is conducted through a secret ballot. What are the qualifications mentioned in the constitution to become a vice president? First and foremost, you have to be a citizen of India. Here, we do not mention what type of citizen, whether naturally born citizen, by birth acquired citizenship, or through nationalization or acquisition. That we have not mentioned. We only tell citizen of India. And that particular person should be 35 plus years of age. So, minimum is 35 years. And also, one more added aspect is he or she must be qualified to be a member of Rajya Sabha. Okay, the specifics and details are there in your Representation of People's Act of 1951. Now, for the elections also, okay, in order to make sure that you will remove your non-serious candidates, what you will do is you need to have 20 proposers and 20 seconders. 20 people should suggest your name, and next 20 people should recommend that and stand by the decision. And also, you should pay a security deposit of 15,000 to RBI. Understanding? And one more most important aspect is the Vice President of India should not hold any office of profit, with the exception of offices like President, Vice President, Speaker, Governor, these kind of things. Okay. The term is usually for 5 years, and the role of Vice President, if you see, it is two things. First and foremost is your acting president for a maximum of 6 months. Second aspect is act as the ex officio chairman of Rajya Sabha. Understanding? So they are eligible for any number of elections, I mean any number of re-elections. And also, the remember when I was speaking about president previously, I told you there is a constitutional mandate that tells if the office of vice president is vacant, in this case I'm telling vice president is vacant for more than particular period of time, they have not given a timeline as to within which time you have to conduct elections. But for president, it is clearly mentioned that within 6 months you have to conduct election. There is no such obligations to conduct elections in regard to your vice president. Also, if you have to remove the president, there is a ground, okay, that is violation of constitution, impeachment of president will happen, all of those. For vice president, there is no specific impeachment mentioning there. Majority how it happens means, because your vice president is also the ex officio chairman of Rajya Sabha, the removal motion can be initiated only in Rajya Sabha, and it has to be passed in effective majority in Rajya Sabha. Effective majority means what? You will remove the vacancies, and then for that you will consider for the remaining seats. And it has to be agreed upon by Lok Sabha. Agreed upon by Lok Sabha means simple majority say Lok Sabha should pass the removal of the Vice President of India or the Chairman of Rajya Sabha. And for that 14 days mandatory notice has to be given, and for the removal of Vice President there has been no grounds mentioned in the Constitution. In the history of India, no Vice President has been removed. The only first instance of even a motion trying to be introduced against the Vice President, even though it failed, was in your present times, that is your during Dankai period of time, and also he becomes the first Vice President who has resigned during mid-term citing health reasons. Okay, so what are the powers and functions of your Vice President of India? Acts as the Chairman of Rajya Sabha and acts as the acting president in case of a vacancy for a maximum period of 6 months. Now let's see some possible questions from this topic. Consider the following statements regarding election of Vice President of India. First statement, members of State Legislative Assembly participate in the election. I told you, electoral college of Vice President is narrow. There is no wide representation unlike your President, which means State Legislative Assemblies will not take part. Next question, nominated members of Parliament are part of the electoral college. Correct. Election is conducted using proportional representation with single transferable vote. This is also correct. Okay. So the correct options here are 2, 3 and 4. Next question. The resolution for removal of the Vice President of India can be introduced in either house. No, it can only be introduced or initiated in your Rajya Sabha. Requires a special majority in both houses. No, effective majority in Rajya Sabha and simple majority in Lok Sabha. Must originate in Rajya Sabha. Correct. Requires an impeachment procedure. There is no impeachment procedure mentioned for Vice President of India. The correct option is C. Next question. Which body has the authority to decide disputes related to the election of the Vice President of India? See, again in here, options are Election Commission, Parliament, Supreme Court, President. The correct option, if you see, your Supreme Court suo motu will not interfere into the elections of your President, Vice President or MP, MLA. Rather, only through an election appeal. Understanding? And Supreme Court is the final deciding authority with regarding to the dispute. So correct answer is your Supreme Court. Next we will see is with regarding to your Prime Minister and Council of Ministers. Look into this. Article 74. Okay, here a little bit of articles are important. Whatever articles are important, I have mentioned it. Article 74 tells that there will exist something called as Council of Ministers who will be there to aid and advise the President. Understanding? Article 74 COM to aid and advise the President. 42nd Constitutional Amendment Act of 1976 held that the advice tendered by COM is binding on the President. Understanding? And also it holds that whatever communication has been made by your COM to the President, that remains confidential and that cannot be inquired in any court. Okay, so your judicial review is not applicable in the advice tendered by the COM to the President. Understanding? 1 point. Second thing is, aftermath of your 1976, your internal emergency and all the period that we saw, 44th Amendment, which came as a solution to the issues during your 42nd Amendment, was 44th Constitutional Amendment Act of 1978 told that COM will tender an advice to President. Now what President can do is, here we have told the advice is binding on the President. But one extra position was given, telling that the President can return the advice for reconsideration once. When the same advice comes back, that decision is binding on the president. Understanding? So this is the change that was made. So two things, 42nd Amendment, 44th Amendment, you have to remember here. The Prime Minister is appointed, okay, by the President. Prime Minister can be, now usually the ruling party will pick a person to represent himself, that is the Prime Minister of India. That Prime Minister of India can be from Lok Sabha or can be from Rajya Sabha. Understanding? We also have one more provision that tells that a person can be made into a minister. One person who has not contested election can also be made into a minister for a maximum of 6 months. Within that 6 months, he has to contest in elections and win. He can be member of Lok Sabha or a member of Rajya Sabha. We have had instances in our country where our prime ministers have been both from Lok Sabha as well as from Rajya Sabha. Understanding? So, your prime minister is appointed by the president. Now, how is the relationship between prime minister and president? Means this is the president, PM, COM. Your PM acts as a bridge between your president to COM and COM to president. And also, the COM, Council of Ministers, are appointed by the president based on the advice of your prime minister. Understanding? And also your prime minister can tell the COM or any particular minister to resign. Okay, he will be the one who will be allocating portfolios. Okay. Now, these two, that is the prime minister and council of minister, because they are appointed by the president, usually they do not have something called as a fixed term. Okay, no fixed term is there. Meaning what? They hold the office as long as they have the pleasure of president. Now when we tell pleasure of president, the president cannot arbitrarily use his power as long as they enjoy the majority in Lok Sabha. Okay, they will be the prime minister or council of ministers. Now here is where I will be introducing about collective responsibility and individual responsibility. Let's say the prime minister is from Rajya Sabha. Let's say the ministers, council of ministers are also from Rajya Sabha. But the PM and COM are what comprises of the main chunk of the government, central government. Now, this chunk is what we call as state executive. State executive comprises of president, prime minister, council of minister, attorney general of India, and also CAG. Now, your prime minister and council of ministers, irrespective of which house they belong to, they are collectively responsible to Lok Sabha. When they are collectively responsible to Lok Sabha, they hold the office as long as they enjoy the majority and support of your Lok Sabha. This is collective responsibility. What is individual responsibility? Who is the one who appointed them? So the Prime Minister and Council of Ministers are individually responsible to the President of India. As long as they enjoy the support of Lok Sabha, they can be in power, they will have the pleasure of President. Once your Lok Sabha passes no confidence motion and it is passed, then the government, that is your PM and COM, have to resign. Okay. One more important article that you have to remember from your Prime Minister and Council of Ministers, Article 75, which speaks about appointment, tenure, responsibility, everything to do with your Prime Minister and Council of Ministers. Let's see a possible question. Consider the following statements. The Constitution of India classifies the ministers into 4 ranks: Cabinet Minister, Minister of State with independent charge, Minister of State, and Deputy Minister. The Constitution of India does not classify them like this. We have the word mentioned Council of Minister, and also after the amendment we also have the Cabinet word mentioned, but we do not have these other words mentioned. So the first statement is wrong. Second statement, the total number of ministers in the union government, including the prime minister, shall not exceed 15% of the total members of Lok Sabha. This is correct. This was brought about in the aspect, it was brought about through an amendment in order to make sure that 15% of the strength of Lok Sabha is the maximum capping. So correct answer is 2 only. Next question. Consider the following statements. See, this particular topic, whatever we are discussing today, is very important from statement perspective questions. Look at this. The President of India can summon a session of Parliament at such a place as he or she thinks fit. This is mentioned in the Constitution that the President is the one who will summon a session of the Parliament at a place he or she thinks is fit. The Constitution of India provides for 3 sessions of Parliament in a year, but it is not mandatory to conduct all 3 sessions. See, first and foremost, Constitution has not told 3 sessions have to be conducted. What it has mentioned means the gap between one parliamentary session to another session should not be more than 6 months. That's all it has mentioned. Out of convention in India, we conduct 3 sessions: budget session, monsoon session, winter session. But it is not mentioned in Constitution. And also it has not mentioned about how many sessions. It has only told gap between 2 sessions should not be more than 6 months. So this statement is wrong. There is no minimum number of days that the Parliament is required to meet in a year. No, they have specified the minimum number of days. But one important thing, see, there is no minimum number of days that Parliament is required to meet in a year is correct. Again, why? They have told Parliament session will happen. The session gap will be so and so. They have not told how many days you will meet. So this is correct. Okay, so correct statements are 1 and 3 only. Okay, this particular aspect please keep in mind, do not get confused. They have told gap between 2 sessions should be how much, but not how many days you are supposed to meet at a minimum. Next topic is your governor. Okay, the governor becomes an important topic because it has been in your current affair for very long and for very lot of reasons. First and foremost, governor comes under your state executive. Who is state executive? Governor. He is the head of the state. Then comes your chief minister, who becomes the head of the government, and then council of ministers, and then advocate general. So the articles from with regard to your governor are from 153 to 167. State executive comprises of your governor, CM, COM, advocate general, and also your governor. Okay, if you see, many times similarities will be made or comparisons will be made to president and governor. President is elected, okay, indirectly elected through proportional representation and single transferable vote. But whereas your governor is not an elected body, it is a nominated body. Understanding? It is the nominated body, nominated by whom? By the central government. Now your governor will act as a link or an agent of the center and state. Now one thing with respect to your governor is a governor can be made to be a governor of one or more states, or of governor of one state and one union territory. Understanding? In that, look at this. In this case, the governor will be made to act according to the aid and advice of COM in the state. Now, the same governor, when he is acting as, let's say, lieutenant governor or administrator for union territory, he is not bound by the aid and advice of COM. Here, he will act out of his discretion. Because we are comparing between your president and governor, your constitutional discretion and situational discretion concepts will arise. Meaning what? Your President of India has only situational discretion. Okay, your president has only situational discretion, meaning how, let's say elections have happened, no other party has won a clear majority, it's a hung parliament, at that point of time hung government, at that point of time what to do, the president will decide based on the particular situation. But your governor, even though a non-elected body, still has constitutional plus situational discretions. So discretionary powers for your governor is higher than that of your president. Governor is appointed by your president of India, and your governor also holds the office during the pleasure of president. So important article here is 156, that is what it deals with. And he is appointed by your president. Now, one of the most important things you have to know about governor means two aspects. The statement state executive or your state legislature. Here also there exists COM, aid and advice of COM is binding on the governor. See, like when we discussed earlier president, we said that through your 73rd, I mean your aspect of, let me write it here. In your 42nd Constitutional Amendment of 1976, it was held that the aid and advice offered by COM is binding on the President. In the 44th Amendment, it said that COM advice, which is binding on the President, which he can return it once, after that it is binding. This kind of provision was made only for President, it is not there for your Governor. Understanding? It did not mention Governor here, it only mentioned President. First thing. Second thing, with regarding to your assent of bills. When a bill is sent from state legislature to the governor has few options. He can sign the bill or assent the bill. He can withhold the bill. He can return the bill for reconsideration. Or one more thing he can do is, he can reserve the bill for the consideration of President of India. Now, the reserving of the bill is not done by the aid and advice of your COM, but by the discretion of the governor. Understanding? He is the one who will recommend for your, let's say, in the case of imposing state emergency or president's rule in the state. Okay. Now, there are many aspects. Now, because of your role of center, governor, and state, there has been a lot of issues with regarding to the governor in the recent times. One issue is with regarding to assent of bills. Your Tamil Nadu governor's case pay, where it was brought that the governor was unnecessarily delaying the bills, where your judiciary exercised Article 142 complete justice and held that these bills will be passed. Again, this is for the first time that bills are passed without governor's assent. The same voice was raised by your other states of your Tamil Nadu, Kerala. Understanding? Next, look at this. Another aspect is with regarding to every time your governor has a constitutional obligation or a formality, consider it like a constitutional formality where the governor will address the state legislative assembly two times. One is after general election, and second thing is when he will address the state legislative assembly during your first session of the year, or otherwise your financial year. Let's take that. Recently in Karnataka, what happened? The governor omitted certain parts of the address which was presented to him by the Council of Ministers. This raised a question as to, can a governor omit or delete or add or do modifications to the speech which was given by the COM? Then here is where it was decided that no. Why did the governor do this? Again, certain aspects of the speech were critical with regarding to central government, especially with respect to delay of funds from Manrega, right? So these aspects were omitted. This brought in the question, which was again voiced out as the same concern by your Kerala and also your Tamil Nadu. The third issue is with regarding to your emergency provision extension. In your Chakma Autonomous Council, emergency provision was extended by another 6 months by the governor, even though the state cabinet strongly disagreed on that. So, can governor himself alone do that without the aid and advice of COM? All this is showcasing what means this is the objective about the friction between the office of governor. Here is where we will mention two aspects or two important committees. One is your Panchi Commission, and one more is your Sarkaria Commission. Panchi Commission held that the office of governor could be a possible use of misuse can also happen. Sarkaria Commission held that the governor should be the bridge between center and state relations, not the barrier. And also both Panchi Commission and Sarkaria Commission have held that assent of bills should have a timeline for the governor. Your recently judiciary has set up a timeline for governor's assent of bill, which led to your presidential reference to the judiciary on asking regarding the doubts of this particular aspect. Okay, so this is your governor topic. Understanding? So, what are the qualifications to be the governor? You have to be a citizen of India and you have to be 35 plus years of age. This is constitutional provision. But out of convention, there are two more things that is usually done. I'm using the word usually. Again, I'll tell you why. One is the governor should be an outsider from the state and the chief minister of that respective state should be consulted before appointing someone as the governor of the state. But most times this particular options or instructions are not followed. Again, it is not binding to follow this. It is just out of convention. The important articles here you have to look into is assent of bills, Article 200, and ordinance making power of your governor. Ordinance making power you have to by heart it like this. Ordinance making power of president is through Article 123, means your governor will be reverse Article 213. Okay, by heart these two articles. And also in many cases your president's permission is needed before promulgation of an ordinance. Other important articles we will see with respect to your governor is Article 163, which tells that there will be something called COM, Council of Ministers, who will be there to aid and advise the governor. And this will apply in all cases except wherever governor has discretion. And also here also, governor is the one that will appoint the chief minister of the state, and the chief minister of state advises the governor to appoint the council of ministers. So your chief minister and council of ministers hold the office during the pleasure of the governor. So what are the constitutional discretions your governor has? While reserving a bill for the president, Article 200, recommending president's rule in a state, Article 356, administration of union territory as an additional charge or just as an administrator of union territory, situational discretion when there is hung government, CM appointment and also dismissal of a ministry which loses a majority, and dissolution aspects with regarding to your political scenarios. Okay, now let's see some questions from this topic. Under Article 200, which of the following is not an option available to a governor for a money bill? Here, look at the option they are telling. Money bill. He can give his assent, withhold his assent, return for reconsideration, or reserve for president. See, when it is a money bill, he can give his assent, he can withhold his assent, or he can even reserve for president, but he cannot return the bill for reconsideration. Again, the bills are introduced with his prior recommendations only, right? Now, this is with regarding to pardoning powers of your governor. Governor cannot pardon. Look at the word cannot. Imprisonment for offences against state law, fine imposed under state law, death sentence, remission for a state law offence. See, with regarding to your remission, respite, commutation, all of this is available to your governor also. In fact, let's say this is a death sentence. Your governor can commute the death sentence, which means he can remove the death sentence to, let's say, life imprisonment. He can reduce the objective nature, everything he can do. But only thing he cannot do to a death sentence is he cannot completely pardon it, which means no punishment at all concept cannot be given. That is the power only for your president, and all these can be done not by the discretion of president or governor, but based on the aid and advice of council of ministers. The correct answer is he cannot pardon a death sentence, but he can commute, okay, reprieve, respite, all those options are available. Next, with reference to the Legislative Assembly of a state in India, consider the following statements. The governor makes a customary address to the members of the house at the commencement of the first session of the year. Okay. When a state legislature does not have a rule on a particular matter, it follows the Lok Sabha rule on that matter. See, the governor makes customary is again I discussed it is in 2 points. First, general election and beginning of each year. So here, look at this. When a state legislature does not have a rule on particular matter, it follows the rule that is made by Lok Sabha only. Understanding? So option B is correct. Next question. Which one of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links or should not have taken part in the politics in the recent past? Where have they suggested? Again, I told you, because of so much in news about these topics, these questions have become important. First ARC report, that is in 1966, Rajmannar Committee 1969, Sarkaria Commission 83, National Commission to review the working of the Constitution. Like we discussed earlier, the correct answer is Sarkaria Commission. Next question. Consider the following statements. No criminal proceedings shall be instituted against the governor of a state in any court during his term of office. The emoluments and allowances of the governor of a state shall not be diminished during his term of the office. Now, here are few things. There are certain immunity given to the office of president and to the office of governor. What are these immunities means? Let's divide it into two aspects. Let's say a governor, okay, on him some criminal case has to be lodged. You cannot start a criminal proceedings on a person who is holding the office of a president or a governor during his term in the office at all. Okay, even if it is done in personal capacity. Okay, even if the criminal activities or criminal proceedings are done in the personal capacity, you cannot carry out criminal proceedings as long as they hold the office of president or governor. Again, this is not the position or power given to them, but to the office they hold. So according to this statement is right. But this applies only to criminal proceedings and not civil proceedings. You can instigate civil proceedings against a governor or president, by giving 2 months advance notice. Okay, so this is the immunity that your head of state of your governor and president enjoys. Next is the emoluments and allowances of governor of state shall not be diminished. Yes, this is correct because this ensures that you are not subject to anyone, meaning you're not bound by a salary payer, so you have to be listening only to them concept. So the correct option are both 1 and 2. Next. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then the assembly of a state is automatically dissolved. Assembly means here we are talking about state legislative assembly. Look at the keyword here, automatically dissolved. In Constitution, the provision of automatically something happening is not very there. So the concept of state getting automatically dissolved will become wrong because state legislative assembly doesn't have to be automatically dissolved. Now let's take your example of Manipur itself. Violence has been there. Your ethnic violence happened because of the presidential rule was put here. Legislative assembly is not automatically dissolved. It is just suspended. Next, the power of the legislature of that state shall be exercised by or under the authority of the parliament. Yes, this is correct. Next, Article 19 is suspended in that state, not necessarily unless and until it is mentioned. The president can make laws relating to that state. Okay. But in this aspect, no, first and foremost, what is the important thing you should consider means the legislature of that state, when we are telling, shall be exercised by or under authority by parliament. And this statement, don't you think your B and D are contradictory? President can make laws means then why parliament will be there in the first place, right? So these two are contradictory to each other. The law making will not come under president, it will come under your parliament. Understanding? So because of that, D is wrong. Correct option is B only. Next question. Which of the following are not necessarily the consequence of proclamation of president's rule in a state? Not necessarily. Okay. First and foremost, which are the not portions? Dissolution of state legislative assembly. It is not mandatory that dissolution has to happen like we discussed in the previous question. So correct. It is not mandatory. Removal of council of ministers in the state. Yes, this will happen. Okay. Okay. Next is dissolution of local bodies. No, why will local bodies be dissolved if something is there with respect to your president rule? No, this is not going to happen. So the correct option is 1 and 3 only. Okay. So because these topics are very important, we will learn these topics through these questions. Consider the following statements. The chief secretary in a state is appointed by the governor of that state. So see, the chief secretary concept is something that comes from your permanent executive or bureaucracy. That will be looked after by a cabinet secretary and not governor of the state. So this statement is wrong. The chief secretary in a state has a fixed tenure. No, there have been many recommendations made to make sure that give a fixed tenure for your chief secretary. But as of now, there is no fixed tenure for a chief secretary. So correct answer is neither one nor two. But there has been a lot of recommendations telling to give a fixed tenure. Next question. Which of the following is or are the functions of the cabinet secretariat? Yeah. Preparation of agenda for cabinet meetings. Yes. Secretarial assistance to cabinet meetings. Yes. Allocation of financial resources to the minister. So why will they allocate financial resources? No, they will not allocate. In fact, it will be the reverse. The correct options are 1 and 2 only. Allocation concept of financial resources will not come to your secretariat. Which of the following are the discretionary powers of the governor of a state? Okay, here we are discussing about discretionary powers. First one, Sending a report to the President of India for imposing President's rule. Yes, that is correct. Second thing, appointing the minister. No, he cannot appoint the minister based on his discretion. He has to follow which particular party has. Now, let's say with respect to chief minister, whichever party has the majority in the legislative assembly, and the ministers, council of ministers are appointed on the advice of chief minister, not on the discretion of governor. So, second statement is wrong. Reserving certain bills passed by state legislature for consideration of President of India. Correct. This is his discretion. So correct options are 1 and 3 only. Next, look at this. Consider the following statements. The President shall make rules for the more convenient transaction of the business of the Government of India and for allocation among the ministers of the said business. Yes, with regarding to convenient transaction, it is mentioned that it will be the President. All executive actions of the government in India shall be expressed to be taken in the name of Prime Minister. It is not Prime Minister, it is President of India. All executive actions are taken in his name. The correct option is 1 only. Okay. Next question. Look at this. Consider the following statements. The Council of Ministers in the center shall be collectively responsible to the Parliament. See, the Council of Ministers are not collectively responsible to the Parliament, irrespective of where the Council of Ministers are, whether they are from Rajya Sabha or Lok Sabha, they will collectively be responsible to Lok Sabha. So, this statement is wrong. The Union Minister shall hold the office during the pleasure of President of India. Correct. Appointed by him. The Prime Minister shall communicate to the President about the proposal for legislation. Yes, he has to do that. That is where we said President, Prime Minister, COI. So the correct options are 2 and 3 only. Okay. Now, which one of the following statements is correct? In India, the same person cannot be appointed as a governor. Look at this. In India, the same person cannot be appointed as a governor for 2 or more states at the same time. Cannot be appointed. Why? Can be appointed. That is what we discussed. So this statement is wrong. Let's look at this. The judges of High Court of the states in India are appointed by the governor of a state, just as the judges of Supreme Court are appointed by the president. This is a easy trap question, okay? But your judges of High Court of the state are appointed not by the governor, by the president only. The President of India appoints the judges of Supreme Court as well as your High Court. So this statement is wrong. No procedure has been laid down in the Constitution of India for the removal of governor from his or her post. Yes, because they hold the office until the pleasure of president. So this statement is correct. In case of union territory having a legislative setup, the chief minister is appointed by the lieutenant governor or based on the majority support. No, it is by the president. Okay. Last question we have come to. The Prime Minister of India at the time of his or her appointment need not necessarily be a member of one of the House of the Parliament, but must become a member of one of the House within 6 months. This is the provision I told you. So he can be from Lok Sabha, he can be from Rajya Sabha, he cannot be a minister or MP, but he has 6 months of time. So this statement is correct. Need not necessarily be a member of one of the houses of the parliament, but must become a member of Lok Sabha within 6 months. There is no provision that you have to become a member of Lok Sabha only. You can be of Lok Sabha or Rajya Sabha. That is of your parliament, member of parliament. So this statement is wrong. Must be a member of one of the houses of parliament. Must be a member of Lok Sabha. The more apt answer is he need not be necessarily a member of one of the houses of the parliament, but must become a member of one of the houses within 6 months. So that is the correct answer. With this, we have come to the end of the content. If you like our channel, if you like our content, subscribe to our channel, hit the like button and share it along with your friends. For more content, follow Legacy IS Academy. Thank you. Hello folks, welcome to Legacy IS Academy. In this video, we will be continuing with our Polity Prelims Marathon series. So in today, we will be going ahead with Parliament, State Legislature and Parliamentary Committees in our Marathon series 5. So here we will also be imbibing these particular topics into our questions and our topic of money bill misuse debates, speaker neutrality and defection delays, parliament productivity issues, frequent ordinances, biocenter, opposition leader recognition and joint sitting relevance in a hung parliament. Okay. So let's get started. First and foremost, your parliament consists of Lok Sabha, Rajya Sabha. These are mentioned in your Article 79 to 122. Now, we will see the features of Lok Sabha and Rajya Sabha. Lok Sabha maximum strength is 552. As of now, presently it is 543. The elections to your Lok Sabha is our country is divided into various units called constituencies, where the elections are direct elections, and also the tenure of Lok Sabha is usually 5 years. Now, when we say usually 5 years, which means it can be dissolved even before that, when there is a loss of let's say there is no clear majority, understanding, or after the election has happened, it is a hung parliament. So this particular Lok Sabha is subject to dissolution, and money bill can be introduced only here. And also in your maximum strength 542, now when we say 543, we had one provision where you could nominate 2 members. The president could nominate 2 members from the Anglo-Indian community here. But this provision was done away with your 104th constitutional amendment of 2020. If you see, Lok Sabha is called the lower house, where it is more of a representative of people. Means your Rajya Sabha is the upper house, or it is a representative of states and union territories. It is the Council of States. The maximum strength of Rajya Sabha is 250, present strength is 245. It is a permanent house, which means Rajya Sabha is not subject to dissolution. Only the members retire every 2 years. 1/3 of members retire every 2 years, and also a president can nominate 12 members who have did significant contribution to art, literature, science, social service, etc. Okay, and also in the 4th schedule of the constitution, it speaks about seat allocation to Rajya Sabha. Now let's see how the election system is. For your Lok Sabha, it is first past the post system, and here it is about single member constituency, and also the way we follow is through your universal adult franchise, 18 plus years of age. Now the same thing when we tell universal adult franchise, earlier it was 21 years, which was brought down to 18 years by your 61st constitutional amendment of 1989. Rajya Sabha, on the other hand, is a proportional representation. It is through your single transferable vote, and also if a Lok Sabha is direct election, your Rajya Sabha is indirect elections. If this is first past the post system, this is proportional representation through single transferable vote. Understanding? Now, at no point should you compare your legislative assembly, legislative council to Lok Sabha and Rajya Sabha. Okay, Rajya Sabha is truly a very strong body, understanding, but there are certain equal and unequal powers here also visualized. But at any cost, do not compare your legislative assembly and Lok Sabha, legislative council and Rajya Sabha. Now, let's see some provisions of the chair of the house or presiding officer of the house. Lok Sabha is presided by the speaker of the house. Your Rajya Sabha is presided by your vice president or chairman of Rajya Sabha. Speaker of Lok Sabha has powers in order to decide whether a bill is money bill or not. The decision of Speaker of Lok Sabha is final, and your Speaker of the House is who will preside over joint sitting of both Lok Sabha and Rajya Sabha, and not chairman of Rajya Sabha. Also, your speaker is the ultimate authority to decide with regarding to disqualifications of members under your 10th schedule with regarding to defection. Your Supreme Court in 1992 said that your decisions of speaker with regarding to defection, like we said in 10th schedule, are subject to judicial review. Understanding? If there is proven grounds of malice. Understanding? And also the speaker is the one who will decide whether a particular sessions will continue or not based on the quorum. The quorum is going to be 1/10 of the total strength of the house. Now, when you see with respect to chairman of Rajya Sabha, the chairman of Rajya Sabha is also the vice president of India. And one more thing is the chairman of Rajya Sabha is not a member of Rajya Sabha. Understanding? Unlike speaker, where the speaker will be from your Lok Sabha. But when they go on to become that, they will leave this. But your vice president or chairman of Rajya Sabha has a electoral college. We have discussed that, right? So vice president ka electoral college is much more narrower compared to the broad electoral college of president of India. So what is the electoral college of vice president of India? That is your elected plus nominated members of Lok Sabha, elected plus nominated members of Rajya Sabha. So which means members of the parliament. Here no state legislative member are involved. Also, the vice president, that is the chairman of Rajya Sabha, cannot preside over the joint sittings. Now, one most important thing you have to understand here is in our constitution, they have told the gap between one parliamentary session to another parliamentary session should not be more than 6 months. Understand this very, very clearly. Meaning, this is first session, this is second session. Gap should not be more than 6 months, which means at least in a year 2 sessions should happen. That is what is mentioned in constitution, nothing more, nothing less. But we in India, we follow 3 sessions. Your budget session, monsoon session and winter session. Alright, and also constitution at any point of time has not mentioned how many days should parliament work. Understanding? It has not told minimum number of days that is needed for working of the parliament in these sessions. The budget sessions are from February to May, monsoon are from July to September, winter is from November to December. Understanding? So this has to be kept in mind. Next is with regarding to in parliament we will be seeing with respect to adjournment, sine die and all. So your adjournment, understand it like this. If I give a specific timeline, let's say now I am the speaker where I will tell let us adjourn the house today and convene back tomorrow at so and so time. So which means I'm ending this session, this today's sitting, but I'm also telling there will be continuity of the session. Understanding? So adjournment is it just ends the sitting, not the entire session, because I'm telling that you will come back, convene in a particular date and time. Adjournment sine die, on the other hand, tells that you are ending the sitting with no respective date of prospective meeting. So which means it will end the session. And also prorogation completely ends the session, that is by your president. Dissolution means it ends the life of Lok Sabha itself. Understanding? Now when we tell dissolution, only Lok Sabha is subject to dissolution and not Rajya Sabha, because Rajya Sabha is a permanent house. Only members retire. 1/3 of members retire every 2 years. Now let's see with regarding to your parliamentary devices. First one is questionnaire. This is the very first thing. When the session or your sitting starts, it will be usually with respect to your starred question, oral question or unstarred question. Understanding? What are the differences between these means based on the responses that have to be given by the ministers. For example, starred question, you have to mandatorily answer that question. Follow-up questions can be followed. Written answers, now when we tell written questions, these does not mandatorily mean that written questions can follow, and answer also will not be given orally, it will be through your written form. Next is your 0 hour. This is not mentioned in the constitution. This is an Indian innovation. For anything that we have not discussed in any other aspects, we can discuss that in 0 hour. This has been there since your 1962. It is an Indian innovation. We also have various motions such as your adjournment motion, which can be carried out in Lok Sabha only. It needs the support of 50 members, and this is to draw attention to very important matters. And also no confidence motion, which can be again introduced in Lok Sabha only. Censure motion, again, if you have to censure someone, it is to showcase that you are showcasing that so and so point said by a particular minister is wrong, or factually they have withheld something, so you're trying to censure a particular person. Then is motion of thanks. If motion of thanks is almost like highlighting the government policies, budgets, government schemes, what plans does it have. If this fails to be passed, then that means it is understood that it is a defeat of government. Next, we will see with regarding to types of bills. Now, whatever I'm discussing, these are just few topics. Much more topics under these things. I will be explaining it with the questions and discussing those topics there. Understanding? Now, let's look into types of bills. Look at this. Under types of bills, we have ordinary bill, money bill under Article 110, financial bill 1 and 2, and then we have constitutional amendment bill. Now let's see ordinary bill ka power is first and foremost. Let's discuss ordinary bill. Ordinary bill can be introduced in either of the houses. Okay, if either of the houses gets introduced and it is defeated in the other house, that is, if the other house doesn't pass, the bill dies. Understanding? So this is pretty much as the name states, ordinary bill. Equal powers are there for Lok Sabha and Rajya Sabha here. Now let's come to money bill. First and foremost, a money bill can be introduced only in Lok Sabha. This is one of the provisions where Lok Sabha has a unequal power with Rajya Sabha. Understanding? Now, when it is an ordinary bill, it can be introduced in both Rajya Sabha as well as Lok Sabha. Money bill can be introduced only in Lok Sabha. And your Rajya Sabha cannot veto or withhold or reject a money bill. By and max, what Rajya Sabha can do is it can suggest recommendations and it has to take action within 14 days. Now, no such provisions are there for your ordinary bill. Let's say Lok Sabha has introduced a bill, ordinary bill, and sent it to Rajya Sabha. Rajya Sabha can even reject this particular bill when it is ordinary bill. But when it is money bill, it does not have the veto power, that is, it cannot reject the bill. And also, whether a bill is money bill or not, the final deciding authority is the speaker. Now, when the speaker endorses the bill to Rajya Sabha, they will endorse it as money bill. So, when it is endorsed as money bill on top of the bill, then it itself means that this has showcased that the powers of Rajya Sabha in this is constricted. Now, this also shows the difference between your powers and positions of Speaker of Lok Sabha and Chairman of Rajya Sabha. Chairman of Rajya Sabha does not have the right to determine whether it is a money bill or not. The only decision authority final is with respect to Speaker of Lok Sabha. And also, your president can also not return the money bill. He can accept it, reject it, but cannot return it. Next is with regarding to financial bill 1. Look at this. Now, when we say financial bill 1, the options, that is the article, is article 117 of 1, which speaks about money bill plus other matters. So the provisions which are mentioned in article 110 plus other matters are together what is called your financial bill 1. One thing about this particular bill speciality is this can be introduced only in Lok Sabha and on President's recommendation. Here, Rajya Sabha can either suggest changes or even reject it. Understanding the only difference is it has to be introduced in Lok Sabha through and your President's recommendation. Next is your Financial Bill 2. One important provisions between Financial Bill 1 and Financial Bill 2 is It has money bill plus other matters, financial bill 1. But financial bill 2 is it does not have any money bill provisions. So in simpler sense, if I have to put it, financial bill 1 will be, or this is article 117, right? Article 117 of 1 is article 110 plus other matters. Okay, that is your financial bill 1. Whereas here in financial bill 2, 117 of 3 is does not mean 1110 plus other matters. In fact, it does not contain your money bill provisions. Then what are the other matters? Anything that affects the consolidated fund of India expenditure, then those things will be brought under here. Now, one speciality of your financial bill 2 is financial bill 1 can be introduced only in Lok Sabha. But in financial bill 2, it can be introduced in either of the houses. So either in Lok Sabha or in Rajya Sabha. One important aspect here you have to know is, in this, it requires president's recommendation. Understanding? And joint sitting is allowed in this. Clear? So it is almost similar like a ordinary bill. So ordinary bills are, that is your joint sittings are applicable in which of the bills? Ordinary bill space applicable and financial bill. Whereas it is not applicable in a money bill and constitutional amendment bill. Here no joint sitting is there. And whenever a joint sitting is there, who will be presiding over the session? It is the Speaker of the Lok Sabha. Understanding? Now we will be discussing cut motions. Look at this. Now, what is the cut motion? First and foremost, policy cut motion. See, first and foremost, irrespective of any of the type of cut motions, if a cut motion gets passed, it is an indicator that the government has lost the majority, or this will be a point to pass your no conference motions, thinking that the government does not have the majority. So any sort of cut motions, okay, will threaten the stability or majority of the government. The first thing is policy cut motion, which means you are telling, let's say, I am disapproving this policy itself. How? Let's say your particular policy is asking around 100 crores. In that, you will tell, I'm going to cut all the money and I'm just going to give 1 rupee for you. You are asking 1 rupee, and if you are asking 100 crores, and if only 1 rupee is given for you, what does that mean? You are disapproving the policy itself, and also this means that your majority is in question. Okay, so this would amount to loss of confidence on the government. Next is economic cut motion. Economic cut motion means a significant amount is reduced in what you have asked. Let's say you ask 100 crore, they will tell only 30 crores I'll give you. Okay, a significant amount is reduced. Next is token cut motion. Okay, token cut motion means in whatever, let's say you are going to pass a bill, it is a bill on healthcare. They are telling, I want to cut 100 rupees out of this. Why? To showcase the scenario of or situation of Indian healthcare system. So it is to vent out your anger. The passage of any three of these cut motions will amount to loss of confidence on the government. Now let's see with respect to the privileges of the house. Now there are certain collective privileges and individual privileges. Collective privileges for all the members put together for the house, and individual privileges for the members. So individual privileges, what do you get? Freedom of speech in parliament. You cannot be charged for anything that has happened or anything that has spoken in parliament. No criminal proceedings can happen. And also you will have civil cases immunity. You can't be arrested 40 days before or after or while during the session. Next is collective privileges, is something with regarding to punish, the parliament has the power to punish someone for contempt of the house, and also they can ask for secret sitting, which means exclude the strangers, understanding. They also have a right to publish, understanding. Now, what are some of the special powers of Rajya Sabha? Now, like I told you, you should not compare your legislative council and Rajya Sabha, because Rajya Sabha is a body that has truly, okay, a strong equal set with respect to your Lok Sabha, unlike your legislative council. So, which means Rajya Sabha has unequal powers, correct, but that does not mean Rajya Sabha has no powers. Rajya Sabha has some special powers. For example, if any law has to be made with respect to state law, according to your Article 249, Rajya Sabha has to pass a resolution. Then also for creation of new All India services under Article 312, that also Rajya Sabha has to pass a resolution. And also for removal of vice president. The removal of vice president, your vice president is none other than your ex officio chairman of Rajya Sabha. So for ex officio chairman removal of Rajya Sabha, it has to be initiated in Rajya Sabha alone. And it has to be passed with effective majority in Rajya Sabha and agreed upon by Lok Sabha. Now when we say agreed upon by Lok Sabha, we mean it has to be passed by simple majority in Lok Sabha. Understanding? And also with regard to any emergency approvals has to be made, and that time Lok Sabha has dissolved, means then your Rajya Sabha will. Now let's see some possible questions where we will learn a new static topics, but through the way of questions. Understanding? Now, which of the following statements about ethics committee in Lok Sabha are correct? Okay, this is a committee question which we will be coming in a little later also. Parliamentary committee will also be there. Now, look at this. Oh, it's here. Initially, it was an ad hoc committee. Only a member of Lok Sabha can make a complaint relating to unethical conduct of member of Lok Sabha. Again, this topic we will separately discuss in parliamentary committee, because the question is here, we will discuss this. This committee cannot take up any other matter which is sub judice. First and foremost, ethics committee. Initially, was it an ad hoc committee? Yes, it was an ad hoc committee. Only a member of Lok Sabha can make a complaint relating to unethical conduct of member of Lok Sabha. No, not only a member of Lok Sabha, but this ethics committee can also take suo motu actions. So, second statement is wrong. So, if you eliminate second option, that gives you the answer 1 and 3 only. This committee cannot take up any matter which is sub judice. Next question. As per Article 368 of the Constitution of India, the Parliament may amend any provision of Constitution by the way of addition, variation, repeal. Which of the options are correct? In simpler things, all they are asking is, through Article 368, what can Parliament do to the Constitution? Can it add to the Constitution? Yes. Can it repeal? Yes. Addition of, for example, take Article 21, repeal, you can take Article 31, variation also is there. So, all three, 1, 2 and 3 are the correct answer. Next, this is with regarding to your bills. Which of the following statements are correct in respect of a money bill in the Parliament? Look at this question. Article 109. Up until now, what we discussed was Article 110 only. Article 110 we discussed, Article 117 of 1, 117 of 3. Article 109 mentions special provision in respect of money bills. This is correct. Article 109 is the one that gives special procedure in respect to money bills, that we told is it has to be introduced here only. Rajya Sabha has only these things. Okay. A money bill shall not be introduced in the Council of States. What is Council of States? Nothing but Rajya Sabha. So we know that money bill can be introduced only in Lok Sabha. They're telling shall not be introduced. So correct. Next, the Rajya Sabha can either approve the bill or suggest changes but cannot reject it. Like we told, the maximum duration that your Rajya Sabha can have with the money bill is just 14 days. In that time, it can either approve the bill or suggest the changes. That is nothing but your recommendation, but it cannot reject the bill. So this is correct. Understanding? Next, amendment to a money bill suggested by Rajya Sabha have to be accepted by Lok Sabha. Whatever amendment suggested by Rajya Sabha to the Lok Sabha is not mandatory to be accepted by Lok Sabha. So this statement is wrong. The correct options are 1, 2 and 3 only. Now, with reference to union budget, consider the following statements. Again, I'm telling you, we are looking at parliament topic, half from your static, half from your current affairs. So it will be a mix of learning the topics. With reference to union budget, consider the following statement. Union Finance Minister on behalf of Prime Minister lays the annual financial statement before both the houses of parliament. Union Finance Minister on behalf of, it is not Prime Minister, it is on behalf of President of India. So this statement is wrong. Understanding? At the union level, no demand for a grant can be made except on the recommendation of President of India. This is correct. So the correct option is 2 only. Next question. With reference to the Speaker of the Lok Sabha, consider the following statement. Here we are seeing with respect to Speaker. While any resolution for the removal of Speaker of Lok Sabha is under consideration, he or she shall not preside. Correct. He or she shall not have the right to speak. No, as a matter of fact, they have the right to speak. Let's say if they have to defend themselves, do you think that if you don't give them a right to speak, then how would it be fair? So, he or she shall not preside is correct. He or she shall not have the right to speak is wrong. He or she shall not be entitled to vote on the resolution in the first instance. No, when they are being considered for this, they can vote in the first instance. That is, they are entitled to vote. This is also wrong. Correct option is only 1. Next question. With reference to the Indian Parliament, consider the following statements. A bill pending in Lok Sabha lapses on its dissolution. Here it is more about your pending of bills in which of the houses leads to what. We will learn it through the question. A bill which is pending in Lok Sabha will lapse on its dissolution. Now, a bill passed by Lok Sabha and pending in the Rajya Sabha lapses on the dissolution of Lok Sabha. This is also correct. Yeah. A bill in regard to which the President of India notified his or her intention to summon the House to a joint sitting lapses on the dissolution of Lok Sabha. No. Here, if they have told their intent for joint sitting, then that point of time, this will not lapse even after your dissolution of Lok Sabha. So, the correct options are 1 and 2 only. Look at the next question. With reference to Parliament of India, consider the following statement. Prorogation of a house by the President of India does not require advice of Council of Ministers. Now, he has to act based on the aid and advice of COM. Next, prorogation of a house is generally done after the house is adjourned sine die, but there is no bar to President of India proroguing the house which is in session. True. Understanding? Sine die ends the sitting without a foreseeable date in the future. Right? Next. Dissolution of Lok Sabha is done by the President of India, who, save in exceptional circumstances, does so on the advice of Council of Ministers. Yes, this will happen, but sometimes, okay, let's say they have lost the majority and there is no alternate viable government. That are the exceptions. Okay, so this is also correct. So correct options are 2 and 3 only. Next question. With reference to finance bill and money bill in the Indian Parliament, consider the following statements. Again, I've told you money bill article 110, finance bill 1 is 117 of 1, which is 110 plus other matters, 117 of 3, financial bill 2, that does not have any provisions of article 110. Now let's see. When the Lok Sabha transmits finance bill to the Rajya Sabha, it can amend or reject the bill. Yes, we are speaking about finance bill, so it can. This provision is correct. When the Lok Sabha transmits money bill to the Rajya Sabha, it cannot amend or reject the bill. It can only make recommendations. That is what we discussed. Money bill by and max, what it can do is keep it for 14 days with it. This second statement is correct. In the case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for finance bill. See, look at the first option. Case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill is correct. Joint sitting is not there for which bills? Money bill and your constitutional amendment bill. Now, the second part of the statement, up until here it's correct. But a joint sitting becomes necessary for finance bill. Why does it become necessary for finance bill? They would have asked whether joint sitting is possible or not. That becomes a separate question. They are mentioning becomes necessary. It is not necessary. So this statement is wrong. How many of the above statements are correct? Only 2. Next, we will be looking into your state legislature. Okay. State legislature, again, we have it in part 6. Your parliament, that is union, is under part 5. This is from articles 168 to 169. Now, in our respective country, we are a federal country with lot of unitary features, right? So, this concept of federalism is something that is given by the constitution itself, right? We have in most states unicameral legislature, which means legislative assembly and governor, that's it, which means there is presence of only one house. But there are few states has bicameral legislature, which means two houses. Now for unicameral legislature, it is governor and legislative assembly, which is called as Vidhana Sabha. Bicameral legislature is one legislative assembly and legislative council, your Vidhana Sabha and Vidhana Parishad. So, which states are having these bicameral legislature? Means Karnataka, okay, Andhra Pradesh, Telangana, Maharashtra, Uttar Pradesh and Bihar. Okay. Now, with regarding to your legislative council, first, let's see about your legislative assembly. The term of legislative assembly is usually 5 years. Okay, the legislative assembly is subject to dissolution. The legislative council is more like a permanent house. Again, when I'm telling more like a permanent house, you can completely abolish it. Okay, but it is not subject to dissolution. All right. Now, abolition or creation of legislative council is there in your article 169. If a particular state feels like they have to abolish or create a legislative council, then they have to pass a special majority. Now, special majority means total membership of the legislative assembly and more than 2/3 of members present and voting. This has to be done. Then finally, Parliament also passes a law for abolition or creation of this particular state legislative council, but it will pass it with simple majority. Now, when Parliament passes this with simple majority, this is considered like a just ordinary law and not like a constitutional amendment, and this does not have to be brought in under Article 368 at all. It is a mere simple majority ordinary bill. Understanding? One more thing about your legislative council is the very entire existence of legislative council is dependent on your legislative assembly. Understanding? Now, let's see the strength of the house. Your legislative assembly maximum can be 500. Minimum has to be 60, but there are some exceptions like your Arunachal Pradesh, Sikkim, Goa and all have only 30 seats. And Mizoram has 40, Nagaland has 46. Also, governor can nominate one Anglo-Indian member to your legislative assembly, but this provision has been done away in your 104th constitutional amendment of 2020. Now, here also, like we discussed in parliament, the constitution has only mentioned what should be the time gap between two sessions. Meaning, they have specifically told that the time gap between two sessions should not be more than 6 months. Understanding? They have not mentioned how many days or how many days in a particular session you have to work. And also, one important aspect when we are going to link with current affairs. Recently, if you see, there is the objective of where your governor of Karnataka, governor of Kerala, Tamil Nadu, all these issues had come in where the governor, there is a constitutional formality where the governor will address the house. He will address it 2 times of the year. One is at the beginning of each year and after general election. Now, when the governor was addressing, that is, let's say this constitutional formality, when he was addressing, he has to read from what your COM has given. The governor in this, what happened means, especially in your Karnataka case, they modified, they left out some parts. Understanding, they left out some parts because let's say it was too critical of the central government with regarding to your funds, delay for your Manrega and all this. So this brought the question, can a governor of a state modify, amend the speech which is given by COM? First and foremost, the provisions you have to see is the governor cannot amend on his own. He can only use discretion on constitutional matters, constitutional discretion where he is given, only there he can use. This he was subject and bound by your aid and advice of Council of Ministers. What other options he had? He could send it for reconsideration, get clarity. Understanding? So, governor on his own cannot exercise discretion on matters where it does not exist. Understanding? So, which particular provisions? Article 175 and 176 tells this for governor of a state. Next, with regarding to your unicameral states, we have governor, legislative assembly. Bicameral states are legislative assembly, legislative council, governor. So as of now, we have Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra and Karnataka which are having bicameral legislature. Now let's see the strength of your legislative council or Vidhana Parishad. They are indirectly elected, whereas your legislative assembly is directly elected. This is partly nominated body also, and also it is a permanent house. Legislative council is not subject to dissolution, but the abolition or creation of legislative council is dependent on legislative assembly. Understanding? Look at this. So, the maximum number of seats your legislative council can have is 1/3 of the total of your legislative assembly house ka strength. That is the maximum. Minimum has to be 40, which is the number will be exactly fixed by your parliament. What is the mode of election for your legislative council? If you see, 1/3 of the members will be elected by the local bodies like your panchayat, municipalities, and 1/12 will be by the teachers, and your 1/3 will be by MLAs, and 1/12 of it will be by graduates who have completed more than 3 years in standing, and 1/6 of these members will be nominated by governor, people who have contributed in your science, literature, art, cooperatives, understanding. Now let's see the qualification to become a member of legislative assembly or legislative council. First and foremost, for both legislative assembly, you have to be citizen of India and 25 plus years of age. For to become a member of legislative council, you have to be 30 years plus your citizen of India. One important thing is with regarding to your qualifications, your MLAs and MLCs are subject to two things. One is constitutional provisions and also your Representation of People's Act 1951. Understanding? And your RP Act of 1951 has also told that this particular person, contesting person, has to be an elector in that respective state. They have also various other provisions. So people are subject to constitutional provision as well as your RP Act of 1951. Next, with regarding to defection. Now the decision with regarding to the defection final is your Speaker of the House, and in the council it is the chairman. It is in the 10th schedule. Understanding? And also your judiciary in 1992 has held that this defection, this qualification through defection is subject to judicial review. Now let's see with the powers. It is almost similar. Your state legislature is very similar to that of your parliament in some of the basic functionings. So presiding officer for legislative assembly is speaker. Presiding officer for legislative assembly is chairman. Now with regarding to the speaker, what is the provisions they have? They maintain the order and they are the final interpreter of your rules, and money bill will be certified by the speaker and their decision is final. And also they cannot vote in the first instance, they will only do a casting vote in case of tie. And also all the defection cases with respect to 10th schedule will be decided by the speaker. Next, when we say with respect to chairman, chairman also has somewhat similar powers, but certain things like your money bill, okay, these provisions are not there for your chairman. And one of the aspect is the concept of council, understand, is a permanent house but not subject to dissolution, but abolition or creation under the hands of legislative assembly. Now let's see with regarding to the bills and resolutions with respect to your legislative assembly and council. Now we will see this for your bicameral legislature, because unicameral though there is only one house. Okay. Now if a bill is pending in the assembly, legislative assembly, then that particular bill will lapse upon dissolution of legislative assembly. Now let's say the bill is passed by legislative assembly but it is pending in your council, but your assembly has lapsed. So at that point of time, that is assembly is dissolved, that means this lapses. Now let's say the bill is pending in the legislative council but it is not even passed by legislative assembly, and then dissolution happens, then at this point of time this bill does not lapse. Now finally both houses, okay, have passed the bill but it is pending governor or your president consent. Based on the governor has reserved that particular bill, then this bill does not lapse. Okay. Now with respect to your ordinary bills, okay, see in Rajya Sabha, I continuously kept mentioning us, do not compare your Rajya Sabha and legislative council is. Rajya Sabha has similar powers and positions as your Lok Sabha in respect to ordinary bills. But your legislative council does not have equal power even with regarding to your ordinary bills. By and max, it is said that your legislative council has the power to delay a bill for 4 months. So which means you can't even technically call it a full-fledged revisionary body. So then this is one of the most, let's say, your disadvantages or issues or criticisms that your legislative council receives is, it is a white elephant. It is an unnecessary body. It is just delaying decisions. It is just too costly to maintain the affair. This objective is more political than your need of the constitutional matters. All these criticisms are seen for legislative council. So your ordinary bill can originate in either of the house, okay, but if a disagreement happens, first thing is your council can delay a bill for the first time by 3 months. Let's say Legislative Assembly introduces a bill, passes it, sends it to Legislative Council. Legislative Council returns for reconsideration, or in this particular period of time, it has 3 months. Understanding? Now, again, the legislative will pass the assembly with either considering the changes to be made by Legislative Council suggested or not. Let's assume Legislative Assembly did not make the changes, it sent it back. Now, for the second bill, the Legislative Council has 1 month of time. It has to sign that bill or take action on that bill within 1 month, otherwise it is considered passed. So, by and max, what it can do is delay the bill by 4 months. Understanding? And there is no provision of joint sitting in case of deadlock arising. It obviously the bill is either way getting passed, even in an ordinary bill itself, whether your legislative council agrees or not. So there is no need for a joint sitting. Understanding? Because your assembly has overriding power on council even on ordinary bills. And money bills though, we know when ordinary bills only, this is the situation. What is the money bill? They cannot reject or return, they can only suggest recommendations. And it can be introduced only in legislative assembly on governor's recommendation. The governor also cannot return the money bill. And the council, by and max, it has 14 days to suggest recommendation. In that, legislative council can either accept or reject all the recommendations. Understanding? Next, with regarding to your position of legislative council with regard to legislative assembly, equal powers or equal-ish powers we can tell, because this is not the same like your Lok Sabha, Rajya Sabha equal powers. Ordinary bills can be introduced, ordinances can be discussed, ministers can be from either house, okay, but your no confidence motion, all this can only be from your legislative assembly and not your council. Unequal areas, again, they cannot introduce money bill, they cannot reject money bill, they cannot even in fact reject ordinary bill for that matter. By and max, they have 14 days, they can delay a money bill, and an ordinary bill they can delay it for 4 months, and they cannot demand for grant, and no confidence motion can be passed only in legislative assembly. Irrespective of the fact where the ministers are from, in a bicameral legislature, all of them are responsible to your legislative assembly only. Then the entire existence of legislative council is dependent on your legislative assembly under your article 169. Next, we will see the topic of parliamentary committees. Parliamentary committees, there are two types of parliamentary committees: standing parliamentary committees, ad hoc parliamentary committees. Standing parliamentary committees are more permanent in nature, ad hoc are temporary. They come in only for that particular issue and disbanded after that issue is resolved. Look at this. Under standing committees, we have 6 components, but most important one that we will be referring from your prelims perspective is a financial committee, under which we have public account committee, estimate committee, and committee on public undertakings. We also have departmentally related standing committees, which are 24 in number, and we also have committees to inquire on your petitions, privileges, ethics committee. So ad hoc committees are temporary ones, they will be inquiring into particular issues. First and foremost, let's look into public account committee. Your public account committee concept originated in 1921, your Government of India Act 1919. There will be in total 22 members in your public account committee. These numbers you have to by heart. They can ask you in statement kind of questions, where 15 are from Lok Sabha and 7 are from Rajya Sabha members. And how is the election means? It is through proportional representation, single transferable vote. They hold the term for 1 year. Ministers cannot be member of public account committee. Okay. And one more important thing, if you see about your public account committee, means the chairman is appointed by the speaker, and also the chairman, especially from 1967 as a convention, is from your opposition. Understanding? What exactly is this PSC doing? This will examine all the comptroller and auditor general audits which are laid in front of the parliament. It will see appropriation account, finance account, public undertakings account. It is to see whether legality is there and also economic prudence is there. First and foremost, it will try to see what is the amount that is sanctioned by parliament, what is the spending of the government. Okay. And also they are one most important keyword you have to see is legality as well as propriety. Whether the money spent, is it going to proper ways or is it in a wasteful manner? Understanding? So this will detect waste, loss, corruption, inefficiency. This becomes a very important committee where your CAG becomes your friend, philosopher, guide for this particular committee. Understanding? Now, with all parliamentary committees, the disadvantages are very similar only. What is it? First and foremost, it is like conducting a post-mortem. That is, after the money is given, they have spent, this is being discussed. And also, this is not just policy focused as to whether you're only seeing the financial aspect of the policy. You're not seeing whether the policy itself is correct or not. Then, no day-to-day administration, and the recommendations are merely advisory in nature and not binding on the government. And also they cannot disallow expenditure. Understanding? They can by max tell that the money spent like this so and so has been wasted like this. That's it. Next is your estimates committee. Okay. Estimates committee was set up in 1950 by the recommendation of your John Mathai. This is one specific aspect of your estimates committee. If you see, all the members are from Lok Sabha only. Highest members are there here only, that is 30 members, only Lok Sabha. No Rajya Sabha members. Again, election is through your proportional representation, single transferable vote. The term is for 1 year. Ministers are not allowed to be members of this parliamentary committee. The chairman, okay, will be appointed by the speaker and usually it will be from ruling party. The public account committee, I told you, it will be from opposition. Here it will be from ruling party. One of the way, if you see your estimates committee, it is more like you gather support for your government policies and interventions. Okay, so it examines budgets, estimates, and suggests any economic changes that we want. So it is more like a continuous economy committee. It will try to gather the support. Understanding? And it suggests economics, administrative reforms, and alternative policies. But again, if you see, there are various limitations in your estimates committee also. Your CAG does not come as a friend, philosopher, guide to assist estimates committee, and the examination is done after all the things are voted, demand for grants, everything. So it is not done before, and also it cannot question the policy itself, and the recommendations given by the committee is only advisory in nature. It is not binding on the government, and also they will be taking up particular topics in rotation per year. They will select few ministries and only those topics they will be taking up, not holistically. And again, this is also post-mortem in nature, that is after everything is done. Here, next, Committee on Public Undertakings. This Committee on Public Undertakings was created in 1964 by the recommendation of Krishna Menon Committee. It has 22 members, 15 members will be from Lok Sabha and 7 from Rajya Sabha. Election is through proportional representation, single transferable vote, term is for 1 year, no minister will be a member of this committee. The chairman is appointed from the speaker and only by in the Lok Sabha, which means even though this has members, see, estimates committee has members only from Lok Sabha, so chairman will be only from Lok Sabha. But here in Committee on Public Undertakings, it has members from both Lok Sabha plus Rajya Sabha, but chairman will only be from Lok Sabha and will be appointed by speaker only. Understanding? So Rajya Sabha members cannot become the chairman. So what are its functions? Again, it will examine reports, audits of your public sector undertakings, and it will also see CAG reports only with regarding to your public sector undertakings. One important thing is they will see whether this PSUs are managed with sound business principles and prudent commercial practices. Same thing, limitations like we saw the previous ones. They can examine only limited PSUs per year. Again, they can't take up all of those because bulky in nature. And it is again post-mortem, that is after everything is done. Recommendations are only advisory in nature, not binding. and also they do not have technical expertise which is needed for that particular PSU. Okay, so this is also merely advisory in nature. Next, we will be seeing is departmental related standing committees. Now, this was introduced in 1993. When it was introduced, there was 17 committees, but as of now, we have 24 of these committees. What are the objective of this? If you see, means it is to gain more executive accountability and also better budget scrutinies to happen. Now, in each departmentally related standing committee, there will be 31 members, 21 will be from Lok Sabha, 10 will be from Rajya Sabha. The members will be nominated by the speakers and chairman of the respective house. Again, ministers will not be eligible. Your term is 1 year. Of this, 16 are under your Lok Sabha, 8 are under your Rajya Sabha. What are its core functions? It will examine the demand for grants before voting. It also will examine the bills for your particular related ministries which are referred to it, and they also consider annual reports. Understanding? It is more like a long-term policy document determination. The next type of committees is your day-to-day business committee. One such is your business advisory committee or BAC. What does this particular committee do? Means it is the one that will be allocating time and timetable for the house. Okay, in Lok Sabha there are 15 members. The chairman of your business advisory committee in Lok Sabha is the speaker. In Rajya Sabha it is 11 members. The chairman of your business advisory committee in your Rajya Sabha is the chairman. Next is rules committee, which will be looking into the procedures or rules or any changes which are needed to be done for the respective house. In Lok Sabha, it has 15 members. It is presided by the speaker of Lok Sabha as the chairman. And in Rajya Sabha, it is 16 members and it is presided over by the chairman of Rajya Sabha as the chairman of this committee. At last is your housekeeping or service committee, that is your general purpose committee, which means topics which are not covered elsewhere in any of the committees will be covered here. Okay, so this will be having a broad composition of what are to be done with regarding to certain specific, okay, like with regarding to presiding officers, deputies, panels, okay, these aspects are there with respect to your housekeeping or service committees. So it started with this particular topic. Which one of the following statements about ethics committee in Lok Sabha are correct? Initially, it was an ad hoc committee, correct? Only a member of Lok Sabha can make complaint relating to unethical conduct of member. Not only a member, it can also take up suo motu actions. So the statement is wrong. This committee cannot take up any matters which is under sub judice. This is correct. So which means correct options are 1 and 3 only. With this, we come to the end of the content. If you like our content, subscribe to our channel, hit the like button, share it along with your friends. Thank you. Hello folks, welcome to Legacy IAS Academy. In this video, we will be coming up with another interesting series in your Polity Prelims Marathon, where we will be discussing about your Supreme Court, High Court, Subordinate Court and Tribunals. So basically, we will be discussing the judicial aspects. Alright. Now, first and foremost topic that we will be discussing is, we'll start off with your Supreme Court. First and foremost, what type of judiciary is Indian judiciary? Indian judiciary is both an independent and integrated judiciary. Now, here I will be using few words, okay? Integrated judiciary means we have a chain of command or hierarchy, wherein let's say Supreme Court, High Court, your district courts or subordinate courts, all of them are bound by the law. For example, if Supreme Court passes a law that is valid on High Court and that is on your district court, and also they can make laws on both center as well as state laws. So when I tell Indian judiciary is integrated, we will take what other kind of judiciary there could be. For example, your US judiciary. US judiciary is a federal judiciary. Yes, your Supreme Court will deal with the topics of center and your high courts will deal with that of the state. Yes, federal courts. So, Indian judiciary is integrated and independent. Independent as in its powers, functions, salary, tenure, all of this is given to them independently by your constitution. Now you can tell salary is given by constitution, which means it is charged on the consolidated fund of India. Understanding? And also your powers, functions, and when I tell your concept of tenure, that just means that they cannot be arbitrarily removed by the executive. They can be only removed on the ground specified in the constitution: proved misbehavior or incapacity. Understanding? So this makes them independent. So India's judicial system is both integrated as well as independent. Now, when we will be discussing fundamental rights, we would have discussed something about Article 21. Yes, Article 21 is right to life with and personal liberty. There we would have discussed two aspects with regarding to your procedure established by law and due process of law. Now, through this due process of law, understanding, the term procedure established by law is mentioned in the constitution, whereas your due process by law is not mentioned in the constitution. But your Indian judiciary has started integrating, especially post your 1978, especially after your Menka Gandhi case. Your judiciary goes for your protection of people, that is, let's say, from not just arbitrary actions of the executive, but also arbitrary actions of the legislature. Now, quite contrarily, if we see your AK Gopalan case of 1950, where the Supreme Court went for a narrow interpretation of Article 21, you can protect, or protection can be given only against arbitrary executive action and not legislative action. This changed in your Menka Gandhi case, wherein they said arbitrary actions, that is, protection will be given against both your arbitrary action of legislature as well as your executive. So, through this concept, why am I explaining Article 21 here? Because through due process of law, they started bringing in concepts such as fair, just, reasonable law, and also this coupled with your Article 13, your judicial review became stronger. Understanding, your judicial review as a concept started becoming more stronger, and it started changing the course of the way judiciary started viewing things. Now, all this is mentioned. Is the term judicial review mentioned anywhere in the constitution? For that matter, I'll tell you one small thing. We started comparing Indian judiciary with US judiciary. The concept of judicial review was taken from your US judiciary, but at the same point of time, neither Indian constitution or your US constitution does not mention the term judicial review. Okay. We also have a unified judiciary. We follow single system of laws, which means both central and state laws are enforced by the same judiciary. The source of it is from your Government of India Act of 1935. US is dual judiciary, that is federal and your state, whereas India is integrated judiciary. Now look at this. What are the constitutional establishments? Your judiciary comes under Supreme Court, here specifically comes under Part 5 of the Constitution, Articles 124 to 147. You don't have to by heart all the articles. Important ones I will tell you, those you have to by heart. Now, with respect to your presidential reference, complete justice, original jurisdiction, special leave petition, these kind of things, I'll tell you eventually. So, your judiciary, that is more specifically, your Supreme Court was inaugurated 28th January 1950. This Supreme Court was succeeded by your Federal Court 1937. It had replaced your Apex, the appeal of British Privy Council. What is the composition of Supreme Court? See, first and foremost, the total number of judges as of now in present for your Supreme Court is, there will be one Chief Justice of India and 33 judges. Total composition is 34. And also this was increased through a notification, that is through your Supreme Court Number of Judges Amendment Act of 2019. Originally, when we started out in 1950, we had 8 total judges of Supreme Court, 1 Chief Justice of India and 7 Supreme Court judges. Now, look at this. Appointment process of your Supreme Court judges. One thing is, the judges of Supreme Court and High Court are appointed by the President of India according to Article 124. Now, how the appointment will happen? Initially, here is where we will be introducing these concepts called as first judge's case, second judge's case and third judge's case. So what happened? First and foremost, in the first judge's case, there was this question: is consultation equal to concurrence? In Constitution, there is a provision that tells that President of India will appoint the judges based on the recommendations of your Chief Justice of India. Now, first and foremost, how will you appoint the Chief Justice of India? See, eventually over the years, we have come to an understanding that yes, the senior most judge will be appointed as the Chief Justice of India, but there are many times, for example, where this provision has not been followed, largely during your 1970s period, where Justice Beg, Justice Ray, these people have all superseded, or this norm was broken. So now what happened? The overall procedure, if you see, as of present, if you have to be appointed as the Chief Justice of India, the provision is senior most judge of Supreme Court will be appointed as the Chief Justice of India. Now, for the appointment of your Supreme Court and High Court judges, you have to consult your Chief Justice of India and other judges of Supreme Court. Understanding this is the norm. In the first judge's case, when they asked, when President is appointing, does that mean this consultation with Chief Justice of India, is it binding? Initially, they said that no, consultation does not mean concurrence, which means it is only recommendatory in nature, not binding. So the first judge's case in 1982, they held that no, concurrence is not your consultation. Second judge's case in 1993, they held that no, the consultation means concurrence, which means the advice tendered, that is, while appointing the judges of your Supreme Court, the decision of Chief Justice of India is binding on the President. And at the same point of time, your Chief Justice of India should also consult two other senior most members of your Supreme Court. Understanding? So here what happened, the concept of collegium system was introduced. So when we said in the first judge's case consultation is not equal to concurrence, the power of your judiciary appointments pay was given to your executive. Now in the second judge's case, when we held that no, the decision, what is that, your recommendations of Chief Justice of India is binding on the President, then we brought back the control from your executive back to judiciary. Understanding? But here also bias could be witnessed. So finally, third judge's case was introduced in 1998, which was based on the concept of plurality, which means here also consultation means concurrence, and the Chief Justice of India alone will not be taking the decision. He will be consulting four other senior most judges. Even if any two senior most judges tells no to a particular name, then that particular name should not be proceeded. So this again reiterated the appointment process in the hands of judiciary. Independence was there, and at the same point of time a sense of plurality was also there, but there was also your disadvantages. What are the disadvantages? On what basis these names are considered? Understanding? It was more of an opaque system. So the collegium system and its attributed feature of opaqueness continued still date. So what happened? This is when your NJSC was proposed. Look at this. Now, when I say NJSC was proposed, this was again, like I told you, collegium system is very opaque. So, your NJSC was proposed by your executives, that is, a constitutional amendment bill was passed for the appointments of judiciary. Now, it was introduced as the 99th Constitutional Amendment Act of 2014. This became nothing but your NJSC Act. Judiciary struck down NJSC Act as well as 99th Constitutional Amendment, stating that it violated the basic structure. How does it violate the basic structure? Because it affects the independence of judiciary, and independence of judiciary is part of a basic structure. Understanding why did judiciary strike down NJSC is because of there was a lot of executive interference in the judicial appointments. Understanding. So, your fourth judge's case became your NJSC. So, by convention, Chief Justice of India is going to be the senior most judge of your Supreme Court. But there has been instances where I have told you earlier, this particular norm was broken. 1973, when Justice A.N. Ray superseded three senior judges, and 1977, when Justice M.U. Beg superseded the senior most judge. So finally, in the second judge's case, they held that no, only the senior most judge of Supreme Court should be made the Chief Justice of India. Okay. Now, look at this. So, we saw how your NJSC was removed by your judiciary or struck down by your judiciary, and this became your fourth judge's case. Next, let's see the qualifications to become a judge of Supreme Court. Qualifications are mentioned in Article 124, according to which you have to be a citizen of India, and one important thing is no minimum age is mentioned to become a judge of Supreme Court. Okay, but rather your qualifications are you should have been a High Court judge for 5 years, or a High Court advocate for 10 years, or there is third most important condition. You have to remember this from prelims perspective is because the third provision is there only for your Supreme Court judge and not for your High Court judge. Understanding what is that? You have to be, see, all these are ors, High Court judge for 5 years, or High Court advocate for 10 years, or you have to be a distinguished jurist in the eyes of a president. Understanding this, just distinguished jurist is there only in Supreme Court judge, not for High Court judge. And there is no minimum age mentioned in Constitution to become a judge of Supreme Court. Now, what is the tenure and removal? The term of office for your judiciary is up to 65 years. Now, you can resign, or that is, let's say, a judge of Supreme Court wants to resign, then he has to write to President of India. Understand one important provision, not Chief Justice of India, but to the President of India. And one more attribute, when we started, we told independent, judiciary is independent, is because they have security of tenure. You cannot remove a Supreme Court judge on arbitrary grounds, which means the removal or the way of removal for a Supreme Court judge is mentioned, either for Supreme Court or High Court. The procedure is mentioned in the Constitution, the grounds, understanding? The grounds for removal of a Supreme Court or High Court judge is mentioned in the Constitution. What are the grounds for removal of a Supreme Court or High Court judge? It is proved misbehavior or incapacity. Okay. How is the procedure happening? Means, let's say, a motion will be passed in Parliament, either house of the Parliament, 100 members by Lok Sabha or 50 members by Rajya Sabha. Okay, what is this motion? To tell that shall we take impeachment of a judge. This is called impeachment process, removal of a judge. So a motion has to be introduced either in Lok Sabha by 100 members or in Rajya Sabha by 50 members. Now this particular motion can be either accepted or rejected by the presiding officer. Let's say the speaker can reject it or he can accept it. Now let's say the speaker accepts it. If the speaker accepts it, then a committee has to be formed. The committee will comprise of, this is very important, either the Chief Justice of Supreme Court or any judge of Supreme Court, first one. Second member will be Chief Justice of the concerned High Court. And third person will be a distinguished jurist. So only these three members will be part of this committee. Okay. Then committee will give its proceedings. Then they will take up for voting. That is, in this removal of judges comes in a very higher priority. So you can have that is, each house separately has to pass it to special majority, 2/3 of members present and voting. When both houses passes, then okay, you can remove the judge. It is seen here according to your Judges Enquiry Act of 1968, the impeachment procedure. So this is for the removal of your Supreme Court and High Court judge. Now when we tell independent or they have security of tenure, which means you can only remove them on the grounds which are mentioned in the Constitution. Now we will see some other more things with regarding to your acting Chief Justice of India, ad hoc judge and retired judge. Okay, look at this. Who can become an acting Chief Justice of India and who appoints? First and foremost, when the office of Chief Justice of India falls vacant either permanently or temporarily, then your president appoints an acting Chief Justice of India. Okay, that is your acting Chief Justice of India. Ad hoc judge. See, ad hoc means temporary. Let's say for a particular case, you have to have so many judges. Let's say for a constitutional case, it is like at least 5 members have to listen to this. Okay, 5 judge bench should be there. So when there is lack of quorum or lack of judges which is needed for that particular case of hearing, then the Chief Justice of India will appoint a High Court judge as an ad hoc judge. Understanding? Now, while your Chief Justice of India will appoint an ad hoc High Court judge for short period of term to function as a Supreme Court judge, then he has to do it with prior precedent consent, and also he has to take the permission of the concerned High Court, your Chief Justice. Understanding? Understand this clearly. Acting Chief Justice of India means when the position or office of Chief Justice of India falls vacant, President of India appoints someone temporarily as an acting Chief Justice. Now, ad hoc judge, when there is lack of minimum quorum or number of judges which are needed for a case is not available, means that point of time, Chief Justice of India will appoint a High Court judge for a short or temporary period of time to act as your Supreme Court judge. This Chief Justice of India can only do it with the prior permission of President, and also the judge from where which High Court he is taking that particular High Court ka Chief Justice permission. Right? So he has to consult them. This is your ad hoc Supreme Court judge. Next is your retired judge. Now, retired judge means the Chief Justice of India will request the Supreme Court and High Court judges who are already retired. For what? In order to make sure that, okay, as of now the caseload is higher, we need you to come back and work. This is not a permanent employment, but just for a short period of time. To do this also, he needs prior precedent, permission and the consent of the judge involved. Okay, and this is not to be considered like a permanent position. Now let's see with regarding to seat of your Supreme Court. Seat of the Supreme Court is in New Delhi. If we want to increase more than one seat for Supreme Court, then Chief Justice of India can increase the number of seats of your Supreme Court, but with your President approval. So with regarding to your Supreme Court rules, it is with your president approval. And also one more important thing is with respect to your constitutional cases, any presidential references made or any constitutional cases they are going to listen means at least minimum it should have a 5-judge bench. Now, we will see about jurisdictions of your Supreme Court. In which and all scenarios does your Supreme Court has original jurisdiction? Your Supreme Court has original jurisdiction in your center state conflict, or your center state on one side and other states on one side, or states and state conflict. All this is your original and exclusive jurisdiction of your Supreme Court, and they can only be original and exclusive jurisdiction as long as a legal right is involved, that is they are fighting over some legality issue, not political issue. Understanding? And what things is not coming under original exclusive jurisdiction of Supreme Court means your pre-constitutional treaties, okay, and also your treaties which are excluding, specifically excluding Supreme Court jurisdiction, interstate water disputes, the finance commission matters, right? These are outside the purview of original exclusive jurisdiction of Supreme Court. Look at this. Next is writ jurisdiction of Supreme Court. First and foremost, what are your writs? Writs are the ways where your judiciary will exercise, specifically Supreme Court will exercise to safeguard your fundamental rights. What are the types of writs? Your habeas corpus, mandamus, prohibition, certiorari, quo warranto. Yes, we have discussed what these are in your fundamental rights. So your writ jurisdiction, if you see, the writ jurisdiction of Supreme Court is quite narrower compared to that of High Court, because High Court has a wider writ jurisdiction. What does that mean? Supreme Court can use writs only in case of your fundamental right violation, whereas High Court can invoke writ jurisdiction for not just fundamental right violation cases but also other cases. Understanding? So, according to Article 32, the writs Supreme Court can utilize is only for fundamental right violation, but whereas your High Court can issue writs for fundamental rights plus other purposes. Now, writ jurisdiction with respect to Supreme Court is not exclusive. It is concurrent with your High Court powers. So, exclusive term cannot be used for writ jurisdiction and Supreme Court. Next, if we see jurisdictions पे appellate jurisdiction. Appellate jurisdiction means the order by appeals. The cases in our country, now let's say if your fundamental right is violated. If your fundamental right is violated, then you have a provision according to Article 32, that is right to constitutional remedies. You can directly go approach Supreme Court or High Court. But the other cases cannot go that way, which means what? Every single particular case has to go through a chain of command. It has to come from lower court to the higher court. Understanding? Through way of appeals. That is your appellate jurisdiction. Now, there are certain provisions where if you have to appeal to higher court, just because you don't like an order, you cannot keep appealing to higher court. There has to be a substantial question. Now, let's say you have gone to your high court. High Court has given you the verdict. Now, just because you don't like that doesn't mean you will keep on appealing to higher court and waste the entire court's time. So, if your particular case has an issue or a question of law, or let's assume that the evidence was not seen properly, understanding, or there is a overall constitutional question of law involved, only on certain conditions can you appeal to the higher courts. So, in appellate jurisdiction, if it is a constitutional case, let's assume, a high court certificate is needed to tell that in this particular case, there is a substantial constitutional question involved, so which is why we need you to take it up. Understanding? Now let's say with respect to your civil cases. Again, if you have to appeal to higher court, you need a high court certificate stating that in this particular case there is a substantial question of law involved, and that means your Supreme Court's decision, because it impacts a lot of members. Earlier they said that it has to be above a particular limit, but your 30th Constitutional Amendment Act removed this. Next, if it is a criminal case and you have to appeal to your higher court, at that point of time, if in case death sentence is pronounced, then you can appeal. Or let's say if there is a reversal of acquittal, or high court is taking a particular case and acquitting more than a particular number of years. Okay, so on certain grounds only there is appeals. This is appellate jurisdiction. Next important one is your special leave petition. Look at this. Special leave petition is a very important aspect, which is a discretionary, wide scope and very sparingly used by Supreme Court. It does not use it at any point of time it wants, and it cannot be used against your military tribunal or court martial, but it can be used in any other courts or tribunals. Okay, and one more important aspect is your advisory jurisdiction. Here is where I want you to keep an important tab on, because there was also a huge amount of presidential references involved in current affairs with regarding to time limit set by the judiciary for governor to sign the bills. So based on that, your president had asked a question to your judiciary, that is called as presidential reference. Now your president can ask a question or seek opinion from judiciary on two types: on any aspect with relating to your constitution, treaties, covenants. In these kind of issues, Supreme Court must give an answer. Let's say when your president seeks opinion with regarding to any law or facts which are important to public importance, Supreme Court may or may not give an opinion. But whatever opinion given by your judiciary, it is only advisory in nature and not binding on the president. Next is court of record, according to your Article 29. First and foremost, with regarding with the aspect of court of record, these serve as records which are of evidential value, and these set a precedent for upcoming cases. Understanding? Your 1991 Supreme Court held that we have the power to punish for contempt of court, which means if your intention is to throw malice or disregard the institution, judges, etc., then you have, the judiciary has the power to punish for contempt of court. In 1991, judiciary held that contempt of court of judiciary, Supreme Court, means it can also punish for contempt of not just Supreme Court, contempt of High Court, contempt of your subordinate courts, and contempt of your tribunals. So we can punish for all of these things. Okay, and with regarding to your original jurisdictions pay, with regarding to disputes with aspect of your presidential elections or vice president, then the final deciding, that is with respect to the elections disputes in the president and vice president, the final exclusive original jurisdiction rests with your Supreme Court. Understanding? And also when your cases have been referred with respect to, let's say, removal of your UPSC chairman or members, if an inquiry committee is done, your Supreme Court payments, then that decision is also binding on your president. Next, with regarding to the advocates which have been recognized as to three categories in Supreme Court. One is senior advocate, next is advocate on record, next is other advocates. Now when you call someone as a senior advocate, they are the ones who are designated by Supreme Court or High Court, which means they cannot appear without advocate on record. and they will also be not doing the drafting, pleading, all those things. The advocate on record is the only person who can file for documents or matters in front of Supreme Court. There are also other advocates who can argue if they have been enrolled in the State Bar Council, and they cannot file in your advocate of records. Okay. Now I told you I will be discussing also some important articles with regarding to your judiciary, Supreme Court. Look at this. Article 130, which is seat of Supreme Court, which is in Delhi. Who can increase this seat of Supreme Court? Chief Justice of India with the President's approval, not the other way around. Next is Article 131, original jurisdiction of Supreme Court. Article 136 is special leave petition. Article 142 is complete justice, which has been, again, this becomes important from current affairs perspective, because for your Tamil Nadu governor ka bill's case, your judiciary invoked Article 142 of complete justice and it passed the bills, understanding that even though the bills were being kept on delayed by the governor, the judiciary told that the time that the second time the house passed, from that day those bills are considered passed. So to do that, it invoked Article 142. Next is Article 143, which is your presidential reference or advisory jurisdiction. Article 32 is right to constitutional remedies. Article 226 is with respect to your High Court jurisdiction. And Article 50, this is where your DPSP of separation of judiciary from executive. Okay. Now, let's look into possible prelims question. Like I always tell in your marathon series, I will teach the content half through the static topics and half through your PYQs. Okay, look at this. Under which of the following articles of the Constitution of India has Supreme Court of India placed the right to privacy? In simple sense, right to privacy is under which article? Article 15, Article 16, Article 19, Article 21. Correct option is Article 21, which is right to life and personal liberty. Next question. A writ of prohibition is an order issued by the Supreme Court or High Court to. So you issue prohibition to whom? A government officer prohibiting him from taking a particular action? No. The parliament or legislative assembly to pass a law on prohibition. Why will they tell this? No. The lower court prohibiting continuation of proceedings in a case. Yes. Prohibition is issued to your lower courts in order to prohibit them from taking up that particular case. Maybe they will be exceeding the jurisdiction. Yes. So this is only preventive in nature. Then comes one more writ, that is certiorari, which is you don't take up the case, but rather I will take up the case, which is both preventive as well as curative. Prohibition is only preventive in nature, as in you are only prohibiting, you are not providing any cure. The government prohibits it from allowing from following an unconstitutional policy. No. So the correct answer is C. Next, in India, which of the following constitutional amendment was widely believed to be enacted to overcome the judicial interpretation of fundamental rights? First Amendment, 42nd Amendment, 44th Amendment, 86th Amendment. The correct answer is First Amendment. This is where they brought in the concept of your ninth schedule. They kept the laws, okay, which will be outside the jurisdiction of your judiciary. That is where things changed in IR Coelho case, where they said from 1973 it is fine, but after that we will put them through your Golden Trinity test, understanding. So these changes were seen. Next, consider the following statements. The Supreme Court of India, okay, has held in some judgments that reservation policies made under Article 16 of 4 of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. In simpler sense, your 16 of 4 speaks. In 16, it is more about your public employment. In that 16 of 1, 2, 3, 4 and all, what do we see means exceptions, reservations for SC, ST, OBC. Yes. Now 335 means in order to make sure you will have a efficiency in administration, something about promotions. See, what we are trying to tell by this particular statement is reservation is also there and also promotions is there, but at the same point of time, the reservation should not compromise the efficiency of the administration. Understanding? Article 335 of the Constitution of India defines the term efficiency of administration. See, it is constitution we are talking about. The concept of constitution defining certain term is highly unlikely. So, the efficiency of administration term is not defined in constitution under 335. So, statement 1 is correct, statement 2 is wrong. So, correct answer is C. Look at this question. With reference to the writs issued by the courts in India, consider the following statements. Okay. Mandamus will not lie against private organization until it is entrusted with a public duty. See, the word mandamus stands for we command. Okay. So, we command applies to only your public officials or public organization, not to private organization unless and until they have been given a public duty. So, this statement is correct. Next, mandamus will not lie against a company even though it may be a government company. No, I told we command is for anything which is a public entity. Your government companies are public entities, so will not lie will become wrong. It will lie for your government company. Second statement is wrong. Next, any public minded person can be a petitioner to move the court to obtain the writ of quo warranto. What is quo warranto? Under whose warrant and authority? Under whose authority and seal have you created this particular government office or government position? So, this question can be raised by any public minded person. So, this statement is correct. The correct options are 1 and 3 only. Next question. With reference to India, consider the following statements. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from the recognition of advocates. Why will corporate lawyers be not recognized as advocates? They are lawyers who are dealing with corporate law. Yes. So that does not mean that they will not be recognized as advocates. So this statement is wrong. Yeah, next. Bar councils have the power to lay down the rules relating to legal education and recognition of law colleges. This is correct. So, the correct answer is 2 only. Consider the following statements. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. True, this was based on your H.N. Sanyal Committee. The Contempt of Court Act was passed. Next, the Constitution of India empowers Supreme Court and the High Court to punish for contempt of themselves. Yes, they can punish for contempt of court. Next. The Constitution of India defines civil contempt and criminal contempt. No constitution has not defined. Again, whenever this particular terminology comes, defines, be very careful because constitution will not define it anything that easily. So this statement is wrong. It has not defined anything as civil contempt and criminal contempt. Next, in India, Parliament is vested with the power to make laws on contempt of court. This itself proves that Contempt of Court Act, who can make an act? It is Parliament. So this statement is correct. Correct options are 1, 2 and 4 only. Now, look at this question. With reference to India, consider the following statements. Judicial custody means an accused is in the custody of the concerned magistrate and such accused is locked up in police station, not in jail. Now look at this, judicial custody. Judicial custody means he will be locked up in jail and not police station. But if I tell police custody, then he will be locked up in police station, not in jail. It is reverse. If it was police custody, this statement is wrong. If it is judicial custody, this has to be in jail. So this statement is wrong. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. This is correct. Correct option is 2 only. Next, look at this question. With reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. See, up until here, prisoner makes out a sufficient case, parole cannot be denied. See, parole cannot be denied means there are certain grounds for denial. Let's say if there is a public risk involved, okay, and one more aspect is matter of his or her right. Parole is not a matter of his or her right. So this statement is wrong. Look at the next statement. State governments have their own prisoners release on parole rules. True, state governments have their own rules with regarding to parole. The correct option is 2 only. Next question. With reference to Indian judiciary, consider the following statements. Any retired judge of Supreme Court of India can be called back to sit and act as Supreme Court judge by the Chief Justice of India with prior permission of the President. This we discussed. Yes, with respect to the retired judge, this statement is correct. Next statement. A High Court in India has the power to review its own judgment as the Supreme Court does. No, it does not have the power to review its own judgment like the Supreme Court does. So the correct option is A, 1 only. Next question. In India, separation of judiciary from executive is enjoined by which one? Otherwise, we are talking about which particular place where have we spoken about separation of executive and judiciary. In the important articles list I told you in the last article 50. Article 50 is nothing but your DPSP. So preamble, DPSP, 7th schedule, conventional practice. Correct answer is DPSP. 7th schedule is your lists, union list, state list, concurrent list. Why will that be involved here? Next, look at this question. Consider the following statements. The motion to impeach a judge of Supreme Court of India cannot be rejected by the Speaker of Lok Sabha as per Judges Enquiry Act. Why cannot be rejected by the Speaker? When I was explaining, I told you, your, let's say, motion has to be introduced. Lok Sabha either 100 members has to sign, Rajya Sabha either 50 members have to sign and they have to introduce it. The speaker has the right to either accept it or reject it. There is no thing as cannot be rejected. So this is wrong. Okay. The Constitution of India defines and gives details as to what constitutes incapacity and proved misbehavior of the judges of Supreme Court. Again, do you see the same pattern here? Defines. Will Constitution define things? No, it mentions. We have seen earlier also. Proved misbehavior, incapacity term is there. It has not been defined. So this statement is also wrong. Next, the details of the process of impeachment of the judges of the Supreme Court of India are given in the Judges Enquiry Act of 1968. This is correct. We have discussed it in the earlier portions. If the motion for impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of total membership of the house and by not less than two-thirds of members of the house present and voting. Yes, that is special majority is needed to be passed by each house. So this by after this only a judge is called to be impeached. As of now in India there has been no judge who has been impeached. The correct options are 3 and 4 only. Look at this question. Consider the following statements. The 44th Amendment of the Constitution introduced an article placing the election of Prime Minister beyond judicial review. No, it was not 44th Amendment, it was 39th Amendment. So this statement is wrong. The Supreme Court of India struck down the 99th Amendment of the Constitution of India as being violative of independence of judiciary. What is your 99th Constitutional Amendment? Nothing but your NJAC, or what we called as fourth judge's case. Right? Yes, it did strike it down because it was violative of your independence of judiciary, which is a basic structure doctrine. So it did strike this down. The correct option is 2 only. Look at this question. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following? The decisions taken by Election Commission of India while discharging their duties cannot be challenged in any court of law. See, ordinary law cannot act as prohibition or limitation on the constitution of powers under Article 142. Why is your Election Commission coming under this? Next, the Supreme Court of India is not constrained in the exercise of its powers by the laws made by the Parliament. In simpler sense, how am I able to exercise my complete justice? For complete justice, we don't need your Election Commission ka topics here. Okay, so this is the correct option. I am not obligated by any particular law which is made by the Parliament. Next, in the event of grave financial crisis in the country, the President of India can declare financial emergency without counsel from cabinet. See, grave financial crisis, fine. President of India declare financial emergency, fine. But without the counsel from the cabinet, no, they can only do it with the aid and advice of COM. Last option. State legislatures cannot make laws on certain matters without the concurrence of the union legislature. Why do they need concurrence of union legislature for this? भैया मैं अभी बात कर रही हूँ माइक से इससे ही बात कर रही हूँ कनेक्ट हो गया ना आप मेरी वीडियो को इंटरफेयर कर दिया पे हो रही है, मैंने चेक किया। हाँ, शो मैंने फिर कट करना है भैया। भी आप थोड़ा देर के लिए छोड़ दीजिए ना। State legislatures cannot make laws on certain matters without the concurrence of union legislature. Why can't they make laws without asking your union legislature? No, this statement is wrong. Next, look at this question. With reference to Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Why is that? There is no such thing as, we are an integrated judiciary, not a federal judiciary like your USA. So this statement is wrong. An amendment to the Constitution of India cannot be called into a question by Supreme Court of India. No, see, in according to Article 13, what is Article 13 means, here we are defining what is a law, definition of a law, and Article 13 is also judicial review. So we are telling, if judiciary can exercise judicial review, it is on a law. So the question came in as to, is constitutional amendment a law? The answer was no, constitutional amendment is not a law, but judicial review is subject to your constitutional amendment, which means constitutional amendment is subject to your judicial review. So which means amendment to constitution can be questioned by the Supreme Court. So here neither 1 nor 2 are the correct answer. Next, in India, judicial review implies which of the following? The power of judiciary to pronounce upon the constitutionality of laws and executive orders. Pronounce the constitutionality, whether are they violative of constitution or not. So this is correct. The power of judiciary to question the wisdom of the laws enacted by the legislature. No, why will they question the wisdom of the laws? Next, the power of judiciary to review all the legislative enactments before they are assented to by the president. No, it is only after the assent, okay, not before. Next, the power of the judiciary to review its own judgments given earlier in similar or different cases. No, that is not what your judicial review is. Okay, they have their own set of court of records. The correct option is A, power of judiciary to pronounce upon constitutionality of laws. Next, who or which of the following is the custodian of the Constitution of India? President of India, Prime Minister of India, Lok Sabha Secretariat, Supreme Court of India. Correct option is Supreme Court of India. Okay, so these are the questions with regarding to your Supreme Court. Next, we'll start with your High Court. So we finished Supreme Court. Now let's start with High Court. See, High Courts come under Part 6 of the Constitution. Okay, they are from your Articles 214 to 231. Article 214 speaks about the fact that there will be a High Court for each state, and your High Court can be shared by states. For example, your Punjab and Haryana share a High Court in Chandigarh. The northeastern states share High Court, and also High Court is the highest level of court in the state. As of now, we have 25 High Courts, and only Delhi is a union territory which has a separate High Court, and Jammu Kashmir and Ladakh, these union territories share one common High Court. And also Parliament is the one that can extend or exclude jurisdiction of your High Courts over your union territories. Now, according to your Article 216, there will be a Chief Justice of a High Court and also judges. Understand this very, very clearly. The judges of High Court and judges of Supreme Court are appointed by President of India. Judges of High Court are not appointed by the governor. Understanding? That comes only for your other cases where I will tell you where. But High Court appointed by President of India. And what was the strength? That will also be decided by the president. There is no one fixed strength. Appointment again by Article 217. Okay. Same, based on your collegium system only. This is also. Now, let's say if you have to bring in the consultations as to who you will appoint, it will be based on your collegium system. Now, what are the qualifications? So, remember, while I was discussing qualifications of Supreme Court judge, I told there are three options, right? Here, the qualifications for your High Court judge are he or she has to be a citizen of India, and they have to have held judicial office for 10 years or be an advocate in High Court for 10 years. In Supreme Court, we saw there was one more provision called as distinguished jurist in the President's opinion. Here, no option of distinguished jurist. Keep that in mind. Prelims may important. And also here also same thing. There is no minimum age prescribed by the Constitution. And the distinguished person, that thing to keep in mind, not there for High Court. The oath for the High Court judges will be administered by the governor. Their term is for 62 years. If they have to resign, they will write it to the President of India. The salary is charged on the consolidated fund of state. The pensions are charged on the consolidated fund of India. Whereas for your Supreme Court, salary, pension, allowances, all of those are charged on the consolidated fund of India. Okay. Now, with regarding to transfer of judges from your High Court, from one High Court to another High Court. So here initially it was like transfer of judges used to happen, but then later it was observed that see, transfer of judges will invoke a feeling like as if they do a good job, they are being posted elsewhere. So for the protection of the judges, certain safeguards were brought in your transfer of judges. First and foremost, who can transfer the judge? President, after consulting the Chief Justice of India. But after 1977, Supreme Court gave out a ruling that judges should be transferred only in case of public interest, not because that you are not finding compatibility with the judge. Okay. In 1994, judicial review was allowed on the transfer of judges. 1998 onwards, the Chief Justice of India plus four senior most judges and also the Chief Justice of the High Courts of the transferring High Court and receiving High Court also should be consulted. Understanding? Next here also let's see with respect to your appellate jurisdiction. Appellate jurisdiction works in both civil cases as well as criminal cases. Civil cases, again, if there are, the first appeal is allowed if there are any issues with regarding to facts or laws. Okay, and then second appeal is allowed only if there is a question of law involved in it. Criminal cases can be appealed only if it is appealed from session court which is having a sentence above 7 years, and death sentence, if it is your lower court can prescribe death sentence, but compulsory high court confirmation is mandatory. Okay, the rest all similarities only we will see with respect to your Supreme Court and High Court, which we have discussed in your Supreme Court. Next topic is tribunals. Okay, look at this. See, tribunals were not originally present in the constitution, they were added through your amendment. Which amendment? 42nd Constitutional Amendment Act of 1976, which added part 14A, which was tribunals, and it created two articles, Article 323A and 323B. 323A is for administrative tribunals and 323B is for other tribunals. Okay. Now, first we will see is with your administrative tribunals. Administrative tribunals, again simpler sense, they are created through your Administrative Tribunals Act of 1985. We have also created your Central Administrative Tribunal or CAT through this. In 1985 it was established. The principal bench is in Delhi. Circuit sittings is allowed throughout the different benches, and also it is a multi-member body which has chairman and members. Earlier there was also chairman, vice chairman and other members, but then now it is only chairman and members. The original jurisdiction of your administrative tribunals is, let's say, the Central Administrative Tribunal covers all India services, central services, civil posts under center, and civilian defense employees. It excludes armed forces, Supreme Court staff, and parliamentary secretarial staff. This is important for your statement kind of question. Keep in mind. Next, again, tribunals becomes important because your constantly center kept on passing ordinances and laws, and your judiciary kept on striking it down because they placed a minimum age for to be a member of tribunal, which was to be 50 years. Judiciary struck that down, telling that no, what is the logic behind minimum age? And we have not placed any minimum age concept. So based on that, tribunals becomes important. Now, appointment to tribunals, members and your chairman are appointed by your President of India. The selection committee for the member of tribunals will be chaired by sitting Supreme Court judge or a judge nominated by the Chief Justice of India. The term for chairman will be 5 or 65 years. The term for members will be 62 years. And if your Chief Justice of India concurrence is there, after that they are appointed through your appointments committee of cabinet. Understanding? And also for your tribunals, they are not bound by your criminal procedure code, but they are guided by principles of natural justice. The appeals, initially appeals lied only to your Supreme Court, but after Chandrakumar case in 1997, they even brought in the jurisdiction of High Court. So which means now if you have to appeal against the decision of tribunals, then High Court jurisdiction is also there. You can appeal for both. Judicial review is also brought under this, and the present position is you can appeal to division bench of High Court and you can go to Supreme Court only after your High Courts. Next is State Administrative Tribunal. This has to be set up by the central government after the request of your concerned respective state. Now this State Administrative Tribunal or SAT are set up also under your Administrative Tribunal Act of 1985. So what and all here we see means who are they involving or what is their jurisdiction means state government employees. The appointment is again they have chairman and members. They are appointed by president after consultation with the governor of the concerned state. Next, we also have, we saw CAT, Central Administrative Tribunal. We saw SAT, State Administrative Tribunal. Next is JAT, Joint Administrative Tribunal, which is for two or more states. They have the authority, jurisdiction of both these states, that is whichever participating states. They are appointed by the president, that is the chairman and members are appointed by the president after consulting the governors of the states involved. Article 323B is for tribunals of other matters. What are the other matters covered? For example, your taxation, foreign exchange, import, export, industrial labor disputes, urban property ceiling, elections, food stuff, rent, tenancy rates, all these things. Now, your legislative authority is there. Again, if we are going to see as a difference between Article 323 and 323B, first and foremost, 323A deals only with service matters, 323B with all the other matters, like I spoke, your taxation, foreign exchange, imports, right? Who can make laws? Okay, in your Article 323A, that is your administrative tribunal, only parliament. With respect to your 323B, it is parliament plus states. What is the hierarchy that we see in your 323A means there is one central administrative tribunal and state administrative tribunals for the respective states. Here they can have multiple tribunals in your other tribunals. Hierarchy is not allowed in your administrative tribunals. Hierarchy is allowed in your other tribunals. Next topic is subordinate courts. Okay. In subordinate courts, first of all, subordinate courts means your district courts and lower courts. They are subordinate to the high courts. Supreme Court, High Court, subordinate courts. Now the constitutional articles for them are from 233 to 237. According to Article 233, appointment of district judges. Remember I told you judges of High Court and Supreme Court are by President of India. Your district judges are by governor, but in consultation with your high court. If you have to become what is the eligibility criteria to become a district judgment, you should not be in government service, you should have been an advocate for at least 7+ years, and you have to be recommended by your high court. Now according to article 234, okay, you have to recruit people other than your judges, means for your judicial services. What you will do, first and foremost, that is where your state public service commission will come. The governor will be appointing these people, those who have written this exam, but after the consultation with your high court. That is for the previous one is for judicial services. Next, if we see with regarding to the structure of our district courts, we have three-tier system below your high court. First level is your judiciary, that is Supreme Court, High Court, Subordinate Court. Subordinate courts pe three levels are there. In the first level is your district court. District judge is the highest in that particular district. The civil, when that particular judge takes up civil cases, he is called district judge. When he takes up criminal, it is called as sessions judge. What are the powers? They have original and appellate jurisdiction with respect to your civil and criminal cases. They also have administratory and supervisory district over the other courts. The appeals from district court goes to your high court. The sessions judge, who is the sessions judge? Criminal side. So what is the punishment he can give? He can award penalty including death sentence, but this has to be confirmed with your high court. So high court confirmation is needed. The sessions court judge has the power to impose death penalty? Yes, but with high court confirmation. The second level after district level is your subordinate judge in the civil side. Criminal side by civil judicial magistrate. In the civil side, they have unlimited pecuniary jurisdiction, which means the amount of money in the civil cases to be involved, that is unlimited. Whereas here, the punishment maximum, they can take up cases where the punishment can be a maximum up to 7 years. The lowest level, Supreme Court, High Court, your district court, your middle level, and then this is your lowest level pay. Civil judge will be called as a munsif, criminal judge will be, that is criminal cases dealing judge is called as judicial magistrate. In this, the jurisdiction is small value cases, okay, particular amount will be given, and the punishment for your criminal cases should be maximum to 3 years, that is what they can be their jurisdiction. Next is your National Legal Services Authority and Lok Adalat. Otherwise, your Article 39A speaks about providing free legal aid and free access to justice, that is equal access to justice. So because of that, they have come up with Legal Services Act of 1987, which came into force in November 1995. What does it do? A proper legal aid network is created, because again our judiciary is based on the fact that your justice to all concept, they are trying to deal with your NALSA or Legal Services Authority Act. Your NALSA or National Legal Services Authority is constituted under Legal Services Authority Act of 1987. What are its functions if you see? It is for providing policies or guidelines for legal services, monitoring the implementation of your legal services, and they provide schemes for your free legal aid also. Now in this, if you see state level, we have your national level, we have state level, district level, taluk level, and last Supreme Court Legal Service Committee. Now, who and all are eligible to avail the benefits under your free legal aid? Means women, children, SC, ST, industrial workmen, your victims of disaster, violence, flood relief, and also your drought, earthquake, industrial victims, industrial disaster victims, disabled persons, persons in custody, and anyone whose income is your less than 1 lakh, and victims of trafficking, begar, forced labor. All of these people are eligible for free legal aid. Next, Lok Adalats. Lok Adalat means these are more like people's court. Okay, this is what one of your Gandhian principles also, wherein you try to go to the grassroots level democracy, where one of the ways where justice is disseminated is through your Lok Adalats. It is more of a alternate dispute redressal. It is ADR mechanism. Okay, the settlement is by compromise and conciliation. It got statutory status the first after independence. Something if we have to see with regard to Lok Adalat, we can see it with respect to your Gujarat camps. It is created under your Legal Services Authorities Act of 1987. So, what is the jurisdiction? They can take up cases which are pending in front of court in the pre-litigation stages. But one most important thing is, in your Lok Adalats or ADRs, you cannot take up cases which are non-compoundable offences, such as your murder, right? Very serious or heinous nature crimes are not going for your ADR mechanism. So the judicial officer will be the chairperson, there will be an advocate and the social worker. One of the main principle of your ADR is time bound justice delivery. So they will have the same powers as that of a civil court, and they can award the awards which are given is similar to that of a decree of a civil court. No criminal court, because no non-compoundable cases not involved here. Their decision is final and binding, and no appeals are there against this. You can freshly file a case, but you can't appeal against this decision. Now, permanent Lok Adalats, again, they have also created by your local legal services authorities. This was created through an amendment. Why are they there? Means for your public utility services, for example, your transport, right, any issues in those. So, a lot of those things. Here, the composition will be chairman and two members. Chairman will be a district judge or of higher rank, and two members who has the experience with your public utility services. What are the features here? They can take up cases up to 10 lakhs, and here also non-compoundable cases or your severe heinous crimes and all are not allowed for your ADRs. Pre-litigation mechanisms, that is, they can take up cases which are still pending in that. And also, if settlement fails, further what action can be taken upon will be decided based on your permanent Lok Adalat. Understanding? This is one differentiating feature between your Lok Adalat and permanent Lok Adalat. The award given by them are final and binding. Next is your family courts. Family courts are set up through your statutory act of your Family Court Act of 1984. What is the objective of creating something called a family court? For conciliation and speedy settlement in family disputes. Family disputes, again, if you see like marriage, divorce, child custody, those kind of things. So who can set up a family court? By the state government in consultation with a respective high court. And also it is mandatory to set this up where the population is above 10 lakhs. Look at this. The jurisdiction is in which cases means your matrimonial, divorce, separation, okay, child custody, on all this, property of spouses, custody rights, maintenance, and what is the procedure in this case? Means first step, it will always be towards conciliation. When that fails, then only they go for the next stage. Appeal is allowed against this one appeal, that is to your high court. Next topic of discussion is your Gram Nyayalayas. Gram Nyayalayas are set up through your Gram Nyayalayas Act of 2008. This is last mile justice delivery or access of justice to your doorstep. This is a grassroots level justice delivery system where the judicial magistrate of first class will be the one who will be presiding over. The presiding officer is also called as your Nyayadhikari. This will be appointed by the state government, again in consultation with High Court. It is more like your Gram Nyayalaya, means mobile courts, right? They will be visiting villages. It will be set up for your panchayats, okay? And this has both civil and criminal cases, they will hear. Now, they can be set up for intermediate panchayat or group of your panchayats. The jurisdiction is both criminal cases plus civil cases, which are listed in your schedule first and second. Most importantly, they are not bound by your evidence act, but rather through your principles of natural justice. For appeals, for criminal appeals, you can go to your sessions court, which has to be disposed within 6 months, and also for civil courts, you can go to your district courts, which has to be disposed within 6 months. Other features if we see of this Gram Nyalaya, first thing is conciliation is largely through your conciliators, and plea bargaining is also allowed because again it is in the grassroots level. Understanding? So you can't follow the Evidence Act procedure here. Alright, 5,000 plus Gram Nyayalayas they are planning to establish as the new target. With this, we're done with the judiciary topic. If you like our content, subscribe to our channel, hit the like button, share it along with your friends. Thank you. Hello folks, welcome to Legacy IAS Academy. In this video, we will be discussing with our Polity Prelims Marathon continuation, which is 7th in series. So in this, we will be discussing about constitutional bodies and various non-constitutional bodies. First, we'll start with the constitutional bodies. The first one is Election Commission of India. Now, according to Dr. B.R. Ambedkar, there are certain things called as bulwarks of our constitution. What are the bulwarks of the constitution? If you see, in that first body is Election Commission of India. Second one is your Supreme Court. Okay. And third one is UPSC, Union Public Service Commission. And fourth one is CAG, Comptroller and Auditor General of India. So these four are considered as the bulwarks of Indian Constitution. What do we mean by this bulwarks of Indian Constitution? Means these are the bedrock on which our constitution is built, and in fact, let's say if our particular country has to be truly democratic in nature, first and foremost, what we have to do means maintain a free and fair elections in our country. So if you have to conduct free and fair elections in our country, then which one is important? The election conducting body is important. So what is the election conducting body in our country? That is Election Commission of India. The Election Commission of India, if it has to conduct free and fair elections, then it has to be a constitutional and independent body. Why do I tell it should be an independent body, or what does a constitutionally independent body means? Which means they are not deriving their power from any executive or legislature, but directly from constitution itself. They also have security of tenure, which means you can only remove them in a procedure mentioned in constitution. That is on the grounds. Second thing is the salary, allowances, etc. are all equal and similar to that of your Supreme Court judge. Another important aspect is they have a fixed term. Now what happens when you have a fixed term is you cannot arbitrarily remove them. Understanding? So this arbitrary removal is taken off means the body functions as an independent body. And also you cannot change the service conditions to their disadvantage after being employed. So all these safeguards with respect to security of tenure, your salary, perks, allowances, your powers, functions, positions are all something which makes a particular body independent. So Election Commission of India is a independent body. Now let's see what are the constitutional provisions it has. It is in part 15. It is from articles 324 to 329. Article 324 tells that for creation of a permanent, independent and constitutional body. Understanding? Three keywords very important: permanent, independent and a constitutional body. Now, what does your election commission do? It's conducting elections. Conducting elections for which one? Your Lok Sabha, that is your Rajya Sabha, Lok Sabha put together, Parliament, and also your state legislature such as Legislative Assembly, Legislative Council, and also to the office of President and Vice President. Understand, they will not conduct elections to Panchayat and municipalities. That is separately under your State Election Commission. Okay, which is dealing with articles from 243K to 243ZA. So one thing you have to know, the Election Commission of India conducts election to Parliament, State Legislature, Office of President and Vice President, not to Panchayat and municipalities. Next, members of your election commission. See, initially, that is from 1950, your election commission functioned as a single member body. So what happened in between your period of 1989 and all is, your voting age was reduced. Earlier voting age was 21 years, then it was reduced to 18 years. So with the increased workload, they made it into a multi-member body. Then they went back to being a single member body. Then finally, now as of convention, we are following a multi-member body. Multi-member body means there will be one chief election commissioner and other election commissioners. How many other election commissioners? As deemed fit by the president. And also, all the members of your election commission of India, including chief election commissioner and election commissioner or other regional election commissioners, will be appointed by the president of India. How? According to your CEC and other election commissioners appointment conditions of service and term of office act of 2023. Understanding? And the other regional commissioners or election commissioners are also appointed by the president of India only. So as of now, if you see election commission, it is a multi-member body with one chief election commissioner and two other election commissioners. Okay, have a look at this. What are the service conditions? Now they have a tenure of 6 years or 65 years, whichever is earliest. They can resign at any point of time by writing to the president. The salaries and perks, allowances, etc. are similar to that of a Supreme Court judge. The conditions cannot be varied to their disadvantage after the appointment. And also the decision making, here this is the most important thing, especially in statement kind of question for prelims. The decision making is by majority, which means, let's say this is one CEC and one EC, another EC. They will take the decisions through majority, means let's say if these two agree to 2:1, it will not be any casting vote. Okay, when the statement tells CEC will not vote in first instinct, it is only to break casting vote. None of those things will apply. The decision is based on majority. Understanding? With respect to powers and functions, they will enjoy similar powers. Then what is the point of calling this person a chief election commissioner? And also, who becomes the chairman of Election Commission of India? This means it is your chief election commissioner. He is the chairman. So what is one special privilege if you see? Removal of CSE is on the ground similar to that as your removal of Supreme Court judge. How is that? Through proved misbehavior or incapacity. Now, for the removal of election commissioners, this can happen only with the recommendation of your CEC. That is, CEC must tell, Chief Election Commissioner must tell for the removal of other election commissioners. Okay. Next. One very important landmark judgment, if we are going to see with respect to Election Commission of India, is your Anup Baranwal versus Union of India case in 2023. So what happened in this is your judiciary exercised Article 142 of complete justice and told that free and fair elections are an important part of our country, so much so that it constitutes to the basic structure. So when free and fair elections are to be made, then for the appointment also, it should be very important that a certain procedure is followed. It was a 5-judge bench decision. What did they tell means, they told your see, appointment of chief election commissioner and election commissioners is by your president, but there should be something called as a selection committee. That selection committee will comprise of Prime Minister of India, leader of opposition in Lok Sabha and Chief Justice of India. They also further went on to tell that if there is no leader of opposition in Lok Sabha, then leader of the largest opposition party. Understanding, this is what they told. Based on this understanding, based on this principle, as a okay, a response to this is where your parliament came up with CEC and other ECs, Chief Election Commissioner and other election commissioners appointment, conditions of service and term of office act of 2023. So this was the aftermath of Anup Baranwal case. Understanding? So your chief election commissioner, both are appointed by the president only. What are the powers and functions of your Election Commission of India? First and foremost, let's see what are its administrative functions. See, like we discussed, they will be the one who will be conducting elections for your parliament, state legislature, office of president, vice president, and also delimitation of constituencies as per your delimitation act. They will also be very much important aspect of election commission, if we will tell, is for preparation and revision of electoral rules. Why this becomes important is, see, recently you saw your Bihar SIR controversy, and also your election commission comes into current affairs because your January 2026 pay we had something called as National Voters Day. Understanding, this is to showcase that when election commission came into picture. Understanding, so this becomes important. What else does your election commission do? Means they are the ones who are with registering registering parties, and also with respect to designating the status of national party or state party based on the poll performance. So here is where one important prelims aspect you have to remember. Your Election Commission of India is responsible for registration of a political party, but they are at no way responsible for deregistration of a political party. Keep that in mind. Election Commission, registration of political party, but deregistration of political party, Election Commission will not do. Clear with that? Next, they will be the one who will be recognizing political party. They will allocate election symbols. And also now one more topic I'll tell you from this is, let's say a particular party, which was a national party. Now, it lost that amount of polls needed. Does that mean they will instantly lose the symbols? No, they will have a time of 6 years. Understanding? The Election Commission of India is entrusted with enforcing model code of conduct, and they have the authority for poll cancellation in case of rigging, booth capture. Understanding? And also they will request your staff from your center or state government to assist them, and the entire election machinery will be supervised by your Election Commission of India. Now look at this. What are the advisory powers? Now, when we are telling advisory, okay, see, advisory means itself, it is telling that the recommendations are not binding on the government. It is merely recommendatory in nature. So, what does it advise? It advises the president with respect to your MP disqualification, advises governor with respect to your MLA disqualification, and also advises for when is it feasible to conduct elections when there is precedence rule. Understanding, in a state. So Article 356 pay we would have seen. Next, they also have your quasi-judicial functions, in where with respect to disputes on your party recognition or symbol allotments. Okay, and one more thing is, in any election related dispute, they will be the one who will sort it out. One more thing with respect to your political parties is, like I told, the Election Commission will be the one who will be recognizing them as your national party, state party, registered party, unregistered party based on your poll performances, allocation of party, your election symbols, all of it will be based on this. If you see the election machinery of our country, first is deputy election commissioners, who will be drawn from the lot of your civil servants, and also in the state level the highest is your chief electoral officer. In district level there is something called as district returning officer or DRO. Understanding, which is usually your IAS cadre level. And in the constituency level there is something called as a returning officer or RO. Okay. This completes Election Commission of India. So usually we will be discussing questions also, but here how we will do means first we will go through all the constitutional non-constitutional bodies, and then at last we will look into the questions, and through that also we will learn more topics. Okay. The next constitutional body is UPSC. I have told you, according to Dr. B.R. Ambedkar, UPSC is also a bulwark of the constitution, the base on which our constitution or democracy is built. Look at this. Now, the UPSC, Union Public Service Commission, is a constitutional body, part 16. Okay. The articles are from Article 315 to your 323, and also it is an independent constitutional body. Again, the same aspects like I mentioned for your Election Commission. Independent means they have security of tenure, they also have grounds for removal, which means arbitrarily you can't remove. And one more important thing, when I tell security of tenure, they do not hold the office until the pleasure of president. Unlike your Prime Minister, Council of Ministers, who hold the office during the pleasure of president. Even though these bodies are appointed by president, they can be removed only on the grounds mentioned in the constitution. Okay, what is its role? If you see, they are the central recruiting agency in India. Okay, one more important thing about UPSC is it is only central recruiting agency, not personnel management. Personnel management goes under Ministry of Personnel. Now, let's look at important articles with regarding to your UPSC. Okay, Article 315 is establishment of Union Public Service Commissions and State Public Service Commission. Article 320 enlists the functions of Union Public Service Commission. 321 is powers of Parliament to extend the functions and jurisdiction of UPSC. Who can extend it? It is Parliament. Keep that in mind. Article 316 is appointment and tenure of chairman and members. 319 is prohibition of further employment after tenure. That is trying to tell whether are they eligible for further employment after being as chairman or members of UPSC. 322 is expenses charged on Consolidated Fund of India. Remember, we told you it is an independent body. So which means again your salary etc. is also charged on Consolidated Fund of India, which is not subject to vote. Which is not one of the main aspects that makes it independent is these things. Article 317 is removal of your chairman or members, again based on the grounds mentioned in the constitution. 318 is powers of president to determine the service conditions of these people. 323 is the report submitted by UPSC to the president. Keep that in mind. Now look at this. Composition of your UPSC. There will be a chairman and other members. Other members is not a fixed term, that will usually be determined by the president. Okay, the chairman plus members are all appointed by the president of India. And also, like I told, the strength of the members are not fixed by the constitution. Usually it ranges from 9 to 11 members. What are the qualifications? If you see, there are no specific qualifications, but it just tells at least 50 members in UPSC should have held any government post for at least 10 years. Understanding? Now, what are the terms and service conditions? First, they hold office for either 6 years or 65 years, whichever is earliest. They can resign at any time by writing to the president. And now, this is the most important thing. Look at this. Let's say I am the chairman of UPSC. After my term is completed, I cannot serve the second time. Understanding? And also, let's say I am a member of UPSC, but I am eligible to become the chairman of UPSC. Understanding? But not second term to the same position. Clear up until here? So to the same position, no second term. And one more thing is the removal procedure for these chairmen and members are mentioned in Article 317 we saw earlier. The president can directly remove these UPSC members when the person is declared insolvent, bankrupt, but they engage in paid employment outside the office during the tenure, or they are physically and mentally of unsound body and mind. But there is also another ground for proved misbehavior or incapacity. What is that proved misbehavior means? In case you have to remove a person that is a member or chairman of UPSC on the grounds of misbehavior, then you have to refer. Who has to refer? President has to refer this matter to Supreme Court. Now, whatever Supreme Court does, okay, it has to conduct an inquiry mandatorily. Now, whatever inquiry it has conducted and the decision it gives, that advice is binding on the president. So, Supreme Court's advice with regarding to your UPSC chairman or members removal is binding on the president. Understanding? Now, in between, they like while the inquiry is going on, they can be suspended. The misbehavior also includes your interest in government contracts or sharing profits from such contracts. Okay. Now, this is with regarding to the removal procedure. Now, let's see what is the safeguards that this particular constitutional body has. Look at this. First thing is they have security of tenure. What do we mean by security of tenure? They cannot be removed in office arbitrarily, or they do not hold the office until the pleasure of president. They have a fixed term. And also their salary, allowances, etc. are all charged on the consolidated fund of India. After they are appointed to their job, you cannot change the service conditions to their disadvantage. So the chairman is not just allowed for the second term, okay? The chairman of UPSC cannot appear for the second term, but also he is prohibited from further government employment. Okay? The members, like I told, cannot become the members of UPSC for second term, but can become the chairman of UPSC for second term. After this, no other government further employment is allowed. So there is no reappointment for the same position to the second time. Now, let's see what are the functions of your UPSC. That is mentioned according to Article 320. They will be the one who will be recruiting for your All India services, central services of Group A and Group B services, and also services of union territories. Now, let's say if any states want assistance in order to conduct certain exams, then with the president's prior permission and approval, they will assist the states. Now, with respect to advisory role or your personnel matters, what happens here means whatever advice tendered by UPSC is recommendatory in nature and not binding on the president. So, your UPSC is usually consulted on your recruitment methods, appointment principles, promotion, transfers, deputation, absorption, all of this. So, let's say even if you are not consulted in certain scenarios, that doesn't make it invalidated. Understanding? And also, the what is the nature of this consultation means it is not mandatory that you have to consult UPSC. That is what I mentioned. Even if you do not consult, it doesn't invalidate the decision of the government. Okay. And also, this particular aspect what we are now discussing, this you have to be very careful because this can come to you as your UPSC prelims question in statement form. Just because the post is conferred, okay, selection is done by UPSC does not mean you have right to appointment. This is told by your Supreme Court. Understanding? So, and it has also told government must act fairly and not show any arbitrariness. This is your Supreme Court's directions. Now, where will it submit its annual reports? According to Article 323, UPSC will submit its annual report to the President. President will further lay it in front of Parliament alongside a memorandum of acceptance or rejectance, which means which of the advice of UPSC is accepted. Understanding? and which of them are not accepted. So you will get to know what action government has taken on the recommendation of your UPSC. These recommendations are not binding on the government. Keep that in mind. And after this, if you have to appoint someone, then you need approval from appointments committee of your cabinet. Okay. Now, what are the limitations that are there with regarding to your UPSC? First and foremost, UPSC is not consulted in, even though it is a central recruiting agency, it is not consulted in any of the reservation matters or SC/ST claims with respect to tribunal or commission appointments or high diplomatic posts, groups, your group D post, your UPSC is not consulted, and also in any government temporary post which is less than 1 year. So just because UPSC is not consulted in this doesn't make it invalidated decision. Understanding? Even consultation is directory, not mandatory. Look at this. What is the role of UPSC? First and foremost, it is considered as the watchdog of merit system, so as to make sure that merit is given prior importance. And also, it is just a recruitment body, not a personal management body. This goes to your Ministry of Personnel, and also its role is only advisory in nature. It is not binding on the government. Your UPSC is recruitment and advisory, whereas training, posting, pay, service conditions, all of this is by your Department of Personnel under your Ministry of Personnel. One more important thing here we will see is with regarding to your overlap of certain functions between your UPSC and Central Vigilance Commission. Okay, on what aspects? Both of these bodies are consulted with respect to disciplinary matters involving your public servants. So again, because both of these bodies are there, there is a possible conflict, but your UPSC has a slight edge over CVC because UPSC being a constitutional body. Understanding? And CVC is a statutory body since your 2003. And so we're done with UPSC. Next we'll start with SPSC, State Public Service Commission. Also your part of your watchdog of merit system. It is in part 14 of the constitutions with respect to articles from 315 to 323. It is an independent constitutional body which is for recruitment in your state. What is the composition? The composition is chairman and other members. Other members, it's not fixed. And also again here there is one very important point you have to keep a note, especially from prelim statement kind of perspective. The appointment of this chairman and members are by the governor of the respective state. But the removal is only by the President of India. Keep this in mind. Also, what is the strength? Again, it is not fixed by the constitution. It will be determined by the governor. Qualification rule is again at least minimum 50% of the members of SPSC should have held any government office under your center or state for at least 10 years. Okay. Now, important thing, look at here, the tenure and service condition. They hold office for your 6 years or 62 years. Whereas your UPSC is 65 years. That difference also you have to get. They will write their resignation to the governor and the reappointment to the same office is not allowed. Which means, let's say I am a State Public Service Commission member. I am further eligible, that is making sure it's within the age. I am eligible to be the chairman of your, if I am a member of SPSC, I am eligible to be a chairman of SPSC or a member of UPSC or a member of or a chairman of UPSC. Now let's say I am the chairman of SPSC, that is a State Public Service Commission. I am not eligible for the same position second time, but rather next I can be eligible to be member of UPSC or chairman of UPSC, not to the same position again. Now, the removal procedure according to Article 317. Now, first and foremost, the members of SPSC, even though appointed by Governor of India, they are removed by President of India. On what grounds? Directly you can remove them on grounds of insolvency, bankruptcy, paid employment outside the office during the tenure, or unstable mind and body. But if it is, you have to, let's say, remove them on the grounds of misbehavior, then again the same concept will apply. President has to refer the matter to Supreme Court. Supreme Court mandatorily will commit will create an inquiry, and whatever decision that Supreme Court tells, that advice is binding on the President of India. Okay. At that point of time, in between, they will be suspended during, okay, the inquiry, no, that is done by your governor. Okay. Next, with respect to their safeguards, we saw the removal, now we will see the safeguards. They have security of tenure, the service conditions cannot be altered to their disadvantage after employment, and the salaries, pensions, all of these are charged on the consolidated fund of state. Okay, look at this. So if I am a chairman of SPSC, I am eligible for UPSC chairman or UPSC member, but I am not allowed to be a member for the same position second time. Also, I do not have further government employment. If I am a member of SPSC, I am eligible to be a member of UPSC or chairman of UPSC or chairman of SPSC, and also I am not eligible for any further government employment. Apart from this, I am not available for the same position for the second term. So second term is not permitted. What are the functions of your SPSC? According to 320, they recruit in your state civil services, state public post, and they also offer advisory functions, which means whose recommendations are not binding on the government. They are usually consulted on your recruitment and appointment principles. Again, this consultation is not mandatory, it is only directory. If they are not consulted, that does not invalidate the decision. Yep. Next, nature of consultation. Now, because they are not consulted, that does not invalidate the decision. And again, same like your UPSC, selection by SPSC does not give right to appointment. And again, government must act fairly without arbitrariness. This is by your judiciary. Now, coming to the reports. The State Public Service Commission will submit report according to Article 323. The annual report will be submitted to Governor, who will then place it in front of state legislature, explaining what are the actions taken on that by your state government. Again, these recommendations are not binding on the government. What are the limitations? If you see, your State Public Service Commission is not consulted on reservation matter or your SC/ST claims. Now, when it comes to your judicial services, okay, judicial services also is conducted by your SPSC. But when a governor, while making appointments to your judicial services, he will consult, okay, SPSC and also State High Court. Both of this has to be consulted while doing the appointments for judicial services, and all this will apply to the posts which is below your district judge. Next body we will be discussing is your Joint State Public Service Commission or JSPSC. Okay, look at this. So your UPSC is a constitutional body, SPSC is a constitutional body, but JSPSC is not a constitutional body, but rather it is a statutory body created through an act of parliament. So when two or more states request for a joint public service commission, they will create this. Now all the members and chairmen are appointed by the president of your JSPSC. The term is 6 years or 62 years, whichever is earliest. And also removal is also by the president only for your JSPSC. And who will they submit the report to in JSPSC? Means to the concerned state governors, who will further table it in the respective state legislature with memorandum of actions taken. Next is Finance Commission. So your Finance Commission, most important, you have to know the article, by heart the article, it is Article 280. which is in part 12, which deals with finance, property, contract, suits. If you see, your finance commission is a constitutional body, but it is quasi judicial in nature. It has the powers of your civil code, and it is constituted by President of India either at the end of 5 years or earlier if deemed necessary. Understanding, it is not permanently there. Okay, it is constituted at the end of 5 years or earlier when deemed necessary by President. And also, your finance commission is called as balancing wheel of fiscal federalism, and it also mainly deals with your fiscal relations between center and state, which deals both about your horizontal devolution of funds and vertical devolution of funds. Understanding, what is the composition of finance commission? If you see, the total 5 members, one chairman and 4 other members. All of them are appointed by the President of India. They are eligible for reappointment. Okay, and here, because it is constituted at the end of every 5 years, right? What is the qualifications? The qualifications are not prescribed by the constitution. Keep that in mind for your statement kind of questions. It is prescribed by Parliament. Okay, look into this. The chairman should be someone who should have experience in public affairs. The members should either be judge of high court or qualified to be a judge of high court, should be an expert in government finance and accounts, should have expertise in financial administration and have special knowledge of economics. Either one of these should be there. Alright. So now what are the functions of your finance commission according to Article 280? First is tax devolution between your center and state. Tax devolution between center and state also includes your horizontal devolution and vertical devolution. Also, distribution of net proceeds of the taxes. Again, any of the recommendations of finance commission are not binding on the government. So much so that when Raj Mannar was your finance commission head, he had held that this is, again, this itself is recommendatory only. You should not ignore the recommendations of finance commission unless and until there is a strong reason. Understanding, so this showcases, or this at least tries to showcase the importance of finance commission, but yet that recommendation itself is recommendatory in nature. Understanding, so your finance commission will allocate funds among states between your center and state. They are the ones who will be pertaining with respect to grant in aids, and also how grants should be given to states from your consolidated fund of India. Next, with respect to the local body finances also, there is also something called a state finance commission, but at the same point of time, your finance commission will also give more of a state consolidated fund, how the money has to be augmented. Okay, so this is based on your state finance recommendations for your panchayat and municipalities created by your 73rd and 74th constitutional amendment. What else they will do means, if any other matter is referred to them by the president in the interest of sound finance, they will look into that issue also. Now, with regarding to the report is submitted to the president, who will further lay it in front of both the houses of the parliament with the memorandum of explanation as to what action has been taken by these recommendations on the government. These recommendations are not binding. Understanding, it is merely advisory in nature. And because your finance commission pay, they have told, okay, you have to give this many percentage to states, the states cannot claim that as a legal right from your union government. Okay, that is also one important thing you have to keep in mind. One thing when we are discussing about planning commission and finance commission is, there was a tendency of overlapping of functions from 1915 to 2014. Understanding, why is that? Because your planning commission was a non-constitutional body which was dealing with discretionary transfer of funds, or your fund distribution was also taken up by your planning commission. So this was an overlapping function to which, to a constitutional body. Understanding, but with the abolition of planning commission in 2015 and replacing with Niti Aayog was stripped of any financial allocation powers, which means completely it went to finance commission, which was initially diluted by your planning commission. So today, Finance Commission has the primacy with regarding to fiscal transfers and center state financial relations. Next is Goods and Service Tax Council or GST Council. This was not originally there in the constitution. This was added through a constitutional amendment. Look at this. Your GST Council. It was added through 101st Constitutional Amendment Act of 2016. It inserted an Article 279A, Part 12 was added. And what is it means? It is a constitutional body with federal aspects, which means it is specifically to deal with center state in the decision making of your indirect taxes. Alright, what is it trying to do? To create cooperative federalism in GST framework. So your president is empowered to constitute your GST council. The secretariat is in New Delhi. Its ex officio secretary will be your union revenue secretary. What is the vision of your GST council if you see? For highest standard of cooperative federalism, and mission is your GST through wider consultation and also to make it more of flexible to the taxpayer also. What is the composition of your GST council? The chairman will always be your union finance minister. This is so obvious. Then the members are going to be union members of state of revenue or finance picked by the respective state. So the state members will be finance or taxation minister of each state. The vice chairperson will be chosen by the state ministers. This will be decided by the states how many terms, or by rotation basis. The permanent invitees are your chairperson of your CBEC. And also, let's see what is the nature of this particular GST council. First, it is in simpler sense, understand it like it is more like the cooperative federalism, especially in fiscal areas, is where they have issues. If true cooperative federalism has to be met at the same point of time, the states should not be put at a disadvantage. We all know that states usually have a lot of cash crunch. Cash crunch in the sense they are financially starved, right? So this gives them, okay, with respect to the taxation of your indirect taxes here, this gives them a platform for their bargain. Understanding? So it is a joint forum of center and state, which will be having decision making powers. Okay, how is it? Through the weighted voting. That is 3/4 of majority is needed. 3/4 of the votes are needed in order to come to a decision. So decision making is through consensus. Again, how much is the percentage of vote weighting that they have? Weightage means center has 1/3 of the voting weight. States all put together has 2/3. Understanding? So if you have to continue with the working of the house, at least half of the total members should be there as the minimum quorum for the GST council to work. What are the core functions of your GST? According to Article 279A, they also have certain things of your special rates during natural disasters. Okay, they will keep consideration of all the other aspects, and also with respect to GST structures on your taxation, cess, surcharge, they've also have these things which are kept outside the ambit of GST when they will be brought in the GST ambit, and all that will be a collective decisions. Okay, and there is, that is your GST exemptions, model GST laws, what is the principle of levy, right? At the same point of time, they also provide compensation for states. Because of your incoming of your GST, lot of states will experience this loss. To accommodate their interest or revenue loss due to GST, they were to be given compensation for a period of 5 years. Again, the recommendation by GST Council is advisory, and also most important aspect of, if you see what is your GST Council means, it tries to strengthen fiscal federalism. It tries to make shared decision making. This is very important concept of your GST Council, shared decision making and consensus based tax governance. Understanding? So this is your GST Council. Alright. Hello folks, welcome to Legacy IAS Academy. In today's video, we will be continuing with our Polity Prelims Marathon Series 7, where we will be discussing about constitutional, non-constitutional and other bodies, wherein we will be learning more about these topics like usual, half from the static content, half from your current affairs and your prelims previous year questions. Okay, now we will start with National Commission for SCs. See, first and foremost, if you have to know something about your National Commission for SC, the original provision, what was there in the Constitution 1950 when we made the Constitution, was there was Article 338, according to which there will be a special officer for SC and ST. Look at this. There is no commission by this time, there is only one special officer. Where else do we see this concept of special officer? Special officer for linguistics, yes, for linguistic majority. Like that, only a special officer for SC and ST was created. Okay, it was in Article 338 which comes under Part 16. What does this particular provision have? Part 16 means it is the special provisions for scheduled castes. Understanding? So, this was how the constitution was originally. Then when did things change? Things took a turn from a special officer, just one body dedicated for SC/ST, to an entire specific body for SC and ST, to a special body for SC and ST. Things took a turn in your 65th Constitutional Amendment Act of 1990, where they created a constitutional body. A constitutional body with multi-member. What does it mean? That is, there will be something called as National Commission for SC and ST Commission. Understanding? It was one body. This particular body replaced the special officer for SC and ST. Instead, to its place, a full-fledged multi-member commission had come in place. Okay. Then, finally, this did not stop here. What was now a multi-member National Commission for SC and ST further went through changes. When was that? In your 89th Constitutional Amendment Act of 2003. What happened here? Here the commission which was created, National Commission for SC and ST, this got bifurcated into National Commission for SC and National Commission for ST. This separate constitutional body amendment was done in 2003. This came into operation in 2004. So with that, your National Commission for SC was created under Article 338 and National Commission for ST as a separate body was created under Article 338 of A. Understanding? So, originally it was not a commission. It was just a designated officer for SC and ST. Look at this. Now when we tell it is a multi-member body, your National Commission for SC and National Commission for ST. So now we will be seeing National Commission for SC specifically. Under your Article 338, there will be a chairperson, vice chairperson and 3 other members. That is why multi-member body. Also, all of these people are appointed by the President of India under his warrant of seal. One most important thing is the service condition, tenure, etc. are determined by the President. Prelims by this becomes important because they can even tell it as it is determined by Prime Minister. Understanding it is only determined by President. Now, what is the functions of your National Commission of SC? It has, see, first and foremost, like I told you, your National Commission for SC looks into the welfare of your SCs, earlier OBCs also, Anglo-Indians also, and yes, it is a constitutional body, which means it is having a mention in the constitution. First thing. Second thing, the role this body performs is of advisory nature, which means its recommendations are not binding on the government. Also, it does submit an annual report. Let's look into this. What is the functions of your National Commission of SC? A investigative role. What does it investigate? It investigates what are the constitutional safeguards which are given to SCs, and are they implemented properly, and if they are implemented, it will evaluate the implementation. Alongside that, it also can look into complaint inquiry based on your SCs, and also inquire about your rights which have been guaranteed to them by constitution, which are being deprived, understanding, and it plays your advisory role, which means recommendation of National Commission for SC is not binding on the government, and it also recommends welfare measures for the upliftment or betterment of scheduled castes in the society. Finally, it submits report. It submits report 2 times. When is it? First, usually it submits an annual report to the President. At the same point of time, it will also submit a special report when and wherever asked by the President of India. Understanding? Look at this. At the central level, your National Commission of SC will submit its annual report to the President, which is in turn laid in front of the Parliament. Alongside, because this is a constitutional body, this has to have a sense of accountability. So when it is laid in front of Parliament, when President lays it in front of both houses of Parliament, he also submits something called as a memorandum of action taken. Which of these advices are taken into consideration, which of these will be implemented. And also, reasons for non-acceptance should also be included. Now, this is with respect to the central level. The National Commission of SC will also forward its annual report to the governor, who will now lay it in front of the respective state legislature with a memorandum of action taken and why the action was not included, like let's say which of these are included or not included. What are the powers of this commission? While looking into or inquiring into the issues of your scheduled caste, your National Commission of SC acts like a civil court. What does it do? Which means it can summon witnesses, it can enforce attendance, okay? It can demand any public official answer, okay? And also public document. All of this is given to it. So the National Commission of SC is almost like a civil court with regarding to inquiry. Alongside this, National Commission for SC had additional responsibility. What is that additional responsibility? It will investigate the safeguards of Anglo-Indian community and report it to the President. Now, this Anglo-Indian provision means earlier Lok Sabha pe 2 Anglo-Indians could be nominated by the President and 1 member by the governor to the state legislature. But by a 104th constitutional amendment, this provision was done away with. Okay. Next is your OBC functions. That is, earlier up until your 2018, National Commission for SC was only looking into your OBC safeguards, other backward class safeguards. But post 2018, what happened? A separate constitutional body was created for your backward classes with your 102nd constitutional amendment of 2018, which created National Commission for Backward Classes. So with the creation of National Commission for Backward Classes, your National Commission for SC, which earlier had to do the report on your OBC also, this was bifurcated. So now National Commission for SC will only look into your safeguards of scheduled caste. Your National Commission for backward class will look into your OBC issues. So in summation, what are the most important constitutional amendments or provisions that we have looked into? First one is the 65th Constitutional Amendment Act of 1990, where Special Officer for Scheduled Caste and Scheduled Tribe was made into a multi-member constitutional body. Next, in the 89th Constitutional Amendment Act of 2003, your National Commission for SC/ST was split into National Commission for SC and National Commission for ST. Then finally, in the 102nd Constitutional Amendment Act of 2018, your National Commission for SC, which had additional responsibility of OBCs, was removed and National Commission for backward classes was created. So these are the important constitutional amendments. Look at this. Next is your National Commission for ST, National Commission for Scheduled Tribes. Now, we have seen the history before only. National Commission for Scheduled Tribes. Why is it there? It is for safeguard of your scheduled tribes. It is in part 16 of the Constitution. It is a constitutional body under Article 338A. Again, we have seen before 1990 there was just one single special officer for your SCs and STs. Under Article 338, 65th Constitutional Amendment Act of 1990 created a multi-member commission for National Commission for SC and National Commission for ST. So, your National Commission for ST as a separate body, why was it needed? What was the need of it? The answer is because your scheduled tribes or the tribal areas, they have a unique distinct geography, culture and socio-economic issues. What issue your SCs have is not the same issues your STs have. Understanding? So we could not just generalize it. Also, in 1999, a separate Ministry of Tribal Affairs was created to look into the matters of scheduled tribes. 89th Constitutional Amendment of 2003, bifurcation of National Commission of SC under Article 338 and National Commission for ST under Article 338A. So this was operationalized from 2004. Now let's see the multi-member commission of National Commission for ST. There is a chairperson, vice chairperson and 3 other members who are appointed by the President of India under the warrant of his seal, and also the service conditions will be determined by the President. What are the major functions of your National Commission for ST if you see? It is to investigate into your issues of scheduled tribes and also monitor your constitutional safeguards, see how the implementation has taken place. Understanding, if it is there, evaluate how good of an implementation is it there, and also suggest some welfare measures for your scheduled tribes. And it also has the power to look into the complaint inquiry with regarding to the violation of your scheduled tribes. It also has one important role of developmental authority. What is this developmental authority? It will participate in the socio-economic planning and it will advise the government on tribal development, and it will evaluate your welfare progress and report, that is the annual reporting is done twice. One is annually to the President, one more is special report whenever required. Next, the recommendations of your ST, National Commission for Scheduled Tribe, includes welfare and protection measures, also socio-economic advantages and residual functions whenever will be assigned by the President. So the service conditions are determined by the President of India. Alongside that, he also has other additional functions which has been given by the presidential specification in 2005. What are those additional provisions? Means with regarding to forest and livelihood rights, ownership rights over minor forest produce, because we are talking about scheduled tribes, right? Their culture, everything is surrounded around your forests. Last is livelihood strategies for your tribals. Okay. And one more thing is, your National Commission for ST is to specifically look into natural resource rights and safeguard it with respect to your minerals and water resource. And also usually when any developmental projects take place, the first to be affected and the most vulnerable sections to be getting displaced from their lands will be your scheduled tribes. So it has to look into the matters of land and displacement. And one more thing is, like I told, your scheduled tribes are built around your forest. So you have to see that the land and the tribals are not alienated, separated, okay? And they have to be also involved with the rehabilitation of your displaced tribal people and relief measure for project displacement. They will also take an active look into forest governance. Now with respect to your scheduled tribes, if you see in current affairs, why this topic becomes important means your Manipur ka violence. As of now, there is your president's rule in Manipur, which is a fight over your majority and minority of your majority Maitis and minority Kukizos. What is the issue or the fight that started about initially was with regarding to the granting of ST status to your Maitis majority. Understanding? So, the tribal participation in forest protection, all of this has to be looked after by your National Commission for ST. Now, another important aspect of your National Commission for ST is implementation of your PISA Act, Panchayat Extensions Act. Look into this. First and foremost, when your panchayat, understanding, and municipalities, which were brought about by a constitutional amendment in your 73rd and 74th constitutional amendment in 1993, they wanted to bring it for whole of India. But in order to do that, this will not sit well with the scheduled tribes or your scheduled areas. Why? Because they have, like we spoke about, distinct geography, okay, distinct culture, unique aspects of their culture. So this has to be protected and at the same time made sure that your panchayat ka uniformity is there throughout the country. So to deal with this scenario, PISA was launched in your 1996, panchayat extensions to your scheduled area. What do? Means they will deal with the agrarian issues of shifting cultivation, which is largely practiced by them. Also the union level, if you see, the reports of your NCST, National Commission for ST, are submitted to the President, which is then laid in front of Parliament along with a memorandum of action taken and explanation as to why things were not considered. Now at the state level, it is forwarded to the concerned state governor, who lays it in front of the state legislature with the memorandum of action taken. What are the powers of your National Commission for ST? First and foremost, it functions like a civil court while it is inquiring into issues with regarding to your STs. It will also have the power to summon witness, and it will create an overall institutional ecosystem, and Ministry of Tribal Affairs becomes the nodal agency. Your PISA Act of 1996 guarantees more of your tribal self-governance, coupled with your Forest Rights Act of 2006 guarantees the land and forest rights of your scheduled tribes. Next is your National Commission for Backward Classes. Look at this. So we have already seen the history of how in your 2018 bifurcation was from your National Commission of SC, which was doing into your reports for your OBCs, that is your backward classes, was granted with the constitutional body status post your 2018 under Article 338B. Understanding? What was it created for? To provide safeguards for socially and educationally backward classes. See, here when we tell backward classes, we are only seeing from social backwardness and educational backwardness, not economic backwardness. At least this is the stance that is maintained by your judiciary. Now, how did this come into picture? That is your special body of National Commission for Backward Classes. It all started with your Mandal case background, which was again your Indira Sawhney versus Union of India case, where your judiciary directed creation of a permanent body for OBCs, and also it upheld the 27% reservation for OBCs. Also, in this 27% of reservation for OBCs, they held that the overall reservation should not exceed more than 50%. Also, they introduced this concept of creamy layer and non-creamy layer. Understanding with respect to OBCs. Why this particular body was created means to see as to which particular backward classes are under included or over included or not even included in the list of the national OBC list. So, it was to look into all of these. Now, let's see the history. 1993, your NCBC was initially created as a statutory body. But with the 102nd Constitutional Amendment Act of 2018, the functions which your National Commission for SC was doing for your reporting on backward classes was removed and a separate body of National Commission for Backward Classes were created. So, 2018 constitutional status was given and under Article 338B. Okay. So, National Commission for SC is Article 338. National Commission for ST is Article 338A. National Commission for BC is 338B. What is the composition of this body? There is a chairman, vice chairperson and 3 other members, all appointed by President of India under his warrant of seal, and also the service conditions are determined by the President, which means they cannot be changed to disadvantage after the appointment. What are the functions? It will investigate into the cases about your backward classes. It will monitor constitutional safeguards. It will evaluate the implementation. While looking into inquiry of complaints, it will act like a civil court, and it will also look into your deprivation cases with respect to the rights of OBCs, backward classes, and also it will annually submit its report to the President, and also when special report is requested. At union level, the report is submitted to the President by a National Commission for Backward Classes, which is then tabled in front of Parliament with a memorandum of action taking and explanation as to why few of these were not considered. Now to the state level, they are forwarded to the state governors, who then places it in front of state legislature alongside a memorandum of action taken. Now if you see, it has the powers of a civil court while looking into inquiries, which means it can call people for summoning, witness, ask for official papers. So in overall summation, National Commission for BC is a constitutional body from your 2018. 1993 say it was a statutory body. It received constitutional status in 2018. It was created through 102nd Constitutional Amendment. New article inserted is Article 338B. The origin of your National Commission for BC started with your Mandal case, where they said for creation of a permanent National Commission for backward classes, and they will be consulted with respect to policies and provisions for backward classes. Next is Special Officer for Linguistic Minorities. All these are still your constitutional bodies. This is more of a constitutional position. Look at this. Now, the Special Officer for Linguistic, now if you see, originally in the constitution, the linguistic minorities ka special officer was not there. It was added into the constitution after your State Reorganization Act of 1956. It is under your Article 350B. One thing if you do have to know about linguistic minorities means the term linguistic minorities applies to a large chunk. For example, let's say under Article 29 and 30, which we will be seeing as a cultural and educational rights. Specifically, let's look into Article 29. What does Article 29 tell? Any section of citizens with a distinct language, script and culture can preserve it. See, now when I use the sentence or the word any section of citizen, this any section of citizen applies to both minority plus majority. What do I mean by that? See, let's say in Karnataka, Kannada speaking people are in majority. But outside Karnataka, if you go, let's say Tamil Nadu, Kannada speaking people are not in majority. So like that, every language can be both a majority and minority understanding based on the state. So that is why any section, alright. And also Supreme Court has further held that any section of citizens with respect to language, script, culture can preserve it also indicates can agitate for protection of that particular language. Okay. So this was based on the recommendations of your State Reorganization Commission. This is implemented, that is, this was brought about by your 7th Constitutional Amendment Act of 1956. So 1957 onwards, this office is created. Look into this. Next, we will see National Commission of SC, ST, BC and all. So it was a multi-member body. Here it is just a specific officer, special officer, who will be appointed by President of India, and he will have the designation as Commissioner for Linguistic Minorities. It will have constitutional provisions under Article 350B. And also, what is the role of this special officer? Means to look into the safeguards of your linguistic minority and also submit annual report to the President. These reports are further laid by President in front of the Parliament and respective state legislature, okay, along with the recommendations. Again, this particular recommendations are only advisory in nature or not binding on the government. Now, if you see under which particular ministry does it fall, the administrative part of it falls under Ministry of Minority Affairs. So it is submitted, the report, annual report is submitted to the President through this Ministry of Minority Affairs. Now, what is the role of the Commissioner, the Linguistic Minority Commissioner? He will address the grievances of linguistic minorities. He will examine the non-implementation of safeguards. Many a times there has also been very much remedial measures which have brought about, and also it engages with your respective state governments, union territories, and remedial measures are suggested. What are the safeguards which are monitored for your linguistic minorities? Like we discussed, Article 29, cultural and educational rights. Article 30, minority educational institution. Article 347 with respect to recognition of a language. Article 350A, which kind of is like a DPS piece outside part 4 of the Constitution. What are those? Trying to promote your or disseminate education in your mother tongue. This provision is also there as part of your NEP 2020, National Education Policy of 2020. And 350B is for creation of this special officer. Look into this. What are the functions of this special linguistic minority officers? First and foremost, investigate into the safeguard implementation, submit the report to the President through Ministry of Minority Affairs, and he will also initiate a lot of programs with regarding to state level implementation and publicity of safeguards. He has also, that is over the years, if you have seen, we have seen 10-point program for preservation of language and culture. Understanding? So the nature of the office is investigative. Whatever it tells, it is recommendatory only, not binding on the government. And one most important aspect that I want you to see here is, see, we said investigative, right? Which means we told that for National Commission for SC, National Commission for ST, National Commission for BC, they also have investigative powers, which means they have the powers of a civil court. Here that is one difference. There is no powers of a civil court, unlike a National Commission for SC, ST and BC. Understanding? That is one important provision you have to keep in mind. So, summation of this is, special officer is appointed under Article 350B. This provision was not earlier there in the Constitution. This was after your State Reorganization Act of 1956. Office was created in through your 7th Constitutional Amendment Act. The headquarters is in Allahabad. The special officer is appointed by President of India under his warrant and seal. Next constitutional body is CAG, Comptroller and Auditor General. Look at this. First and foremost, Comptroller and Auditor General comes under Part 5 under your Union Executive. It is in Article 148. What is the nature of the CAG? Means it is an independent constitutional body. What do I mean by independent constitutional body? Which means the term, tenure, etc., even though appointed by President CAG, is not holding the office under the pleasure of President. They have a fixed term. The salary allowances also are held by, okay, the things that is fixed through your parliament. Also, they have the aspects where even though they are appointed by the President, understanding, but the aspects of independent term, tenure, salary, allowances makes this body an independent body. And also, your CAG is the head of Indian Audits and Accounts Department. CAG is often called as the guardian of public purse. Next, what is the importance of CAG? How important is it for India? See, first and foremost, it controls the public financial system. It does the auditing for both center as well as state. And also, your Public Account Committee, PAC. Your Public Account Committee के लिए CAG will be the friend, guide and your philosopher. Which means what? Your CAG functions or CAG reports act as a way for your parliament to hold financial accountability of the executive. Understanding? So much so important that this body is Dr. B.R. Ambedkar has called CAG has one of the most important offices under your constitution. Also, while we were discussing about your bulwarks of Indian Constitution with respect to Election Commission, Supreme Court, what were the bodies that we told? So, which are the bulwarks or the base on which your Indian democracy is built on? Election Commission of India, Supreme Court, High Court, your UPSC, SPSC, and Comptroller and Auditor General of India. Your CAG is appointed by the President of India for a tenure, fixed tenure. This means there is a fixed tenure of 6 or 65 years, whichever is earliest. If the CAG has to resign, they have to resign by writing to the President of India. Also, removal of CAG is similar to that of your Supreme Court judge, which means proved misbehavior or incapacity, which means even ground for removal. On the grounds of proved misbehavior or incapacity, wherein Parliament has to first pass a motion which has to be accepted by the Speaker. A committee will be conducted, inquiry committee. Then after that, special majority by each house has to be passed. Understanding? Next, what are the safeguards to make sure this office remains independent? Look into this. First and foremost, they have security of tenure, 6 or 65 years. They do not hold the office under the pleasure of President, even though appointed by the President of India. One more important way that you try to make sure that there is security of tenure and the office of CAG remains independent is you have no further government employment. The salary will be, so why no further government employment will try to maintain the independence of the body means so you do not owe any fear or favor for anyone. So you can truly function as an independent body. Next is you will receive the salary same as your Supreme Court judge, and the service conditions cannot be changed to your disadvantage after your appointment. And also the charged expenses on Consolidated Fund of India, your Contingency Fund of India, all of these things will be looked after by your CAG, including your public sector undertakings. What is the parliamentary status that is given to your CAG? Means, first and foremost, no minister can represent CAG in the parliament. Understanding? Second thing is, no minister is responsible for CAG's action, indicating what? Independence of your CAG. Let's see what are the duties and powers of your CAG. See, first we will discuss all these topics. At the end, we will take up the PYQs. Okay. First and foremost, Article 149 is duties and powers defined by the Parliament. Article 150 is form of accounts which the advice is given on. 151 is the report, annual report. 279 is certification of net tax proceeds. Statutory basis. See, we told 149 duties and powers defined by Parliament. Where is it defined? It is defined in CAG duties, powers and conditions of Act 1971. It was further amended in 1976 to separate the accounts from audit of the center. Now, what are the auditing functions of your CAG? What and all will it audit? First and foremost, it will audit your Consolidated Fund of India, Consolidated Fund with regarding to the state, and Consolidated Fund with respect to your union territories with state legislature. Okay, next look at this. It will also be looking into auditing of Contingency Fund of India and Public Account of India. The bodies, if you see, of all the government annual receipts and expenditure, it will take off government companies, statutory corporations and bodies which are financed by the government. All that is also coming under your CAG ambit. Other audits can also be performed on the request of concerned president or governor of that concerned state. Now the report. CAG submits annual report to the President, which is laid in front of Parliament, and for the respective state it is forwarded to the Governor, who lays it in front of the state legislature. Your CAG acts as the friend, philosopher, guide of your Public Account Committee, through which your Parliament can hold financial accountability from your executives. Again, one of the most common criticism that we see is that it is more of doing the committees, PSC committee, estimates committee, or your public sector undertakings committee, in simpler sense, financial committees. What they are doing is a post-mortem work, or after the money spent action is taken, and also they are trying to see whether the money asked, the sanction by Parliament, is what they have used and where they have used. They are not questioning the basics or legalities of the law. Application of law is not questioned. One more, there is a limitation of CAG means with respect to your secret service expenditure. Here they cannot demand details, they just have to accept whatever your accounts are given by the executives. Okay, so there are different audit types. One is legal and regulatory audit, second one is propriety audit. What is this legal and regulatory audit and proprietary audit? Look at this. Now, when we tell something as a legal and proprietary audit, that is more specifically, legal and regulatory audit is something that your constitution demands a CAG from, that is what you are mainly created for. It is mandatory. You cannot skip this. Understanding? It checks the legality of expenditure. What you have asked is what have you spent it on. Next is propriety audit. Propriety audit is discretionary in nature. Now, first and foremost, in 2023 there was a question raised. Propriety of audit is not mentioned in the constitution. Where exactly is your CAG able to do that? This is when your judiciary held that your CAG duties, powers and conditions of Service Act of 1971, when it mentions, if you see the powers and functions, the concept of propriety of audit is inbuilt into the constitution. Now when we tell it is inbuilt into the constitution as well as the act, which means that he can do proprietary audit. What is proprietary audit? Which means, yes, the money sanctioned and money spent is correct, but is that money going to the proper sources? Is the money wisely utilized? What do I mean by this? For example, in your Ayushman Bharat, a lot of discrepancies was observed. Meaning what? For example, let's say a person ABC, in his name, lot of syringes, saline bottles, medicines, your hospital beds, etc. are all booked. Let's assume this is in 2023. But what in the propriety, what your CAG found out was, the so-called person who is receiving these in 2023 had already passed away in 2018. So what does this indicate? Discrepancy. Money is used, but is money going to the right sources, right channels? Is public account being wasted? This is called propriety. This is discretionary. CAG may do it, may not do it. You can't force it. But whereas a legal and regulatory audit is mandatory, you have to do it. It also examines the wisdom, economy, faithfulness with regarding to your expenses. Now, India and UKK, there is one difference of CAG. Role of your comptroller. See, in India, the CAG mainly just acts as an auditor general. He does not have control of fund or your public purse. Unlike in your Britain, where he has the control of public purse, he has to countersign telling that okay, release the funds for them. So he acts as a comptroller and auditor. In India, even though we call comptroller and auditor general, his main role is limited to auditing. Next, constitutional bodies, Attorney General of India. Look at this. Now, let's say if I have to write down who will come under Union Executive. Listen to this very carefully. So if I am going to call something as a union executive, obviously it will have president, then prime minister, council of ministers, CAG, attorney general of India. This attorney general is appointed by the president, but that does not mean he is part of the union cabinet. This is very important. There will be another separate union law minister who will be there to look after that. This Attorney General of India is not a permanent position, not a full-time practice. He will represent the government of India in Supreme Court and High Court wherever it is needed. Understanding? So, your Attorney General is mentioned where means in part 5 under Union Executive. Under Article 76, it is a constitutional body. Your Attorney General is also considered as the highest law office in India. Who appoints Attorney General? President of India appoints Attorney General. Now here is where I have to tell you certain important things. As he is part of your Union Executive, usually, understand this terminology I am using, usually because he is part of your union executive, usually when the council of ministers resign, he will also resign. But this is not mandatory. It is not mandatory that COM has resigned means Attorney General has to resign. That is why I use the term usually. Now, who can be made as a Attorney General of India? Someone who is qualified to be a Supreme Court judge. So, what is the qualification for a Supreme Court judge? Look at this. He or she must be a citizen of India. Minimum age for a judge is not mentioned in the constitution. Also, they have to either be a High Court judge for 5 years or an advocate in High Court for 10 years or be an eminent person according to your president's opinion. Now, this last option is applicable only in your Supreme Court case. That is in the qualifications of Supreme Court judge. This provision is not applicable to your High Court judge. Understanding? So, if we see what is your Attorney General ka term, CAG ka we saw 6 years, 65 years. But the term of Attorney General is not fixed, which means he usually holds the office during the pleasure of President. He can resign anytime by writing to the President, and also by convention, or usually he resigns when government resigns. His role is strictly advisory in nature, not binding, and also it advises Government of India in all the legal matters and on any other matters that is referred to it by your President of India. What are its duties? Like I told, this is not a permanent full-time position, which means any duty which is assigned by the president, they will perform that legal duty, and also they will discharge the functions with regarding to court representation, appear on behalf of Government of India in a given Supreme Court or High Court. Okay. Now, what are the rights and privileges that your Attorney General of India enjoys? Look at this. He has the right of audience in all the courts of India, which means he can also have additional powers or your privileges like how your MPs have. He can speak in both the houses of parliament, Lok Sabha, Rajya Sabha. He can even participate in joint sitting. He can also be a member or part of any of your parliamentary committees, but he does not have the right to vote. Because he can speak, participate and be part of committees, he also enjoys the same privileges like that of your member of parliament. Understanding what one thing is not there? Your voting rights. What are the limitations or restrictions with respect to your Attorney General? First and foremost, in order to avoid, like I told you, it is not a full-time job, which means on private he can practice his legal profession also. But because he is the Attorney General of India, there should not be conflict of interest. There are few conditions for him. What are those? He cannot advise any party against the Government of India. He cannot appear in cases which are against the Government of India. And he cannot defend the accused, especially in criminal cases, without government permission. Because then it will look like your Attorney General of India is doing this, means that will be a reflection of how the union government is. And also he cannot be a director of any company without the permission of your Government of India, and he cannot advise any ministers or ministries directly. All of it has to be routed through him through your Union Law Ministry. Now, what exactly is the nature of this office? It is a constitutional body, yes, but it is not a full-time government employment. He is also not a government servant, and also he is not a civil servant. Okay, which means he can practice private also. There is also another two bodies which is called as Solicitor General of India and Additional Solicitor General of India. These are not constitutional bodies, only Attorney General is constitutional body. What are they here to do? To assist the Attorney General. If they are not constitutional bodies, then what are they? They are created through your executive actions. Understanding? Next is Advocate General of India. The Advocate General of India is having the similar powers of how Attorney General has the powers in center. Okay. So it comes in part 6 of the Union Government, that is your Governor, Chief Minister, Council of Ministers or Advocate General. Okay. Again same thing here also, he is the highest law officer of the state. Usually when the government resigns, he also conventionally resigns, but this is not mandatory. Now, it is in part 6 of the state executive, coming under article 165. It is a constitutional body. What is the appointment? Who appoints the Advocate General of a state? Governor. What is the qualifications to be Advocate General? He must have the provisions or qualifications qualified enough to be a High Court judge, which means either he should have held a judicial office for 10 years or he should have been an advocate in High Court for 10 plus years. Eminent jurist criteria will not apply here. That is only for Supreme Court judge. That one aspect keep in mind. Next, the term is not fixed for Advocate General. He holds the office during the pleasure of Governor, conventionally resigns when government resigns. He can also write his resignation to the governor. Now, what are the functions he has? He has advisory role, that is he will advise state government on legal matters. He will also look into the cases which are referred to him by the governor. He has executive legal duties which are assigned to him by the governor, and also whatever other additional works which has been asked from him by the governor. Now, he will appear in front of all the courts when and where necessary to represent the state government. So, where in High Court and subordinate courts, in Supreme Court if the state matter has come up. Okay, but primarily High Court and subordinate court. What are the rights and privileges that he has? He has the right of audience in all the courts within that state. He can speak in state legislature. Again, I am telling state legislature, not parliament. Attorney General is parliament. Advocate General is state legislature. He can participate in proceedings and he can also take part in any of the committees, but he cannot be involved in voting. He can't take part in voting. Because of this, he also enjoys the privileges and rights of a MLA or MLC, Legislative Assembly Member or Council Member. Next, we will start with non-constitutional bodies. Like I told, we will first do all these content, then at last we will discuss your PYQs. Okay, so we will be now starting with your non-constitutional bodies. The first one here we will be discussing is your Niti Aayog. Niti Aayog, again this came as a replacement to your Planning Commission. Now, one thing about non-constitutional bodies, in prelim statement kind of questions you should be very clear is, these bodies are not being mentioned by the constitution. Either they have been created through an act of parliament, they have been given statutory status, or they are created through your executive order. Understanding? But not mentioned in constitution. So, this is the successor to your Planning Commission. So, what is Niti Aayog? Not a constitutional body, not a statutory body. Constitutional body means mention should be there in constitution. Statutory body means it should be through an act of parliament. This is neither. Then how did Niti Aayog come in? Through your executive resolution. It's an extra constitutional body. Same was your Planning Commission, which was also created through executive resolution, and it is a extra constitutional body. Your Planning Commission was scrapped in your 13 August 2014, and into its place came Niti Aayog in 2015. We tell, yes, Niti Aayog is successor of Planning Commission, but there are major changes with regarding to Planning Commission and Niti Aayog. Firstly, Planning Commission had aspects with respect to fund control or financial control. Niti Aayog is stripped of any financial control. Okay, it does not have any financial control. Next, what is Niti Aayog then? It is a premier think tank of India which will advise policy and also technical aspects for center and states. Moreover, it tries to promote cooperative federalism. Understanding? Look at this. From your Planning Commission, which was a top-down approach, your Niti Aayog goes for a bottom-up approach, more of decentralized in nature. Otherwise, priority is given for cooperative federalism, where the states will collectively come together and decide rather than center giving the command and control. So, Niti Aayog becomes a collaborative platform. What is the composition of Niti Aayog? There is a chairperson. The chairperson is the Prime Minister of India. There is also a governing council. The governing council will be all the state chief ministers and also your union territories with the state legislature ka CM also are represented here. Delhi, Puducherry, Jammu and Kashmir. And other union territories say representation is through lieutenant governors or governors, administrators. Then there is also something called as regional councils, specifically to deal with the issues of that region. What is there? For multi-state or regional party issue, it is convened by Prime Minister, but it will be chaired by someone called as Niti Aayog chairperson or a nominee. Understanding? Now, there are certain special invitees. Special invitees means these are experts who are nominated by the Prime Minister. Also, your Niti Aayog will be a full-time functional organizational framework, which means there will be a vice chairperson who will be appointed by the Prime Minister. The full-time members hold the rank of your Minister of State, and part-time members will be on rotational basis. Who will be your ex officio members means up to 4 union cabinet ministers who will be nominated by Prime Minister. And also there will be a CEO of your Niti Aayog who will be at the level of somewhere around secretary and above in Government of India. Okay, they will be appointed by Prime Minister. Now, your Niti Aayog has specialized wings in it. It has 3 wings: research wing, consultancy wing and Team India wing. What is this research wing? This is trying to provide in-house expertise for states which come up with issues. Let's say they have issue with traffic management or with respect to the developmental challenges. Then they try to provide expert advice. Now, instead of Niti Aayog on itself going and burdening the states, it is like a space where states can voluntarily approach Niti Aayog. Okay? The consultancy wing is, it provides the government needs with solution providers. And also Team India wing is for center and state coordination. Okay, look at this. What are the functions of Niti Aayog? First and foremost, with respect to policy and program redesigning to help the states and center, major thing is cooperative federalism, and also it will evaluate constantly as to let's say if we have provided a solution, is it working with respect to the policies, and also it tries to come up with innovative solutions such as your Atal Tinkering Labs, Atal Innovation Missions. Understanding? So it is a think tank plus knowledge and innovation hub. What are the differences between your Niti Aayog and Planning Commission if you see? First and foremost, similarities, both are your bodies created through executive resolution. Both are non-constitutional, non-statutory, extra-constitutional bodies. Planning Commission had a very strong role with regarding to your funding, and largely it was following top-down approach. The Niti Aayog in turn, it does not have anything to deal with financial matters. It is a policy think tank and it moves towards cooperative federalism. Okay. Next body, non-constitutional body we will be looking into is NHRC or National Human Rights Commission. Look into this. The National Human Rights Commission is a statutory body, which means it is set up through your Act of Parliament. It derives its power from there. Again, is it mentioned in Constitution? No. It is established under which Act? Protection of Human Rights Act of 1993. So, 1993 pe NHRC was established. What is the definition of NHRC according to your Protection of Human Rights Act? Means something that relates to life, liberty, equality and dignity. And also it looks into the rights which are guaranteed by Constitution of India and international agreements that are enforceable in India, which India would have ratified. Yes, those things. What is the composition of NHRC? NHRC is a multi-member body. What is the members and their qualification? First is the chairperson will be, see how we will be seeing your NHRC means, first let's see NHRC, SHRC, then we will also see your 2019 ka amendment of your Protection of Human Rights Act. Okay, so as of now, the chairperson can be a former Chief Justice of India or any other Supreme Court judge. Earlier, prior to your 2019 amendment, it was that only a former Chief Justice of India could be the chairperson. But after the amendment, even any Supreme Court judge also can be your member. There will also be a member who will be a Supreme Court judge serving or retired. Another member will be a Chief Justice of High Court serving or retired, or a judge of your High Court. Another member would be human rights experts. At least one, more than one women representation is mandatorily needed. Understanding? Also, NHRC has ex officio members of 7, which is the chairpersons of National Commission for Minority, National Commission of your SC, National Commission of STs, National Commission for Women, National Commission for your backward classes, National Commission for your protection of child rights, and National Protection for your persons with disabilities. All this was added post your 2019 amendment to make it a inclusive and representative body. Who are these people appointed by? They are appointed by your President of India, but based on the recommendation of a committee. Which committee? The committee comprises of the Prime Minister, who will be the chairperson of the committee. Also, there will be Speaker of Lok Sabha, Deputy Chairman of Rajya Sabha. Look at this, not Chairman of Rajya Sabha, but Deputy Chairman of Rajya Sabha, Leader of Opposition in Lok Sabha, Leader of Opposition in Rajya Sabha, and one Union Cabinet Minister, which will usually be your Home Minister. What is the tenure and removal of your members of NHRC? Again, prior to your 2019 amendment, the term was 5 years, but this was reduced to 3 years or 70 years. They are eligible for reappointment, but not eligible for further government employment. Okay. How are they removed? They are removed on certain grounds. Which grounds? Directly President can remove if the person is insolvent, bankrupt, has taken up paid employment outside the office while being in service, infirmity, unsound mind or body, or he is convicted and subject to imprisonment. But let's say you are going to remove the person based on your grounds of proved misbehavior or incapacity, then a Supreme Court inquiry is to be conducted. These grounds directly can be removed, but proved misbehavior or incapacity, you need a Supreme Court inquiry. Okay, look at this. What are the powers of your NHRC? It has the powers of a civil court, where it can summon witness, it can ask for public documents. Its headquarters is in New Delhi. Also, your NHRC can promote, okay, this is very important, human your rights research, literacy awareness, NGO promotion, and one more aspect of your NHRC, they can take up cases suo moto also, or by your petition also, but they cannot take up cases which has happened 1 year after the incident has occurred. Okay, so the timeline is there. One more thing about, let's say your NHRC submits a report, means this particular report is not binding on the government. It is only recommendatory in nature. But if the government, if NHRC tells something, the action for this or the response has to come within 1 month from the government. One more limitation of NHRC, if you see, they cannot directly investigate. They have to seek the report from any of the central government employees and they must respond within 3 months. Another attribute is the annual reports which they will submit will be given to the president, who will lay in front of state legislature, who will lay it in front of parliament. The concerned state के लिए it will be forwarded to the governor, who will then lay it in front of the state legislature. Next, under this only SHRC, State Human Rights Commission. Okay, look into this. Again, central level पे there is NHRC means, state level पे there is SHRC, State Human Rights Commission. It is also a statutory body created under your Protection of Human Rights Act of 1993. They can also look into your human right violation cases within 1 year of occurrence of that incident. On which topics can they look into means, on topics which are mentioned in state list or concurrent list. Which topics they cannot take up means, they cannot take up which the cases have already been taken by your NHRC. Understanding? And also, usually what will happen means, the center will assign the functions of your union territories to your SHRC, but with the exception of Delhi. Delhi is taken up by your NHRC itself. Okay. What is the qualification for your SHRC? It is again a multi-member body post your 2019 amendment, wherein the chairperson can be either former Chief Justice of High Court or a judge of High Court. The member can also be a High Court judge serving or retired, or a district judge with 7+ years of experience. And another member can be a human rights expert. Also, they are appointed, SHRC members are appointed by your governor based on the recommendations of Chief Minister, Speaker of Legislative Assembly, one your union, that is state minister, who is usually your union home minister, and also leader of opposition of your legislative assembly. If legislative council exists, then the chairman will be, that is your leader of opposition of legislative council. Look at this. The sitting High Court judge, if you are going to appoint, then it has to be after consultation with the respective Chief Justice of High Court. Look at this. The term of your SHRC is 3 years or 70 years. This is reduced from earlier 5 years. They are eligible for further reappointment but not for further government employment. First and foremost here, difference you have to know. NHRC appointment is by president, removal is also by president. SHRC appointment is by governor but removal is by president. Understanding? On what grounds? Directly they can be removed for insolvency, paid employment, unsound body and mind, your paid employment outside the government, and also if you're convicted and imprisoned. In these cases directly you can remove them. But if it is the removal on grounds of proved misbehavior or incapacity, then you have to conduct a Supreme Court inquiry. Understanding? So removal is by president for SHRC, even though appointed by governor of that state. Now, with respect to SHRC, again their recommendations: are not binding on the government. The reports will be submitted to the state government, which will be laid in front of the state legislature. It will be submitted to governor, who places it in front of state legislature along with the action taken. Also, there is a provision which tells that mandatorily human rights courts will be created in every district, and it will be set up for faster human right trials, violation trials, and also the public prosecutor who will be here will be having 7+ years of practicing advocate. 2019 amendment, or the changes done to your Protection of Human Right Act. What are these means? The chairperson earlier could be only a Chief Justice of Supreme Court or Chief Justice of High Court. Now, Supreme Court judge or High Court judge is also eligible to become chairperson of NHRC or SHRC. The NHRC experts were increased from 2 to 3 members, where mandatorily at least 1 member should be a woman. Added the ex officio members of your National Commission for Backward Class, National Commission for Protection of Child Rights, and also Chief Commissioner for persons with disabilities. The tenure was reduced from 5 years to 3 years. And also same like with SHRC, chairperson not only Chief Justice of High Court but also Judge of High Court. And the Union Territory ka functions, human right functions and all will be given to your SHRC. Exception is Delhi. Delhi is taken up by NHRC. The NHRC General Secretary will have administrative and financial powers, and same is for your SHRC also. Next is CIC, Chief Information Commissioner. Look at this. The Chief Information Commissioner was established in 2005 under your Statutory Act of Right to Information Act of 2005 or RTI Act. This is a statutory body. Initially, it was brought about by official gazette notification of central government. Then it came through your statutory provisions. What will it do? It will act as an independent appellate authority under your RTI. RTI was considered as like a sunshine legislation. Okay, so your CIC was brought in to give effect to that sunshine legislation. Composition, again your CIC is a multi-member body. There will be 1 Chief Information Commissioner and a maximum of up to 10 Information Commissioners. So it is 1 CIC up to means it does not mean that mandatorily 10 should be there, within 10. Okay, they are appointed by the President on recommendation of a committee. Who is that committee? Prime Minister, he will be the chairperson. Leader of opposition of Lok Sabha, and also a Union Cabinet Minister, usually it will be the Home Minister, nominated by the Prime Minister. What are the qualifications if you have to be the member of CIC? First and foremost, you have to be a member of, okay, person with experience in respective things. What do I mean? Just give me a moment. What should be the qualifications be of your CIC? The member should be having experience or adequate knowledge in law, science, technology, social service, management, journalism, mass media, or administration and governance. Disqualification grounds for your CIC is you should not hold office of profit. You should not be an MP or MLA. You should not be connected with any political party, and you should not be engaged with any business or profession, because then that would mean that you cannot be without bias, or you cannot have the freedom from biasness. Possibility of biasness is there. Tenure and service conditions. See, the term is as prescribed by central government or up till 65 years. Now this particular had a change. Okay, what the change amendments little bit later we will discuss. They are not eligible for further appointment under Government of India. Salaries will be as per your central government prescription, and also your salary and service condition cannot be altered to your disadvantage post your appointment. Understanding? Now, on what grounds can you remove the CIC? Removal is by president. Directly you can remove them if they are insolvent, unsound body and mind. Your moral turpitude, which means what is moral turpitude? Something can come in the form of your, let's say, if you are interested in government contracts, or you are wanting to benefit from the government contracts, or you will share the benefits of it, right? Paid employment if you have taken up while during the service condition, unsound body, mind, financial conflict of interest, and all these directly you can remove. But on the grounds of proved misbehavior or incapacity, like I mentioned the grounds, you then Supreme Court inquiry has to be conducted, and your president acts post the inquiry decision of Supreme Court. What are the powers and functions of CIC? Look at this. First and foremost, I told you your CIC was created for your sunshine legislation to give effect, act as affiliate authority, which means complaint handling. CIC will receive complaints from person when they are not able to file an RTO because there is no person of information officer is not appointed, and they were refused the information or provided wrong or let's say false misleading information, and also they were charged with unreasonable fees. Okay, and there is specific time limit mentioned. Within the time limit the answers were not mentioned, means then on all these grounds they can receive complaints. They can also take up suo motu inquiry. They have the powers of a civil court during the inquiry. They can summon the witness, understanding, and also they have the reporting function where annual report will be to your central government submitted, which will then be laid in front of your parliament. Now this is for central level, means it's for the state level is State Information Commission, also created through your sunshine legislation of Right to Information Act of 2005 or RTI Act, and this is created state level through official gazette notification, and it is a statutory body. What is the composition? Again, multi-member body. One state chief information commissioner and up to 10 state information commissioners appointed by the governor based on the recommendations of chief minister, who is the chairperson, then leader of opposition and legislative assembly, and a state cabinet minister, usually your home minister, who will be nominated by chief minister. Qualifications and disqualifications are pretty much same like your CIC. Now, like I told you, there were several amendments in your 2019. What are those? First, earlier the term was fixed for 5 years or 65 years, whichever is earlier. But whereas after your 2019 amendment, it will be as prescribed by central government. This is first change. Second change, earlier the salary was of your CIC. CIC was receiving the same salary as that of your chief election commissioner. Your information commissioners were getting the same salary of your election commissioners. But now the salary will be decided by your central government. But one thing is, after the person is appointed, you can't change to his or her disadvantage. Next, with respect to state election commission, they were receiving the same salary with respect to your election commission. Understanding? Now, again here the salary etc. will be determined by the central government, not state government. That is one important attribute. Next non-constitutional body is Central Vigilance Commission. Look at this. Your Central Vigilance Commission initially was set up through an executive resolution of central government based on your Santanam Committee recommendations for prevention of corruption. It got statutory status in your CVC Act of 2003, Central Vigilance Commission Act. Also in 2004, they were designated as the agency for your whistleblower protection. Now first and foremost thing about your CVC is they can even act against vexatious or misleading or false complaints too. Okay, what is your CVC composition? Is also a multi-member body where we have one Central Vigilance Commissioner and up to 2 Vigilance Commissioners. The appointment is by President of India. Recommendation based on your Committee of Prime Minister, who will be the chairperson, Union Home Minister or Cabinet Minister nominated by your Prime Minister, and Leader of Opposition of Lok Sabha. The tenure is up to 4 years or 65 years, whichever is earlier, and also no more further employment under government, center or state. Again, why? In order to ensure there is no fear, favor or partition, okay, which is involved. So they cannot act in a partial manner. The removal directly can be by your president if it is on the grounds of insolvency, paid employment, unsound body and mind, conflict of financial interest. And if you are removing a person of CVC based on your proved misbehavior or incapacity, which means you will benefit out of certain government contracts, etc., in that condition, then a Supreme Court inquiry is to be conducted and President acts based on the decision of the inquiry. What are the service conditions? CVC will receive the salary, that is Central Vigilance Commissioner ka salary will be similar to that of your chairperson of UPSC. Your Vigilance Commissioner will receive the salary similar to that of your members of UPSC. Understanding? And this cannot be altered to their disadvantage after their appointment. What are the main functions of your CVC? If you see, they will look into the cases of your Prevention of Corruption Act of 1988 with respect to central government employment or authorities. In other words, they will look into complaints of your All India services and your Group A central government officials. They will also have priority over your DSP, Delhi Special Powers, that is your CBI, for your prevention of corruption cases. Understanding? And also they will act under your let's say questions, conditions, inquiries which are coming under your whistleblower protection. Additional role which has been given to your CVC, what means, especially after your local lokayukta and all coming into angle, they will be involved in the selection committee for your director of enforcement or your senior ED appointments, which will be for your CBI and all. Then they will also receive information with respect to any suspicious activities which are taking place under your Prevention of Money Laundering Act of 2002. One more important aspect is your Central Vigilance officer or Chief Vigilance Officer is to be created in each ministry or department. So the CVO acts as a link between your organization or department, CVC and CBI. Understanding? Now let's say how exactly it works then. CVC, Central Vigilance Commission, then Chief Vigilance Officer, CBI. Both of them have the same thing with respect to your prevention of corruption, and your CVC submits annual report to the President, which is laid in front of the Parliament. Your CVC, while inquiring or looking into complaints, has the powers of a civil court. One important aspect is with respect to your Whistleblower Protection Act, which comes under the ambit of your CVC. Look at this. First and foremost, under Whistleblower Protection Act is protection of the identity of whistleblowers, and also in case someone tries to misuse the power, your public servants, and also they have the power to act upon frivolous complaints or misleading or false complaints where they can be fined and imprisoned. Okay. If you are coming forward as a whistleblower, it should not be because you are going to benefit if you remove that person. Okay, you should not be benefiting anyway. It should only be done in good faith. Understanding? No action can be taken on anonymous. Let's assume that someone has created or maintained the complete records enough to frame a person and then they send it also. It is not applicable because anonymous identities are not taken. One more limitation is this is not applicable to your speeches. Okay. One most important thing is we will see the connectivity with respect to your CBI also, Central Bureau of Investigation. Now your CBI was initially created under Ministry of Home Affairs. This is not a technically statutory body, is because it derives its power from your DSP, Delhi Special Police Establishment Act of 1946. Okay, that is one important thing of CBI. Look into this. Now, if you see your CBI is headed by a director who is assisted by your joint directors, additional directors, DIG, Superintendent of Police, all these. And it also has, most important thing is, a Directorate of Prosecution and a forensic or technical support in order to assist in the cases. And also, in the appointment of Director of CBI, the appointment is by central government and the recommendation is based on the committee of Prime Minister, Leader of Opposition, Chief Justice of India, or a judge nominated by a Supreme Court to judge by a Chief Justice of India. Now, one most important aspect you have to see is Section 6A of DSP Act. Now, whenever we will be looking into CBI, especially with concerns to state, there is something called as general concern and case specific concern we will be discussing. So, what happened in your section 6A is it inserted a provision. What does that provision means? If you are going to inquire into cases or allegations above joint secretary level, then you need prior permission to inquire from your central government, even to inquire. So, your Supreme Court felt that this is very arbitrary. Why? What is the rationale behind telling joint secretary and above you have to secure permission to even inquire? Doesn't it violate Article 14? Okay, stating this, your Supreme Court struck down Section 6A of DSP Act as violative of Article 14 and creating a class legislation. If we do this, it is creating a unnecessary class legislation. What is the jurisdiction of your CBI? If you see, they will be involved with the anti-corruption cases, especially of central government employees, and also economic offences, and sometimes with respect to your serious offences, understanding, which will have international ramifications for India and India's interests. Next, we will be looking into Lokpal and Lokayukta. These are your ombudsman bodies. Okay, ombudsman body means this is there to overlook your corruption. Lokpal and Lokayukta is a statutory body from your Lokpal Lokayukta Act of 2013. What is the composition means? You are supposed to have a chairperson and up to 8 members. In that, one provision is at least 50% of the members should be of judicial capacity and another 50% of representation should be from SC, ST, OBC, women and minorities. Okay, look at this. how is the chairperson, that is your Lokpal Lokayukta. Mainly we will be speaking only about Lokpal here. Lokayukta separately we will deal with. Lokpal ka chairperson is elected through a selection committee which will comprise of Prime Minister, Speaker of Lok Sabha, Leader of Opposition in Lok Sabha. If Leader of Opposition is not there, then largest party opposition leader, then Chief Justice of India or Supreme Court Judge nominated by Chief Justice of India, and an eminent jurist. This is selection committee. For them to get the list, there will be one search committee. The search committee will comprise at least 50% of members from SC, ST, OBCs, minorities and women. Now this selection committee can even consider names which are not even been given by your search committee. Jurisdiction of your Lokpal. First and foremost, if you see, including the Prime Minister is also brought in, but with certain exclusions and special procedure. If you have to deal with the Prime Minister, it also includes ministers, MPs, central government employees from Group A to Group D officials. Preliminary inquiry is conducted, investigation, prosecution. For all of this, they have set up time limit so as to give a time bound delivery of justice. And also, they have the power to confiscate property even while it is undergoing, the case is undergoing. Understanding? They have superintendence over other investigative agency like your CBI. For example, for your investigation, they can use your CBI as a resource. Understanding? Now, one thing about Lokayukta is, for Lokpal we have specific set of things told. Yes, this is the selection committee, this is the particular qualifications you should be having and all this. For Lokayukta, we cannot just tell that as a broad aspect, because for Lokayukta they have left for the state legislatures to decide. So, because of that attribute, Lokayukta ke liye we do not have one set rule that this is how it is going to be. Each state legislature can have different provision. So, in Lokayukta, what happened means, your states like Rajasthan, Karnataka, Andhra Pradesh, Maharashtra have set up something called Lokayukta and Upalokayukta, whereas states like Bihar, UP, Himachal Pradesh have just set up your Lokayukta. Appointment of the Lokayukta members is by governor. Again, here selection committee we will not tell this is what the selection committee is, because each state it differs. Most states pe how they will do means, the governor will consult with the Chief Justice of India and Leader of Opposition of your State Legislative Assembly. This does not mean that everywhere it is like this. Understanding? It is dependent on each respective state legislature. Next, non-constitutional body is NIA or National Investigative Agency. First and foremost, if you see NIA, this was not there earlier. This was created in the aftermath of your 2008 Mumbai attacks. This your NIA functions as India's central counter-terrorism law enforcement agency. This was enacted 2008 post your Mumbai attacks. It works under Ministry of Home Affairs. NIA is headed by a Director General, and they will be, if you want to increase the areas or jurisdiction of cases for NIA, then you have to put them under scheduled offences under your NIA Act. Okay, then whatever topics are there in the scheduled offences, all those can be looked into or comes under jurisdiction of NIA. Look at this. NIA Amendment Act of 2019, wherein what happened here, remember I told you, if you have to increase the jurisdiction, then you have to add it under scheduled offences, right? Like that, in 2019 it was expanded to add the offences committed outside India, but if it affects the Indian interest, such as human trafficking, counterfeit currency, cyber terrorism, prohibited arms, and also explosive substances. So, NIA ka ambit was increased. So, this is with respect to your constitutional and non-constitutional bodies. Now, for all the other topics, right, we will be learning through your PYQs. Understanding? First and foremost, how many commissions, how many delimitation commissions have been constituted by Government of India till December 2023? First and foremost, understand what is a delimitation commission. Delimitation commission means it is something that sets up the territories, okay, of India into constituencies based on your census reports. Up until now in India, we have created 4 such delimitation commission. Even after your 2011 census, we have not set up delimitation commission. Again, we had frozen the seats. So, we have to wait for your next census report to act on your delimitation commission. As of now, it is 4. Next question. Consider the following organizations or bodies in India. The National Commission for Backward Classes, National Human Rights Commission, National Law Commission, National Consumer Disputes Redressal Commission. How many of the above are constitutional bodies? See, whatever we discuss as non-constitutional bodies and all, they are not mentioned in the constitution. That is why we are telling non-constitutional bodies. When we saw in constitutional bodies, we have seen your National Commission for Backward Classes was there, right? NCSE, NCST, NCBC 2018 onwards. National Human Rights Commission is a non-constitutional body. National Law Commission also is not mentioned in your constitutional body. Same is with respect to your National Consumer Disputes Redressal Commission. So the correct option is only one, that is National Commission for Backward Classes. Next. Consider the following: demographic performance, forest and ecology, governance reforms, stable government, tax and fiscal efforts. For the horizontal tax devolution, the 15th Finance Commission used how many of the above as criteria other than population area and income distance? See, what happened is in 15th Finance Commission, they brought in new arena, okay, to bring in how the devolution of funds should be. So, what are the grounds that they use? Criteria means one is population area, they have been using it from before. One more is income distance. These are done before itself. They also, okay, introduced 15th Finance Commission, demographic performance, forest and ecology, government reforms, it is not there. Why will they think of government reforms for devolution? Stable government, again this is a generic topic. Why will the stability of government and the financial devolution be involved here? Tax and fiscal efforts. So it is 1, 2, 5. Okay, so only 3 of these attributes. Next question, look at this. In India, what is the role of Coal Controllers Organization or CCO? CCO is major source of coal statistics in Government of India. Yes, name itself states coal controller, major source of coal. It monitors progress of development of captive coal or lignite blocks. This is correct. It hears any objection to government's notification relating to acquisition of coal bearing areas. Yes, when let's say it is the basic minimum concept of good governance. Last, it ensures that coal mining companies deliver the coal to end users. Why will it look about coal mining companies delivering the coal to end users? Right, so this is not the correct option. Correct option is 1 and 2 and 3 only. Next, consider the following statements. Attorney General of India and Solicitor General of India, who are the only officers of the government who are allowed to participate in the meetings of Parliament of India. See, Attorney General is fine, understanding, in the Parliament meetings, but with respect to Solicitor General, no. They are there only to assist Attorney General. According to Constitution of India, Attorney General of India submits his resignation when the government which appoints him resigns. When I was discussing Attorney General, I told you as a convention he resigns, but it is not mandatory. So, correct option is neither 1 nor 2. Next, consider the following statements. The Election Commission of India is a 5-member body. Union Ministry of Home Affairs decides the election schedule for conduct of both general election and by-election. The Election Commission resolves the disputes relating to splits, mergers of recognized political party. Which of the following statement is correct? Election Commission of India is a 5-member body. No, it is a 3-member body. 1 CEC plus 2 EC. It is a multi-member body, but it is not 5-member, it is 3-member body. Union Ministry of Home Affairs decides election schedule for general election. No, it is Election Commission. Why will Union Ministry of Home Affairs come? Election Commission resolves the disputes relating to splits and merger of recognized political parties. This is correct. Correct option is 3 only. Next. Which of the following are associated with planning in India? Something to do with respect to India, planning for the future, that aspects. Finance Commission, National Development Council, Union Ministry of Rural Development, Union Ministry of Urban Development, Parliament. See, in these options, look for something that is very broad and generic and not something specific to a department. Planning doesn't necessarily mean only with respect to rural or urban development. So, your Ministry of Rural Development, Urban Development will not come in. Finance Commission is there only for devolution of funds between center and state. So, this is not there. National Development Council and your Parliament. National Development Council was there under your Planning Commission, which was to secure the support with respect to the planning. But post the coming or initiation creation of Niti Aayog, National Development Council has not held any meetings. So correct answer is National Development Council and Parliament. Next. Which of the following bodies do not find mention in the Constitution? Simpler words, which of these are non-constitutional bodies or which of these are not constitutional bodies? National Development Council. They are asking, do not find mention in Constitution, which is not a constitutional body. National Development Council is not a development constitutional body. So yes, this does not find a mention. Planning Commission, no. This is through an executive order. Your Zonal Council is through statutory act. So this is also not mentioned. So correct option is all these three are not mentioned in the Constitution, or all these three are not constitutional bodies. Next question. Consider the following statements. Attorney General of India can take part in the proceedings of Lok Sabha, be a member of committee of Lok Sabha, speak in Lok Sabha, vote in Lok Sabha. First and foremost, see, can he take part in proceedings of Lok Sabha? Yes. Can he be a member of committee of Lok Sabha? Yes. Can he speak in Lok Sabha? Yes. Can he vote in Lok Sabha? No. So the correct option is 1, 2 and 3 only. He cannot vote in the House. Next question. Who among the following constitute National Development Council? Prime Minister, Chairman, Finance Commission, Minister of Union Cabinet, Chief Minister of States. See, Prime Minister, yes. Chairman of Finance Commission, no. We just tell a Union Cabinet Minister. So, this is there. Chief Minister of States are also there. Correct option is 1, 3 and 4 only. Next question. In India, other than ensuring that public funds are used efficiently and for their intended purpose, what is the importance of the office of Comptroller and Auditor General, CAG? CAG exercises exchequer control on behalf of the Parliament when the President of India declares a national emergency or financial emergency. Exchequer control means financial control. When we were discussing CAG, I told there is Comptroller function, Auditor function. India pe it is only Auditor function, not Comptroller function. Doesn't have hold on money. UKP, that is both comptroller and auditor. Next, CAG reports on the execution of projects or programs by the ministers are discussed by the Public Account Committee. Yes, that is what we said as your friend, guide, philosopher. Information from CAG reports can be used by investigative agencies to press charges against those who have violated the law while managing public finances. Correct. CAG reports can be used, through which only many of the scams had been unearthed. Next, while dealing with the audit and accounting of government companies, CAG has certain judicial powers for prosecuting those who violate the law. Now, CAG does not have any judicial powers with respect to prosecuting those who have violated the law. Okay. Now, with this, we come to the end of the content. Hope you enjoyed our content. If you like our content, subscribe to our channel, hit the like button, share it along with your friends. Thank you.